on O'Keefe trial. And with that, we are live. Hello, Towel friends over on YouTube. It's me, I'm a Towel. I should be popping up on your screen in 1 second now, along with your wonderful comments.
On O'Keefe trial.
Sorry about that. And with that, we are live. That's how you know we're live. We got some double feedback audio. As I said, just give me 1 second. We are obviously not watching day 4. I was just preparing our wonderful stream earlier for all the Towel friends. What we are going to do, though, is talk about what's going to happen today with Arca. We'll give folks a little bit of a preview of that. We'll talk about what led up to today's bombshell developments. Remember, we have half a day of testimony in the morning, and then in the afternoon, we have the Arca Rule 14 reciprocal discovery compliance voir dire. And remember, Rule 14 reciprocal compliance voir dires are not about the content of Arca's testimony about their hot dog glass cannon or whatever the hell they did, or it is specifically about whether Reed's legal team, by deleting 105 text messages to Arca, withholding payments in contacts with Arca, which have already been found on the record by Judge Canon to have been material misrepresentations to the court, whether that should result in a sanction against Reed in the form of Arca being excluded from the witness list. It could be huge. Arca pleading the fifth. Listen, if Arca pleads the fifth, it's, oh my dear God, everybody run for the hills. Everybody run for the hills. Some kind of nuclear detonation will occur within the Karen Reed camp if Arca pleads the fifth. But okay, give me a few seconds here. So the first thing we are going to do is we are going to shift off this. I'm going to bring up the first in a series of videos, because I'm a little Towel. Is it this one I want to get rid of? Yeah, and look at that, it's all ready for us. I'm a Towel. I'm a prepared Towel. All right, so this is how it started, folks. Before opening arguments, hold on 1 second. I want your Towel comments to stay on the screen, so I have to do this. This is how it started, Towel friends. Rather innocuously, before opening arguments, if Karen Reed's experts from Arca, who were involved with a probably pretextual federal probe that started into John O'Keefe's death in November of 2022 and is now confirmed as closed by U.S. Attorney Leah Foley by way of law enforcement partners in multiple different agencies, the Brian Walsh prosecution, the Karen Reed prosecution, and by way of the Canton Police Department, all making statements saying that U.S. Attorney Leah Foley allowed them to confirm the investigation into John O'Keefe's death is over. Now, that's a big deal because under Section 25 of the DOJ Operations Manual, which is really an enumeration of U.S. XREL 2EV Reagan TOUHY from 1985, which is itself interpreted in U.S. 126 U.S. CFR .000 or something. Anyway, the point is, the Arca experts were retained during the context of that pretextual federal probe, which really heated up over the summer of 2023. I think kind of as a favor, because Karen's lawyer, David Yannetti, was on the transition team for the then U.S. Attorney Rachel Rollins back when she became Suffolk DA. And then also because Rachel Rollins had this beef going back to her time as Suffolk DA with another DA, Norfolk DA Michael Morrissey. She actually had beef with a number of DAs, but she had a bifurcated beef with Morrissey related to Rollins' soft on crime prosecution stance. She wouldn't prosecute low-level offenses. And then also because Rollins wanted to not seek life terms for youthful offenders charged with serious life-taking offenses within an age range of 18 to 25 or something, and other DAs really didn't like that. Now, Rollins ended up being vindicated by the Supreme Court 7 years later, but that's an aside to our point here, which is that there was a history of tension between Michael Morrissey and Rachel Rollins, and the pretextual probe of John O'Keefe's death, of which Arca was a part, really ramped up over the summer of 2023, then ended rather abruptly. I believe that probe then shifted over to the cover-up of Sandra Birch Moore's murder, a young woman whose life was tragically taken, allegedly, by a former Stoughton police officer, Matthew Farwell. And then somehow the state police, despite having a lot of evidence of Farwell's guilt, his presence at the crime scene, his statements that Farwell knew Sandra was pregnant and would take care of the problem if Sandra wouldn't herself, quotes, somehow declared that death a result of self-harm. Then, so anyway, August 2023 rolls around, and I believe the John O'Keefe investigation by the feds winds down, and then the Sandra Birchmore investigation winds up. Now here's ramps up. Now here's what's interesting. You can kind of tell Arca didn't do a lot of work for the feds, in my opinion, because there's a contract that was in the federal system that you can find in publicly listed for $36,000 for Arca right around the time that this was occurring. But the $26,000 or $25,000 or so was deobligated from that contract, and Arca only got paid about $9,000 or so. Maybe we'll hear about this today. Now, what's weird is then Arca in March of 2024 sent Reed's defense a retainer agreement for roughly the same amount that was deobligated from the federal contract. Before the first trial, $26,933 or $693, somewhere in that area was the retainer agreement. Reed's team then contacted Arca in violation of a federal protective order during her first trial. She then paid Arca the invoice that was originally sent as a retainer agreement in March in July of 2024. And then none of this came out until, for some reason, the U.S. DOJ changed over in January of 2025 when President Trump took office. Then new U.S. Attorney Leah Foley comes into office. All of a sudden, on January 30th, 2025, Hank Brennan gets a TUI response for the first time ever, according to public statements in court by Mr. Brennan, that actually contained responsive information about the nature of Reed's ongoing discussions with Arca. And then what's really interesting is that single TUI production had just kind of a header of an invoice between Reed and Arca, but within 14 days, February 13th, 2025, Reed's team is turning over previously hidden contacts and payments between Arca and Reed's team to Hank Brennan and the court, Judge Canoni. And that leads Judge Canoni to make a finding of fact on the record that Reed's team violated made material misrepresentations to Judge Canoni, including as recently as a February 6, 2025 sidebar. Okay? So that's the context here. Reed, leading up to what happened before opening arguments, had already got caught multiple times trying to mislead the court and withhold information and payments about information and documents about the nature of payments and contacts that Reed and Reed's team had with Arca over this period, starting sometime in March of 2024 and going right on through right now. That's what today's voir dire is about. It is going to be intense, and that starts at 12 noon, folks. My name's GrantSmithEllis. It's coming up on 7:45 a.m. We have about an hour and 15 minutes until today's Karen Reed trial gets into session. As you can tell, I'm an animated towel. I haven't even had one half of my, whatever this is, icy blue lemonade Recon energy drink. I found it at the store. It was what I wanted. It has energy for towel. Now, I'm sorry that I haven't been able to engage with your comments. Of course, they are playing on the screen. I imagine they are still live. Yep, they're still playing real time, so you all can engage with each other like Tesseracts and with the audience and such. But for the time being, we are going to get caught up on what has led us to today's Arca hearing. Because remember, the timeline last week about what's even going on with Arca procedurally is a little convoluted. Why? Because every other feed covering this trial cut out and didn't actually cover the motion hearing at the end of the first day of trial. So let's watch it all together. Let's get caught up. Let's be erudite, cogent, prepared little towels. Clearly, Towel slept enough this weekend and is fully revitalized and excited to watch this with you today. I heard the Arca hearing starts at noon, lunch is at 1 p.m., but expect to go afternoon, folks. Expect to go all afternoon with this Arca hearing, especially if they flew in. So let's keep our eyes on the ground. There's a lot of developments. Trevor McIntyre says, wouldn't the U.S. Attorney be interested in these 100 deleted texts as there was a federal protective order barring certain communications? Wonder if they'll subpoena them. Yeah, I wouldn't be surprised if the new U.S. Attorney is like, what happened under that old administration? And remember, that old DOJ did not like cops. They were very liberal. Rachel Rollins was extremely liberal. She was close to the Biden White House. I have a theory, in fact, that have you ever, folks, wondered why would former U.S. Attorney Rachel Rollins and Aiden Turtleboy Kearney have been talking directly during the 2020 Senate primary in Massachusetts between Joe Kennedy Jr. and Ed Markey? And furthermore, why would Rachel Rollins, a hyper-liberal, be talking to Turtleboy, a conservative ostensibly, about sending Rayla Campbell, another hyper-conservative, to Joe Kennedy Jr. Senate primary campaign events. Have you ever wondered if maybe the Biden White House saw Joe Kennedy Jr. taking the same path as JFK, literally going from the federal House of Reps to JFK's old Senate seat while in his 30s or so, might have presented, looking forward, a primary challenge to Biden in 2024? Now, mind you, what Turtleboy and Rollins were doing was they were sending Rayla Campbell, this kind of disruptor Republican, to Joe Kennedy Jr. primary events. I think Markey was going to win that race no matter what, but the Democratic establishment and the Biden White House in particular, I believe, tipped the scales to help Markey win. Not just because they wanted Markey in there, because they saw Joe Kennedy's returning to earning JFK's Senate seat and following a similar trajectory of JFK as a threat to Biden in the primary in 2024. Now, in hindsight, with that chaos that was Kamala Harris and Joe Biden's combined strange primary or whatever what that was, that did not work. I think Joe Kennedy Jr. might have actually been a more viable alternative, but needless to say, piecing the puzzle together, I think the reason Rachel Rollins got appointed as U.S. Attorney, and eventually forced out, by the way, but just one more note here on that federal probe. Rachel Rollins got forced out as U.S. Attorney in May of 2023. Why? Because Rollins, in a separate situation to all this chaos, Rollins' ally, Ricardo Arroyo, who was then a sitting Boston City Councilor, lost an election for the primary for Suffolk District Attorney, the very seat Rollins left to go become U.S. Attorney at the appointment of the Biden White House. And when Rollins' ally, Ricardo Arroyo, lost that Democratic Party DA primary for Suffolk County to Kevin Hayden, Rollins got upset. Now, Hayden is a Democrat, but he was appointed to fill Rollins' seat by then Republican Governor Charlie Baker. And by far and away, Kevin Hayden is more moderate, of course, than Rachel Rollins. Almost anyone is more moderate than Rachel Rollins, Democrat or otherwise. And so as a result of Rachel Rollins, of that Suffolk DA primary where Kevin Hayden beat Ricardo Arroyo, Rachel Rollins got caught by the DOJ's Office of the Inspector General, starting a pretextual probe into Kevin Hayden, leaking it to the Herald and the Globe, and then using it to smear Hayden, and then texting Arroyo that Hayden would, quote, pay for beating Arroyo. That's what that old DOJ was like, folks. And why I say this is, if you're U.S. Attorney Leah Foley, you must be thinking, oh my goodness, the liberals ran amok under Rachel Rollins in that old DOJ, and for some reason this Karen Reed woman was allowed to be their kind of cover apparatus to do a honeypot to get attention on the state police and drive tips, and then they stumbled onto the Sandra Birchmore cover-up. And by the way, folks, to tie this all together, don't think for 1 second that the feds don't realize that the unit that investigated Karen Reed is the same unit that investigated Sandra Birchmore. Two of those cops used to work in Stoughton, where Matthew Farwell used to work. There was a cover-up here, but it wasn't related to Karen Reed, who is responsible for John O'Keefe's death, in my opinion, by backing up with a BAC, blood alcohol level, between 0.13 and 0.29, 2 to 4 times the legal limit, at precisely 12:32 a.m. on January 29, 2022, thereupon allegedly making contact with John's body, striking John, causing John to hit the cold ground, be rendered incapacitated by a traumatic brain injury, and then Karen left John to die for hours in a blizzard, allegedly, as which induced hypothermia, as confirmed by a reddening of John's pancreas during the medical examination, therein resulting in John's death. There was no cover-up there. But the Sandra Birchmore situation, folks, maybe the feds do have more to say. Maybe the feds will have more to say about why Karen was allowed to run amok. Who knows, folks? Who knows? My name's GrantSmithEllis. Now, I'm sorry, Trevor McIntyre, your comment was very interesting, but it absolutely sent me on a tangent. You know what happens when Little Towel wants to talk about the overlapping concentric social circles which define soft power dynamics in the United States of America. Now, as Little Towel, I believe we should reverse that ethos, and instead of trying to preserve, demonstrate, and expand our power, we should create a new world ethos rooted in trying to preserve, demonstrate, and expand universal love and small acts of service for one another. So before we dive into this history of ARCA, I hope you all take some time taken this morning to reflect and think about how you, through small acts of service to your fellow towels or those in your life or the wider world, how small acts of service through 6 degrees of authentic separation, not 6 degrees of Chewbacca, can help to invigorate that new appreciation and reverence for universal love as a shared principle upon which modern compassionate digital age can arise. All right, but my name's GrantSmithEllis, and this is, of course, Towel's Public Information Service. I appreciate you all tuning in. The Karen Reed hearing this morning doesn't start for another hour and 9 minutes, so why not do a periodic reminder about the importance of public information services as to engendering cogent public discourse and bringing about a spirit of compassionate universal love for the digital age? I think this is wonderful. All right, but anyway, now Grant's tangents, they're learning curves. Well, if you think about it, human relationship to universal truth and human relationship to universal moral principles such as the categorical imperative, which I believe is defined not by the words do not lie, because you might need to lie to save Jews from like an invasion of dangerous forces. That's how I think about that. The better categorical imperative is do small acts of service for others. But whether it's human morality or universal truth, all humans have an asymptotic relationship with that kind of sort of understanding. We are all perpetual learners in that sense. The worst thing you can be is, instead of an asymptote, some kind of, downward sloping curve away from universal truth. It's the approach. It's trying to strive in a perfectible way to understand universal truth or universal morality. But the key to being an asymptote, like being a towel, is that you will only approach, but you will never touch that sublime line that is universal truth or universal morality. It is a process. It is the process that matters, and striving to get as close as possible is what I think is the manifestation of human eudaimonia. That's what the Greeks would call it, best possible good, or striving towards that. The Latin term is summum bonum. I think they both function in a similar manner, but those are the two terms. Anyway, clearly Towel has had an energy drink today, and Towel is looking forward to this ARCA hearing. Before I continue to get distracted, let us actually get caught up and watch what happened. Asymptote. ASMYTOTE, asymptote. It's kind of like a line that approaches but never touches an axis. Asymptote. Okay, is this a spelling bee now? Towel spelling bee. I'm having a wonderful morning. All right, folks, we need to actually watch this, though. I'm sorry. I know I can sense you all don't want to learn, but while we're learning, I can sense that there's this congenial atmosphere in the chat that wants to talk about all sorts of things, but we need to focus our attention, even if we may not want to, and we're going to watch this clip. By the way, I don't know if you know this, but the Towel channel has now completely evolved. You now have the ability to become Towel members, and you can use Towel emojis. Look at this wonderful lineup of emojis. They are so glorious. You can use Towel emojis. And then you can also support the channel now for the first time ever, although you will not get priority for doing so because everyone's comment is treated the same by Towel. You can send super chats from within the stream. Towel is truly honored and appreciative of all the Towel friends, the washcloths, the flannels. I saw we have Sheffield Flannel here with us. Hello, H. It's great to see you. God bless Sheffield United. May they continue the honorable legacy from the late 1800s and early 1900s that so has earned a place of reverence in Towel's mind, the early English Football Association pyramid, and Sheffield United's dominance thereof. But yes, it is a new Towel world, and I'm so honored to have all of you here. Like I said, washcloths, soap dispensers, flannels, paper towels, towelettes, or otherwise. Now, if you missed the major news I'm avoiding doing this ARCA thing, but we're going to do it. If you missed the major news last week, towelettes made an appearance in the Karen Reed trial. It was a glorious moment, truly a glorious moment. Let's see. The energy drink I have is a Redcon energy drink. It has 200 milligrams of caffeine, 200 milligrams of alpha GPC, I don't know what that is, 1 gram of L-carnitine, 1 gram of taurine, and B vitamins. Needless to say, it's a lot of energy, and I'm ready for this. Okay, towel friends, back to the video. We need to actually get caught up. We're doing it. Here we go. All right, here we go. So this is what happened right before opening statements, towel friends, okay?
Commonwealth's motion regarding defense opening statement. I think the first two motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed, so you will not have an independent reader. Is it fair to say that the third and fourth motions, Commonwealth motion to enforce compliance with court's April 16th Arca discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No.
All right. In light of that and the fact that we don't have time, this juror's been waiting for as many as 3 weeks now, I'm going to prohibit you from mentioning Arca in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give the facts. I would like to hear the law.
That's more than 5 minutes. I'll see you at Sidebar. Come up here.
All right, towel friends, that was just the first part of trial. Now, we have talked about this before, towel friends. We have talked about how big of a deal it is to have your opening statement as a lawyer changed around at the last minute. Oh, by the way, I just saw Lisa Cox send our second ever super chat. I want to first of all say a huge thank you to Jew Drops, who became not only the first towelette mentioned in the John O'Keefe and Karen Reed trial, but Jew Drops has also now become the first person to send a super chat, which is just wonderful. And then we had a super chat from Lisa Cox as well. Thank you so much. As you know, all of your comments are equally weighted in priority. The one thing that super chats do that I can't control, but is just a benefit of doing it, is your comment gets pinned for a certain amount of time. So God bless you for supporting this stream, towel friends. It means a lot. We just took a look, though, at that first part of the Arca situation. We're going into opening statements. Why would Alan Jackson be banned from mentioning Arca by Judge Canoni? Well, first, the 105 deleted text messages. But also, do you start to wonder, folks, whether it's possible that Judge Canoni's thinking about excluding Arca? I certainly think it's possible. The lawyer certainly got that vibe. How do I know? Well, towel friends, look at all this erudite preparation Towel did for you all today. We don't have to go searching for clips. All we have to do is wait for Towel to load up the next video. And we have the full hearing. So let's listen. Judge Canoni, where Judge Canoni said, let's listen to Towel's analysis. If you're just tuning in, you just heard the clip play from Judge Canoni, where Judge Canoni said just right now to us, to the Towel, Pressy and Towel friends, that we are going to come back for a motion hearing. The court pool feed cut, everything else cut, but little Towel keeps pressing away. Also, Towel is only 7 subs away. Oh, we might be coming back, folks. Oh, here we go. Wait a sec, folks. As soon as we come back into session, Towel will have it for you. Here we go, folks. We're back into session. We're the only people who have this.
right. So we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16, 2025 Arca discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential Arca witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Rentschler. That does not reconcile with the past positions and representations of the defense to this court, to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the Arca mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of Arca's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that Arca should be ordered and required to provide that evidence is totally in contrast to what was represented in the past. So before there's even a thought of Arca testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's facts. We won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is, at the time of the opening, it is ambush, it is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away, he is not available, and so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with Arca. They could have called any expert, asked any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Rentschler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court, that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers, we've all tried a lot of cases, it would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi's issue, I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity, so I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders, and I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they would be provided, and he said no. And I asked you at Sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, doesn't the aren't the ABA guidelines the counsel is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware of
regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email, and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided, pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the community text.
That the audio is buffering. Give it a second. I moved around some settings. All we're really hearing, by the way, is Bob Alessi over and over and over again trying to say, yes, we deleted the text messages, but. And you might be wondering, well, why are we listening to this then? Because it shows you how nervous the defense is about this. Yeah, Dewdrops, I'm trying to restore the sound. Unfortunately, the actual source video that we're relying on here is, to call it poor would be an understatement. So I'm doing 2 things at once. I'm trying to reduce its quality to make the sound better, and then I'm also trying to balance things out. So. All right, but I'm giving it about 15 seconds for things to kind of balance out here, and then what I'm going to do is I'm going to return to playing this clip. Oh, all right, give me 1 second. That was one other thing I did to try to make it a little bit easier on the system. No promises, friends, no promises.
Over from Ms. Little, the only other person on the defense team who communicated with Arca. We turned over her text and the text of her text messages. There is nothing else in existence to provide, and importantly, The defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have, and in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently, we've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved, and there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second
Thank you,
motion.
Your Honor. The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that Arca is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move, and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th, the Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it, and by March 24, we received the PowerPoint that was of the Aperture that was supposed to have 2 things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes.
So why don't you highlight them very quickly, because I need to say something.
I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the taillight was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages Arca. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report, and then the last 2 items, we renewed our request to preclude Dr. Welcher on Dalbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that...
All right, so I heard that the audio is cutting out again. It's really not you all. It's what was happening was Alessi was yelling into the microphone, so the volume keeps spiking, and no matter what I do, I can't get it to just play at a level that doesn't overwhelm the feed. But here, let me try this actually. We don't have to stare at them. Let me know if this audio is a little clearer. I'm going to reduce the bit rate of the video actually and try it this way. By the way, just to get folks caught up, if you're just tuning in, we are not watching this gratuitously. Today's ARCA hearing, this is why there is an ARCA hearing today. So what we're watching is, in fact, the very substance that led Judge Cannoni to deny Reed's team the ability to mention her own experts from ARCA in her opening. And then furthermore, why today's ARCA hearing, based on the substance alone, is going to be such a big deal. But yes, part of what I'm doing here is I'm readjusting on the fly because Bob Alessi was screaming into the microphone, and I'm trying to get the clip to play. Now, the important part of this, we are going to hear Bob Alessi talk, I'm sure, for a long time today. We're going to hear Hank Brennan talk for a long time today with these witnesses. The important part is what Judge Cannoni says at the end. The reason I'm playing you Bob Alessi's words is, it is so ridiculous what he argues that listening to how Judge Cannoni responds after he just rambles is actually very interesting. So let's see if we can get it to play a little bit more normal here.
That timeline shows that the Commonwealth took 6 months from the last trial. 6 months. And the defense took merely 2 days after they got the final report of Aperture to retain Arca. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain Arca. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, Arca was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain Arca. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put Arca on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had Arca proceed forthwith with post haste. and they are working post-haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with Arca. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All right.
Go ahead.
Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages as opposed to emails. Text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of Arca to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to Arca and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
All right, so I need you to wrap it up because there's something I want to say.
Certainly, Your Honor, I'm going to wrap it up in 10 seconds. There are no
Did you all hear that? Judge Canoni said, I'm not making a conclusion today on excluding Arca. Is that what today's Rule 14 hearing might be about? I think we got a preview. Now we're going to listen to Judge Canoni's actual ruling here at the end of this hearing, which actually led to today's 12 noon. By the way, folks, I'm told that the hearing for Arca starts at 12 noon. Okay, Eastern. That's 3 hours and 35 minutes from now. Oh, Christina, you are so kind. Folks, we have a rule on this. We are now a super towel public information service or something along those lines. I'm not really sure. You can now do memberships and send little stickers on the chat. Everybody who sends chats and stickers is considered the same as people who just send regular chats. You never have to donate or otherwise to participate in the wonderful towel universe. Also, I want to say a few things. One, I saw Murder by Maestro pop into the chat. It's wonderful to see you, friend. I see so many towel friends just flying by on the screen. I saw True Crime and Wine come in and join us. We welcome some new friends to the honorary towel fold. Jennifer Ray, Brutally Honest. The rules of the wall of the blue wall of towel friends is as such. No derogatory comments, no discriminatory comments, and people can't sea lion. You have been entrusted with a sacred responsibility by joining the blue wall of towel justice, and it is an honor to have so many of you here. If you're just tuning in, my name's GrantSmithEllis. We are leading up to today's 9 a.m. start of presentation of testimony or continuation of testimony in the Karen Reed and John O'Keefe trial. Now, we can do a quick summary of what happened in week one. We'll do that in a minute. But what we really need to get caught up for is why we're stopping today's testimony halfway through and, in turn, doing a voir dire hearing of Reed's experts from Arca. This voir dire, I want to give folks some understanding here. This was supposed to happen mid-trial. right before Arca's testimony. It got expedited because Reed's lawyers admitted to deleting 105 text messages with Arca. It's a big day, folks. Sunken grave. Sea lioning is when someone ostensibly acts in good faith but repetitively asks similar questions, not as a form of good faith discussion, but to undermine and derail discussion. If you Google it, there's kind of specific examples, and as a member of the Blue Wall of Towel Friends, it's worth knowing what sea lioning is, because it certainly is something we keep an eye out for in the chat. None of the folks who are in the Blue Wall of Towels ever do that, but sometimes we get people from varying perspectives who come in and try to sea lion a little bit, and all the Towel Friends keep an eye out for that. Brooke, it's so wonderful to see you. Really, folks just keep flooding into the chat. We are leading up, as Towel mentioned, to today's 9 a.m. Karen Reed and John O'Keefe retrial. It is day 5. It is Monday, April 28th. It's almost 8:30 in the morning here in Boston, where Towel is broadcasting from. I guess it's a nice day here. It's supposed to be slightly good weather, but needless to say, we are going to check in on a few things. One, we're going to watch what Judge Canoni actually ruled that resulted in today's hearing on Arca. Now, you're at first going to hear Judge Canoni say, I want them here Friday. Then we're going to watch the follow-up video where it gets moved to Monday, but that only makes it worse for Reed, because what was another consequence of Arca's hearing for voir dire for Rule 14 reciprocal discovery compliance being moved to Monday today in just over 3 hours? Well, folks, Arca had to have completed all their testing. That was the punishment. So notice, folks, when we start, we're going to hear Judge Canoni say Friday. Don't think that means you missed the hearing. It's actually today at noon. Jennifer Ray says prayers for Brennan and John's family. Lisa, good morning. Welcome. Thank you for your good wishes. Welcome to the honorary Towel fold. We are a Blue Wall of Justice here on Towel Channel. Okay, let us go back to the video and let's listen to Judge Canoni.
Violations of any discovery order, no violations of this court's order. And with regard to the retaining of Arca, because we're the defense, we acted expeditiously in response to the information we're getting, and this can be tested with Arca, the statement I'm going to make. To this date, Arca still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the Arca witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for Arca to bring all these items with them. So Friday will be for Arca for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I got to talk through Arca and I've got to understand what they have and what they don't have. So I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay, now I have that order for you, friends. You want to see it? Why do I have this order? Because I'm a towel. And as I said the other day, do you know why they call a towel a towel? Because it's a towel. Now, here's what the order says. The court hereby orders Dr. Daniel Wolf and Dr. Andrew Rentschler, Arca witnesses, to produce the following. All records within Arca or its owners, parents, employees, or representatives' possession, custody, or control, partners, not parents. I thought it was parent corporation. Partners, in whatever format kept that reflect in or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth v. Karen Reed, 2282 CR 000117. Such records must be produced to the Norfolk Superior Court by April 25th, 2025 at 9 a.m. This order includes, by way of example but not limitation, all correspondence via regular mail, email, text message, and or encoded messages between all the above entities and individuals and any third parties. The order also includes all reports and or draft reports, as well as all test results, photographs, video or media recordings, charts, graphs, and calculations and recorded observations of all tests or experiments undertaken, whether the results were included in a report or not, and all internal memoranda and phone records related to communications about work performed on this case. The order also includes all records related to time spent on the case, including timetables and draft and final bills. To the extent that any record responsive to this order is kept in an electronic form, the Arca witnesses shall bring with them the appropriate hardware, equipped with the appropriate software to allow the court to access all such records over the at the voir dire hearing. Folks, are you ready for this? It's even more than what Judge Canoni was just talking about, dear friends. It's everything you just heard Towel read off. It could not be any more intense. I'm a towel. I'm with you. It's almost 9 a.m. We're going to see 3 hours of evidence, and then we're going to get to this Arca hearing. The world may not be ready for it, but little towel friends, we are ready. We paid attention. We read the documents. We watched the previous hearings. We saw every moment of these discussions. The media missed it, but my towel friends, you did not. The towel universe is prescient, cogent, informed, erudite, and able to ward off insidious usurpations of our liberal form of Republican governance. Notice what I did there? We're a liberal republic. That's why the Democratic Republican Party used to be a thing. God bless Thomas Jefferson. We are ready. I agree. Okay, now, one more thing we're going to do is we're going to watch the next. We can do one of two things. Would you like me to list off the U.S. presidents dating back to Franklin Pierce in order? Or would you like to watch, as a moment of levity, or would you like to watch the next segment in the Arca developments? Personally, I think I'm going to do the presidents. All right, ready? We'll do this in like 45 seconds. Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Chester A. Arthur, Garfield, Cleveland Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. There you go. Look at that, towel friends, all the way back to Franklin Pierce in like 35 seconds. Oh, well, I'm glad you all enjoyed Towel rattling off all the presidents. It's a parlor trick. I use it to mock David Yannetti when he quotes Rutherford B. Hayes. He doesn't actually quote Rutherford B. Hayes. What he does is he quotes Teddy Roosevelt. And I really like Teddy Roosevelt, but I think it's a little ridiculous. So I'm like, David Yannetti likes to quote Rutherford B. Hayes. So anyway, that's the list of the presidents. I think it's about 35 or so, going back to roughly before Abraham Lincoln. I can do the first four as well, obviously. Washington, Adams, Jefferson, Madison, and I think there was a second Adams in there. Where it gets a little funky is from 5 to 11 for me. I can pick back up somewhere. I can do Van Buren at 8, and I think, I know that from Seinfeld, the Van Buren boys. And the Bank Wars, Andrew Jackson is in there somewhere as well, maybe 7. But I really struggle, and Polk is in there. That was a very mundane presidency. There are some presidents I don't particularly have down, but for the most part, I've gotten it. Oh, Tyler's in there too. And then I think whoever they called Tippecanoe, he's in there as well somewhere. But I'm doing my best, friends. I really like U.S. history. Okay, we can't get distracted, though. Just because Towell likes to list the U.S. presidents, we must stay on task. We must become erudite consumers of information. Okay, this is what happened next. This is how we ended up with a Monday voir dire and how things got even worse for Karen Reed's team. My name's GrantSmithEllis, by the way. We are only 24 minutes away from the start of evidence in today's Karen Reed trial, and I am here to preview for you what's going to happen with Arca because I have all these clips archived because I'm a towel. Here we go.
Your Honor, I did email Mr. McDermott yesterday evening. We did speak with Dr. Wolf yesterday, and he is not available.
Sorry, before we get into this, Lisa, we are going to talk about that on Wednesday because Aiden's hearing related to that is Wednesday. So I have all the information related to that I want to say, but we're going to do it Wednesday. Why? Because I am a good faith towel, and I cover things as they happen. I don't engage in all this noise and obfuscation. I find out what's going on. I look into it, and we go from there. Now, there are a lot of developments related to that we maybe will talk about during the break, or if there are, like, the morning recess, I'll go into it roughly, gently. But this is about Arca today, and anyone trying to distract from that is a subversive person, even if there are very real concerns I have about those other situations. All right, let's listen.
Your Honor, I did email Mr. McDermott yesterday evening. We did speak with Dr. Wolf yesterday, and he is not available on Friday. Is there another day that works for the court reasonably soon that we can have them come in?
We could do it tomorrow afternoon, if tomorrow is a better day for him. Yeah, they're just in Pennsylvania, right?
Could we do a Zoom hearing tomorrow?
No, he needs to be here in person. Mr. Alessi, I issued an order late yesterday. You were the one yesterday talking about this voir dire. I assume that you folks provided that order to the Arca witnesses. We don't have an address to serve them. We don't have enough time.
I provided a copy.
All right, so we could do tomorrow afternoon.
We have to make travel arrangements for them to get here. Yes. And he has a conflict that begins on Thursday and goes until Friday. So is there a day next week that works for the court?
Well, we could do Monday, but what I'm going to order is if it's continued all the way until Monday, the testing that he outlined that you were contemplating or were going to do, that has to be done by then. So we can do it Monday, but that testing has to be done by then.
Okay, we'll make every effort to make that happen. I don't have a status on some of the shipping components that they need for the testing.
Okay.
So we'll do the best.
All right. So that'll be done by Monday. We'll do this Monday. I don't want to devote a whole day where, Friday was easy to devote a whole day because the jury thought they were only going to be here a half a day. Can we do this just in the afternoon?
Your Honor, I am unclear as to what the subject matter of the voir dire is going to be.
So I am indifferent to this voir dire. All right? I'm trying to help you out by having the witnesses here because I found a violation of your reciprocal discovery. So I don't know how long this is going to go. I would assume I'm giving you the opportunity to put them on and the Commonwealth an opportunity to cross-examine them.
First, in terms of time, we can do it within a half a day.
All right. Do you agree with that, Mr. Brennan?
Regarding an afternoon voir dire of Arca on Monday?
Yes.
We'll defer to the court whenever is available.
I'd like to keep the testimony going. I've already told the jurors that they have a half a day Friday, so Friday we'll be back to where we were at the half a day.
Will we have a chance to be heard on rulings regarding Arca? Because I still have the same concern about new information.
Yes. What do you mean? When?
Whenever it's convenient for the court, but I have concerns about these witnesses bringing in new opinions that we will not have an opportunity to consider.
All right. Can we do that the day of the voir dire?
Whenever's good for the court.
All right. So maybe we'll break with the jury at 12 on Monday. Now they're going to have 2 half days in a row, but we'll break.
Will we still do the voir dire and I'll have witness testimony prepared for Friday?
Yes.
Okay.
Your Honor, may I have one further follow-up question, please?
Yes.
Thank you. The reason I asked for, and I appreciate the opportunity for the voir dire, it's not lost on me, But what I'm trying to understand is I want to hit the target, whatever the target of the court
So
is.
one of the big concerns I have is that 105 or more text messages were deleted, and you said in due course. I have no idea what you mean by in due course. It's a pending case. I need to figure out that at least.
That's
okay.
In Your Honor, the 30-day, if you make the call, the defense has this very same issue with a matter with District Attorney Morrissey. So you said, I'm unclear of what deletions are, and we're happy to have testimony. The Arca witnesses can discuss it.
They're to bring them if they still have them.
Exactly. That is also very helpful. But this 30-day auto-delete, a lot of attorneys do that. District Attorney Morrissey did that.
I need something in writing about that. That's not my understanding on how you keep records in a pending case. And remember, you still said, out of the blue, months later, a bill came. This gives me pause about that, frankly. Okay?
We're happy to discuss that as well, Your Honor.
All right. So,
Take a clarification.
all right. And there'll be more. I'm not limiting it to that, but those are my big concerns.
Appreciate it.
All right. Are we ready to start?
Okay, folks, you just heard it right there. You just heard it from Judge Canoni herself. That is a preview of what today's Arca's hearing is going to be like. Oh, hold on. Do we have the arrival of Karen Reed? No, it's Hank Brennan. Oh, my word. What a rare moment. We're going to get the arrival of Hank Brennan. All right, hold on one second, folks. We are outside of court right now. We are watching right now, and we are going to take a look at Hank Brennan's arrival. Give me just 1 second. I'm a towel. All right, friends, if you want to be in the clip, now's the moment. Give me 1 second. All right, give me 1 second. I'm a towel. You're all towels. Everybody's a towel. All right, let me put this right here. All right, friends, here we go. This is going to be Hank Brennan's arrival. Let's see if we can hear any volume. Hold on 1 second. Hold on. I'm a towel. No volume. I can't do anything about that. Get out of the Hank Brennan shot. Okay, there we go. What a good shot. All right, give me 1 second, towel friends. Give me 1 second. Hello, towel friends. My name is GrantSmithEllis. If you're about to tune in, we're just 15 minutes away from the start of presentation of evidence in day 5 of the Karen Reed and John O'Keefe trial. Karen Reed, of course, alleged to have gotten drunk, driven with a BAC 2 to 4 times the legal limit, struck John O'Keefe, and then left John to die with a traumatic brain injury, coupled with the effects of hypothermia in a blizzard at 12:32 a.m. on January 29, 2022. We are waiting for a half day of presentation of testimony, and then we are every single person who follows this trial has been waiting for the 12 p.m. noon voir dire related to Rule 14 reciprocal discovery compliance as to Reed's experts from Arca, 105 deleted text messages from Arca, potential massive implications for federal protective orders and Reed's defense, who have already been found to willfully have misled the court on multiple occasions about the nature and payments of contacts and communications and documents involved between Reed and Arca. Will we find out more? Will Arca arrive? Folks, this is Hank Brennan, the prosecutor, who has changed the whole the scope and context of this case, who has the momentum on his side. Hank Brennan's walking into Norfolk Superior Court in the lead up to today's hearing. Let's watch live. There's Mr. Brennan walking with his escort, the media, penned in at the base of the stairs. Mr. Brennan, cool, confident, collected, takes his turn, gives a nod, and walks on. Hank Brennan, folks, arriving to the media. Towel Attenborough here, describing the events in real time. Tune in, youtube.com/@GrantSmithEllis. Ask questions, join the towel fabric. I'm a towel. Talk to you soon. All right, that was the clip, folks. We're still with you, obviously. And now, friends, we await the arrival of Karen Reed. We await for the arrival of a Karen Reed in her natural habitat. I'm a towel. Miss Reed was forced to wait for Mr. Brennan. Here we go. We wait. Where's Miss Reed? Oh, she's coming up the back. Here we go. Hold on. Who's got the glamour shot today? Alan Jackson and Bob Alessi. Hello, towel friends. My name is Grant Towel Attenborough Smith Ellis. We are watching a Karen Reed in her natural habitat arrive for day 5 of what could be bombshell developments. There could be bombshell developments for Karen Reed in her trial for the alleged drunk driving death of John O'Keefe caused allegedly by Miss Reed, going 24.2 miles an hour in reverse with a BAC between 0.13 and 0.29 at precisely the moment of 12:32 a.m. on January 29, 2022. Wherein the state alleges Reed struck John O'Keefe with her vehicle, causing a traumatic brain injury when John hit the ground, thereupon being compounded by the onset of hypothermia and in turn causing John's death. Now Karen Reed arrives. She's walking up the back of the pack. She has Bob Alessi with her, Alan Jackson in the front. She arrives a lonely figure. Her experts from Arca could be removed at a 12 p.m. hearing. Evidence will close early for that 12 p.m. voir dire hearing, which the Karen Reed and John O'Keefe retrial world will be watching. Let's watch Karen arrive, friends. As the Towel Friends chat on, Bob Alessi walks slowly, methodically. Alan Jackson in front of the cameras, his natural habitat. We have sound! We have sound! Birds chirp. Towel watches closely. There are no questions. It has a hushed silence. Karen Reed avoids the media and takes the ramp. Oh my word, things are bad. Things are bad, folks. All you can hear is the squeaking of truck brakes.
This is different.
This is different, says the media. Things have changed. You can sense it in the air. Towel Attenborough here, trying to keep calm and not disturb the Karen in her natural environment. Towel Attenborough must remain a stoic force as he observes the Karen. Karen Reed walking slowly up the ramp. Slowly, methodically, alone. Won't even go in front of the cameras. She fears them now. Her PR apparatus crumbling. And there she goes into the courtroom. My name is GrantSmithEllis. Tune in live, youtube.com/GrantSmithEllis for today's half day of testimony. And then the shocking 12 p.m. voir dire hearing related to Arca. I'll be with you, and the Towel Friends will be here. Join the Towel universe. Karen's not talking anymore. The comments are prescient. We'll see you soon. Thanks, Towel Friends. Thanks, Towel Friends. I had to do my towel thing there. Now, give me 1 second here. I'm going to pause that on your screen. Let's actually pause on the best image possible. Let's pause on the image of Hank Brennan walking into court, because I'm a towel. And I love how Karen Reed had to wait for Hank Brennan. Damn right you do, Karen Reed. There's Mr. Hank Brennan walking slowly, confidently into court for today's hearing. Now, we have a few things we got to do, Towel Friends. So Towel begs your indulgence. We got a few things we got to do here, all right? The first thing that we got to do is, Towel Friends, we are waiting, by the way, for the Karen cam to come on. That's when we know things are really going to get rolling. But if you're new to the Towel feed, then you'll know that one of the things that Towel Friends have to do is we write posts together. When it's time to start the day of coverage, we write posts together. So let's be towels and do that now. And I still don't have my mic stand. Someone was like, Grant, buy a mic stand. I have a mic stand. It's screwed onto the other part of my desk, and I can't get it unscrewed because it was attached there a long time ago. All right, here we go. Good morning, Towel Friends. Day 5 of the John O'Keefe and Karen Reed retrial begins with the arrival of prosecutor Hank Brennan. Now I have to think about how I'm going to word this next sentence. Here we go. I think I'm going to say Brennan walks coolly, calmly, and in a collected manner as the world awaits a 12 p.m., a noon Eastern hearing related to Reed hiding messages with Arca. There we go, folks. How do you spell coolly? C-O-O-L-Y? Coolly? Is that a verb? Can I cool? No. No. Coolly. Calmly and coolly. Calmly and coolly. Oh, it's with 2 L's. Calmly and cool. Cool. Let's just change it to cool. Cool, calmly, and in a collected manner as the world. Okay, so there we go. Got the Hank Brennan video, Towel Friends. I appreciate your indulgence. Yes, I do have to get a mic holder. Someone said, cool, calm, collected. Yeah, I like that. Let me use the verbiage that you suggested, Lisa Cox. 1 second. I got to get the actual arrival. Oh, folks, we don't have the Karen cam yet, but we could be just a few minutes away. We could be a few minutes away here. Bear with little towel. Cool, calmly, and cool. Brennan walks cool, calmly, and collected into court, into his natural domain, as the world awaits a noon Eastern hearing related as to read hiding messages with Arca. Follow along. Hold on. You know what we're going to do? We're going to go over here. We are going to go right here. We're going to get the link with the towel friends, and they're going to say, follow along, including special Karen cam coverage. Follow along, including special Karen cam coverage with the towel friends here. All right, there we go. So now we got a video uploaded of Hank Brennan arriving. That was wonderful. And now we got to get one more video out. Watch this, little towel friends. Look how rapidly we're pulling this off, and I can keep monitoring your comments too. And here is the arrival of a lonely Karen Reed at today's potentially bombshell series of hearings, potentially bombshell presentation of evidence in Karen's retrial as to the alleged drunk driving induced death of John O'Keefe at Karen's hands. Karen may lose her experts from Arca, and she hid from the media. Wow. Wow. I do have a microphone stand, by the way. It's just I don't have a microphone to attach to my desk. All right, so let's grab that clip of Karen. Thank you very much. Oh, folks, I have some audio. Hold tight. Watch live and join in with the towel friends during chat and see special Karen cam coverage here. All right, there we go, towel friends. There we go. Got 2 videos uploaded. Things seem to be relatively stable. I was able to keep watching your comments. Now, watch this, towel friends. You are going to be some of the first people in the world to know when we're into session. Why is that? Because we have the special towel Karen cam, and the Karen cam runs a few seconds before the pool feed, which means before anyone else, the towel friends will know when we are in session. Now, give me all of 25 seconds here, just getting the last of these videos up. There were only actually 2 videos, one of Hank Brennan's arrival and one of Karen Reed's arrival, who entirely avoided the media. Now it should go to 60%. It's interesting to both make real-time uploads and then make real-time clips, do live coverage, clip the stuff, upload it. It's just one heck of a day, towel friends. One heck of a day. Now, are you ready to get a real-time look? And we will find out when exactly we are coming into session, because we have the special towel Karen cam. Here we go. Give towel a second. Towel's working on it. Come on, towel Karen cam. Where are you? There it is. You're a towel. I don't want to cover Hank Brennan. Give me 1 second, towel friends. I'll get this adjusted for you. It's great to see you all getting excited. We are only 5 minutes away. By the way, towel friends, I just want to thank you all so much for your support and everyone celebrating Towel Channel becoming official as a whistle. Like I said, do you know why they call a towel? Because it's a towel. Do you know why they call a Towel Channel official? Because it can now take super chats and do all other fun things like use towel emojis and whatnot. It's great to see you, Angela Wittick, by the way, and Lisa Cox. I said hi earlier. Eva, it was great to see you. Wild Roses. We've welcomed so many new towel friends into the fold. Now, listen, I don't know how this whole YouTube thing works, but I really appreciate all of your support and memberships. Apparently, you can gift memberships to other people. Just God bless you all. It means a lot to Little Towel. We're going to be with each other all day today. Remember, this is a public information service. There's no ads. There's no sponsors. There's no anything. It is just you, much like PBS or the BBC, engendering informed, educated, and somewhat entertaining programming for the wider polity in the service of, as I said, creating cogent public discourse to ward off usurpations of liberal republics and the justice system. Isn't that a beautiful thing to support? But yes, that said, we're coming up on the start of hearing today, folks, and as soon as we are in session, I promise you, you are going to be the first people to know. Why? Because we're going to see what is that? What kind of thing is that? I don't want to see that. We are going to see the Karen Cam. We are going to see the Karen Cam start up, and then Tal's going to transfer you over. Now, one thing is you're going to hear a little bit of dual audio. You're going to hear the Karen Cam audio, and then we're going to, about 20 seconds later, be into session. If you missed it earlier, we saw Hank Brennan's arrival. That was quite intense. And if you also missed it, last week, Karen has just been devastated by Hank Brennan's case. Videos of Karen confessing to being drunk and driving when she shouldn't have. Videos of Karen mocking John's mom that caused jurors to gasp. It is bad for Miss Reed, folks. It's bad, bad, bad. And we're also, of course, waiting for the world waits for the 12 p.m. Arca voir dire hearing. Oh, that's what I wanted to say. So Tal is doing his best, folks, but I don't know when this YouTube thing actually sends out revenue. It might be like a month or so. So if you want to help Little Towel stream and you like what you're hearing and you don't donate again if you already donated through YouTube, okay? That I will get it in a few weeks, don't worry. But Towel definitely will share. As someone asked for it earlier, there are direct ways to donate. You can find them in the chat now. God bless you, those of you. Someone sent $5 over for a 7-Eleven pizza. I promise you I will be going to 7-Eleven. I also am working on trying to get an actual live feed set up from the court. That's going to be a little bit more difficult than I thought initially, but I have someone who explained to me what we have to do to actually get it set up, and I got permission, more importantly, from Court TV to do it. So all I have to do now is get an SCI drop or something, and then I have to get a piece of equipment that can do real-time uploading, which is just going to be a hotspot on someone's phone attached to like a drop device, and then, or maybe like it's probably going to actually have to be like something that can hook up to the Wi-Fi, but that's fine. And then that has to be able to perpetually upload. So I'm working on getting the Towel feed a pool feed as well, but I just want to say thank you. Oh, God bless you to the Towel friends who have been reaching out. Just appreciate it. It means a lot to Towel. This is a public information service. And by the way, I am talking through 9 a.m. because we should be coming into session any moment here. Bear with Little Towel. We have the fan. Towel friends, the fan is up. The fan is up, but we do not yet have the courtroom audio, which means we are not ready for session. Now, let's start a poll. Towel friends, the most important poll of the day, and it's not, is Chewbacca Aiden Kearney in a wig? Oh, thank you, Harvard Yard. You were one of the first members, you and Drew Drops. I will always remember you. I'm going to have to make you towel plaques. You both will get super towel plaques. Well, Drew Drops is super towelette. Will Arca be excluded from Karen Reed's witness list due to Karen's multiple Rule 14 violations? Yes? No? Testimony, Arca testimony limited by order. Okay, those are your options. What do we got, folks? What do we got? The poll is up. I'm interested to see your thoughts. This is definitely, there's going to be witness evidence too, but the Arca hearing at noon is the big moment of the day. What do we got? People are saying Arca testimony limited. That's limited. That's quickly losing, though. It's only at 67%. As of course I mentioned, my name is Towel Attenborough, and I'm here to monitor for you all. I'm sorry you have to. Oh, actually, you know what? I'm not going to make you watch the fan. We have a stand on this channel, a moral, ideological stand against the fan. We do show the light. When the Court TV pool operator shows the light, we show the light. But showing the fan is illegal. It is a violation of Towel's core constitutional principles. If I ever am allowed to write a constitution, one of the primary constitutional principles is going to be no courtroom anywhere ever shall permit a courtroom pool camera operator to broadcast a spinning fan. That will be called Towel's law. This is what you come here for. This is what you come here for, right, folks? Commentary on why Towel does not like spinning fans because they make people dizzy. We're almost here, though, folks. It's 9 a.m. We are going to come into session any minute, and I am going to be with you because as soon as we come into session, I'm going to turn you over. You're going to hear it on the Law and Crime feed. We are going to listen to a few seconds of the Karen Cam feed before we come into session. You all will see it before anyone else. Truly, Towel friends, I'm so grateful to have you with me today. We're leading up to 12 p.m. noon. Tell your friends, tell your towels. That's going to be the moment. That is going to be the moment, Towel friends. And just remember, Towel is going to be here with you throughout every moment. And we are going to be watching very, very closely. Very, very closely. So, I am excited, Towel friends. I think you all are a little bit nervous. I can sense the palpable tension in the air. A lot of folks are thinking Arca is going to be limited. I'm leaning towards exclusion, Towel friends. I'm leaning towards exclusion. You might say, why are you leaning towards... Oh, folks, get ready. Get ready, Towel friends. And we'll have special Towel multicam coverage. Don't forget, it will take me a few seconds to get it set up once we turn over. Actually, you know what? We can do that now. Look at that. I'm a Towel. We're going to change screens here, folks, but I'm still going to be with you. I'm changing over to my Grant Towel Attenborough mode. Now, as you notice in this mode, it's going to take me a little bit of time here to get things set up, and it's because I have some windows to move around. Don't fret. Don't fret, Towel friends. I will get everything set up for you, and we will be ready to go very shortly. What you're looking at right now, of course, on the screen is there is no Karen Cam coverage yet, but the reason why I'm taking a little bit of time to get things set up early is you will get your Karen Cam coverage very, very soon. So the first thing we're going to do is switch this over to the fan. I'm sorry you have to watch the fan, Towel friends. I have an ideological objection to making you look at the fan, but in a case like this, we have to watch the fan. Why do we have to watch the fan? Well, because the fan is going to bring us what we need here, which is when the real-time developments occur. You are also going to hear on your screen, because we have access to the in-room audio, you're going to hear that come up as well. You're going to hear that first, and then we're going to go over to coverage of today's Karen Reed and John O'Keefe trial. Now, a few things we got to work on. One, I'm going to bring up the Karen Cam for you. That's going to show up on your left, on the left of your screen. When the Karen Cam comes into session, that is when we are ready to go. That is going to happen probably in the next few minutes, so keep an eye out for it, friends. Towel is here with you, waiting, watching, patiently, doing his Towel Attenborough thing. Now, I'm also setting up for you the multicam coverage. Down on the bottom of the screen, you are going to see the Karen cam, a reiteration of it, the Karen's Eyes cam. You're going to see the Bill and Janet Reed cam. You're going to see the Nathan Reed cam. You're going to see the Marshmallow Man cam. That's what we call Alan Jackson because he brought up the Stay Puft Marshmallow Man for reasons that are not yet completely clear to Little Towel. And then you're going to see the David Yannetti cam. We just call that the David Yannetti cam. All right, so give Little Towel 1 second. And we wait. We wait patiently, like good little towels. Your comments, obviously, over there on the left of the screen. I'll get rid of that poll in 1 second so that your comments are a little bit more aligned with a little more flush with the Karen cam. All right, there we go. All the different cams are set up. And then the only thing we now need is Law and Crime will eventually do their split screen. And we, as good little towels, will do a, one side will be the witness, and then on the other side will be a different Karen cam. I like to do a more, I don't know if I'd call it refined, but I like to do a more precise version of the Karen cam. All right, so give Little Towel a second. I'm just getting a few things set up. Let's see. HB says, Grant, God bless you. He did by giving you a brain like few in the world. You are exceptional with your knowledge and your memory. Oh, that's so kind of you to say. Actually, because you all are being so wonderful with your comments, let's fix the comment section first. Hold on. Maybe we'll actually make the towel. Oh, someone sent a super chat. Hold on, I can't see it yet. It'll scroll up on the screen in a second. Oh, you became a member. God bless you, Pilgrim Shadow. You're a towel fan. We're all towel fans. We're all reciprocal fans of each other. It's a very loving towel family. Now, here's what we're going to do, friends. Hold on 1 second here. I have to, first of all, I just want to get this little thing off the top, because I might actually run polls today. So let's just bring this down a little bit. All right. And by the way, we're not missing anything. How do I know we're not missing anything? Because Towel Friends have the direct line into the courtroom. And as soon as that stream begins, we Towel Friends, before anyone else, are going to hear that. So we are waiting. We are waiting like patient little towels. My name is GrantSmithEllis. I do see all your comments. I'm adjusting the towel chat now so that you all will be able to comment right on the Karen Cam in real time. So give me 1 second while I get all that set up. There's a lot of towel things to set up, but we're also not in session yet, and I can do some of that when we actually get into session. By the way, I'll be with you for our morning recess. When we do take our morning recess, I, of course, will answer all your questions. You are towelettes. We're all towelettes. You know what? We can list on break. Dewdrops remind me. We will play the towelette clip. The moment that towelettes made their well-deserved appearance in the Karen Reed trial, we all celebrated. It was Dewdrop's moment to shine. Dewdrop stepped forth from the light and saith upon the world, towelettes have now been established as a primary motivator and player in the analysis of blood alcohol swabs in the John O'Keefe and Karen Reed trial. We all have taken our rightful place among the world hierarchy. We are towelettes. But yes, give me 1 second, because as Tal mentioned earlier, I'm going to, as we're waiting to come into session here, I'm going to make your comments on the actual feed today a little bit larger, and then I'm going to make it so people can actually read them. Because I'm a towel. And then we're waiting for court to come into session. We don't even have the Zoom feed up yet, towel friends, so don't feel like you're missing anything. You are not. I'm a towel. You're a towel. We're all towels. If you're not a towel, that's okay. You can become a towel. You can also be a flannel, a washcloth, a soap dispenser. You can be any number of things in the towel universe. We're very welcoming here. We believe in the power of towel unity. Yes, my friends, towels will facilitate international economic cooperation. Towels will engender the rise of universal love and morality. Towels will save the world from a descent into vacuity and greed. And we will do it together, waving our blue flags, asserting the principles of unconditional love, and proclaiming the importance of Hank Brennan. Yes, towel friends, we will come to define a new epoch, with our towel flags waving proudly, asserting that, yes, the towel faithful with a homeland somewhere in northern France are ready to take our rightful place on the world stage. We are towels, we're hemp towels, we're paper towels. Eva says it will be fireworks if Arca pleads the fifth. I agree with Eva. All of us together now, we wait patiently. We are on the Serengeti. We are watching. I am Towel Attenborough. You all are my loyal, I think a steed is a horse. So you're definitely not horses. You all are my loyal towel watchers. We sit. We watch closely. We observe for the Karen in her natural habitat. Getting a Karen on camera, a Karen Reed on camera in her natural habitat, folks. That's why you turn in to Towel Attenborough. Towel Attenborough provides very unique perspectives. We capture the target. We watch the Karen in her natural habitat. We analyze the Karen as she moves chairs closer, her nervousness, her anxiety growing. We have spa towels among us. I know that was a bit of a hard turn, but listen, if you're going to be Towel Attenborough, then you must remember there are spa towels. There are all sorts of different towels. All right, now here's one other thing I think we can do. I have a plan. We can make your comments even larger, but they'll have to be two at a time. Yes, I am Towel Attenborough, and you all are also fellow court whatever we have decided to proclaim ourselves, court watchers. And we have a mission, towel friends. Our mission is to provide erudite public commentary on matters of the utmost concern. All right, so let's see here. I think what I want to do is actually do it this way. Yep, hemp towels can be made of lots of different things. Oh, I see. Look at all these comments we have. See, I wanted to bring those comments down. That's exactly what I wanted to do. Oh, no. What did the towel go? Why did the towel go to the doctor? I don't know, Angela Wittick. What's this going to say when I reveal this as we wait for court to come into session? I bet it's going to be a good one. It had too much lint on its mind. That's hilarious. I give you a 10 out of 10 for that. You're hilarious, Angela Wittick. Look at that. We're going to have a big towel chat on the side today because we're towels. We're endearing towels. We're lovable towels. Actually, you know what we can do? I think I can take this clock, okay, because I'm a towel. I can take this clock and I can move it over here. It's going to move more, but let's just do that for now. And then, Grant, is Howard Cosell and Johnny Most reincarnated? Grant does his best. I really like Casey Kasem because he played Scooby-Doo or Shaggy in the Scooby-Doo films at one point. And there was a whole episode called or a whole movie called Scooby-Doo Be Cool or something. And it's about a guy like in the Nepalese mountains who broadcasts radio. Fascinating Scooby-Doo episode. And if you're wondering, Grant, do you actually watch Scooby-Doo? Well, I haven't in a while, but yes, I have every episode of the 1962 through 1964 Scooby-Doo series memorized. I am a huge proponent of that specific Scooby-Doo series, and I watch it quite often. And then if you're also... Oh, folks, I'm hearing noise. Here we go. Get ready. We're coming into session. I'm a towel. I'll see you at the break, towel friends. You're going to hear two volume. You're going to hear two channel audio for just a second. All right, towel friends. Now we just wait. Now we wait together. All right. We're waiting. Come on, lawn crime. All right, we got it. All right, towel friends, we're coming into session. Enjoy your commenting with each other. I'm here. I'll see you at the break. I'm a towel.
All persons have any business before the Honorable Beverly Kenobi, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and shall be heard. By the state of the Commonwealth of Massachusetts, this court is now open. You may be seated.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning.
I do have to ask you those same three questions. Were you all, four actually, I guess. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were last here on Friday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left on Friday? No. And were you all careful? Everyone said no or shook their heads. Were you all careful with your social media this weekend? Yes. Thank you very much. All right, Mr. Brennan?
Good morning, Your Honor.
Good morning.
Lawful call Ian Whiffin.
Okay.
Approach the matters we'd like to discuss.
All right, just come on up.
Oh my word, towel friends, we're starting the day with Ian Whiffin, the Cellbrite expert who's going to debunk who's going to confirm the Google searches from Jen McCabe. We're at 6:23 and 6:24 a.m. Oh my word, hold on, let me record this.
Careful with your social media this weekend.
I have to do one thing. Hold on, towel friends, you're not missing anything. You will see on the Karen cam when we are back in session. What we're going to do right now is I'm going to, no, please stop. I'm going to remove that. we're going to jump forward if they come back into session. Don't worry, towel friends, but I'm going to put this clock right here. Okay, we're going to have a brand new clock, towel clock. And then we're going to do this. Get ready.
Good morning.
Thank you very much.
Okay. Towel friends, just in, the first witness of the day on day 5 of the Karen Reed and John O'Keefe trial will be none other than renowned Cellbrite expert and person who has helped implement and develop the software itself, the foremost tool for analyzing phone records in the digital age. Ian Whiffin will be taking the stand to confirm that Jen McCabe Googled how long to die in cold at Karen Reed's request at 6:23 and 6:24 a.m. on January 29, 2022. They're in right away blowing the defense's nonsensical claims of an earlier Google search that was the result of Richard Green, a basically almost layperson who had to rely on Cellbrite chat support and wouldn't return Ian Whiffin's phone calls, to make a nonsense argument about misinterpreting a write-ahead file in the wall DB of a Cellbrite extraction and trying to ruin Jen McCabe's life over that misinterpretation, which Green eventually apologized for because there was no user deletion of any kind on McCabe's end. We're going to hear from Ian Whiffin, folks. Let's listen.
All right, Mr. Brennan.
Good morning, Your Honor.
Good morning.
Lawful call Ian Whiffin.
Okay. All right, just come on up.
We are now at Sidebar, towel friends. Tune in live, youtube.com/GrantSmithEllis, or on X, or anywhere you can find towel feeds. Join the towel chat on the bottom left. See the Karen cam, the Bill and Jana Reed cam. Let's go back into session.
Come on, call Ian Whiffin.
Please face our clerk and raise your right hand. Do you want your phone, the evidence you give to the court and jury in the case down here should be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, sir.
Good morning.
May I, Your Honor?
Yes, please.
Good morning, sir.
Good morning.
Would you kindly introduce yourself to the jury?
Yes, my name is Ian Whiffin. I'm a digital forensics examiner and decoding product manager for Cellbrite.
You just mentioned Cellbrite. Is that where you work?
It is, yes.
And you're a forensic examiner.
I am.
Can you tell us a little bit about Cellbrite, where you work?
Yes, Cellbrite provides digital forensic solutions to customers globally for access and decoding of digital artifacts from devices.
Where would you find a digital system? Is that resigned to a phone, or is it all systems?
Typically, Cellbrite focuses on phones or iPads, but we do have some additional devices that we can also integrate: computers, vehicles, things like that.
So simply, what is Cellbrite?
Cellbrite is a digital intelligence company.
Do they use a certain type of software? Do they brand a certain type of software?
Yeah, we create our own software to access devices and to decode the data that we pull from devices.
So essentially, does that software help you look into the data on a phone and analyze it?
It does, yes.
What is the role of a digital forensic analyst?
Typically, the analyst would take the data that's been extracted from a device, such as a cell phone, process that in software such as a physical analyzer that Cellbrite create, and use that information to filter, to search, and to create a report for the investigator that would allow them to see what happened on the device at the time being investigated.
How long have you been involved in analyzing data, sir?
I started my career in digital forensics in 2013.
Can you take us back to the beginning of your career and tell us a little bit about how you became involved in learning about analyzing data?
Certainly. I spent 5 years as a frontline police officer in the UK during the 2000s. In 2009, emigrated to Canada and continued policing frontline officer in Calgary before joining the digital forensics team in 2013. Pursued several qualifications related to digital forensics and just continued in that role until 2019, 2020, when I left the police agency and began working for Cellbrite.
While you were working at the police agency and began your career analyzing data, were there special classes that you took?
There were. In order to be a forensics examiner in Canada, you have to take a 3-week foundational course in Ottawa, basically covering the basics of digital forensics. And then from there, other courses are available that would focus on things like cell phones, would focus on how to get data from different types of devices. And then there's industry qualifications that can be sought as well, where you can focus on particular types of device or particular types of data.
Does software in this field continually change?
It does. Every time an update is released to an application or to an operating system, there's the opportunity for the foundation of that software to change. And from a forensics point of view, you have to re-understand what has changed, make sure you understand what is now happening on that device, and provide that information to the users.
As you've progressed through the field, do you continue to take classes?
I've not taken a class now since I actually joined Cellbrite and did the basic foundational courses that Cellbrite offer. But prior to that, I was doing courses across the industry.
Do you teach courses?
I do teach webinars. I don't teach any actual courses, although some of my research and some of my tools are taught to examiners in many of the industry standard qualifications which users seek.
Do you ever write papers about the subject that are published?
I do. So I have a blog where I publish my research. Sometimes some of those become papers which get peer-reviewed and distributed in more academic channels.
So when one of your papers is peer-reviewed, can you tell us what that means?
Yeah, essentially, other forensics examiners would read over the paper that I've written, do their own testing, compare their testing and research to what I've conducted, and make sure that what I've said is consistent with their findings. And presuming that what they find is the same as what I found, then they would agree that it's a valid document and it gets shared.
Take us now to Cellbrite. When you began working at Cellbrite, what did you do?
When I started there, I was considered the senior digital intelligence analyst. My role was to help the developers of the software understand the role of a digital forensics examiner, what an examiner needs from the tool, what an examiner wants to do with the tool, and how they want to use it. And then since then, I progressed to the decoding product manager, where I can manage the backlog of software applications that we support, decide how we should support those applications, and how that information should look to the users.
Do you do research?
I do still do research, yes. It's not my primary function within Cellbrite, but it's something that I've continued to do throughout my career.
Have you ever done any programming?
Yes, again, I'm not an official programmer with Cellbrite, but I do program as well, and I have several tools which I've written myself for the last few years, since around 2015, tools that I wrote to do the things that the vendor tools didn't do, and to offer examiners things that the vendor tools didn't offer. And I continue to maintain those tools as a learning opportunity for myself, and also because other examiners can make use of these same features.
Mr. Whiffin, have you ever testified in courts regarding forensic examination of data?
I have, yes.
And can you share a little bit about that?
I've been qualified as an expert in Canada, Australia, the UK, in total around 20 times.
I want you to take us now to the Cellbrite software. We talked a little bit about it. I don't want to go into too much detail, but can you help us explain how software works like Cellbrite software?
Yes, so fundamentally when we've got data from a device, it's a series of files, a series of databases, property lists, or all manner of different structured data. The software that we create knows where these files exist, knows how to read these files and what the data inside them means, and provides a clear view for the user to view that data. As an example, if you were to look at the SMS database on a device, all you would see is a long list of messages that don't really have an easy way to interpret or to read them. Our software takes that information, converts it into a conversational view so that as a user you can read the data, you can see who sent what message, what time it was sent. We can do decoding and decryption of various different types of security to give the user as much information as possible.
Is there other software available in addition to Cellbrite?
There's multiple vendor-supplied tools and multiple tools available that are maintained by users in the community, like myself.
Does a forensic examiner, should they rely simply on the software program, or is there more to do other than the program itself?
The software program is great at finding the data and displaying the data, but I always maintain it's the role of the examiner to actually understand what that data means and provide context and validation for what that data means, making sure that the end user of the report, whether that's the investigator, a judge or a jury, can understand what that data actually means rather than just taking it at face value from the software.
Does the software create a report that you can look at that manages or arranges some of the data that you can see?
It does. It just creates a list of all of the results that the examiner wants to include in the report.
So the software can produce a report, but the examiner goes beyond the report and looks into the data itself?
The examiner can and should go beyond what the program provides.
Let's turn now to your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellbrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
And when Richard Green reached out to your company, what specifically was the question or issue?
He reached out to the tech support team, asking basically if there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
What is a timestamp?
Essentially, it is the time which is attributed to an artifact. So it should intentionally be when something happened on that device, we would show a timestamp associated to it.
Can you tell us what an artifact is?
An artifact would be any piece of data that we pull from that device. So it could be a text message, it could be a location point, it could be a photograph.
So if I had photographs on my phone, would each photograph be considered an artifact?
It would, yes.
Would the date and time I took the photograph be considered an artifact?
I'd consider that a property of the artifact.
And if I had a phone call or a text message, those would be considered artifacts?
Yes.
When I look at my phone and I see a call log or a name, does that tell me all the information about that call?
When you look on the phone itself?
Yes.
No, there's usually a lot more information in the background of the phone that's available to the forensics examiner, which the user wouldn't necessarily see on the device.
And so when you're looking at an artifact, a phone call, a text message, whatever it may be, and you see it on a report, if you want to know more detail, where it came from, when it was developed, when it started, is that what a forensic examiner would do, to look into the data to try to identify that other information?
Yes, you can see what other information is available. You can see if there's any information that's been deleted that can be recovered. And you can validate the information that's there and make sure that the timestamps are being interpreted correctly and that they mean what you think they mean.
You told us you got a call from a consumer or a forensic examiner, Richard Green, about a timestamp. What type of timestamp? For what type of artifact was this timestamp?
It was related to an internet query.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green, had a question about it.
He did. He wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the question, the query that was made?
In response to Richard Green at that time, I didn't. I wasn't aware that Richard Green had made this request until several months later. But it was an almost identical question that had been asked by the troopers here. And that's the question that I was able to look into and to answer.
And can you share with us what was the issue? What was the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m. And an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices, recreate test data to find out exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
So after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
So to summarize, there was an inquiry about a phone that made a Google or a internet search, and the question is, what time was that search made?
Correct.
And relative to that inquiry, there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
So at some point, did you have an opportunity to forensically examine a telephone that was attributed to a person by the name of Jennifer McCabe?
I did have the opportunity to look at the data that was extracted from that device. I never saw the device itself.
And putting that aside for a second, secondly, were you asked to look at any other phone to examine data in this case aside from the phone attributed to Jennifer McCabe?
Yes, I was also sent the extraction of data from John O'Keefe's phone.
Did you look through the data and analyze some of the data in John O'Keefe's phone?
I did, yes.
So I want to walk through both your analysis of Jennifer McCabe's phone, but also of John O'Keefe's phone. So if we can first start with Ms. McCabe's phone.
Yes.
Did you actually receive her phone?
I didn't know. It was just a download of the extraction.
So how does that work?
The examiners here had done the extraction of the device, resulted in a large zip file, which is a container containing all of the files extracted from the phone. They uploaded it to Cellbrite's secure portal, where I was able to download it and verify what the data was in the extraction.
When you received the download of the extraction for Jennifer McCabe's phone, was it a similar process for John O'Keefe's phone?
With John O'Keefe's phone, I actually received the data on a USB thumb drive through the mail.
And before we begin, can you summarize briefly the issue, what you were looking for, and what the scope was as far as Jennifer McCabe's phone?
For Jennifer McCabe's phone, it was related to the internet search that occurred, or that allegedly occurred at 2:27:40.
Okay. And as part of your effort and analysis, did you put together a PowerPoint that would help educate us on how a timestamp works and what happened in this case regarding a search?
I did, yes.
And have you seen that PowerPoint recently?
I did, yes.
May I approach, Your Honor?
Yes.
Thank you.
I'm handing you a binder that should take a look in. Do you know or do you recognize what's in that binder?
Yes, this is the PowerPoint presentation I created related to Jen's phone.
And with that presentation, do you have it downloaded on your computer?
I do, yes.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
All right, thank you.
38.
You know, with the court's permission, I'd ask Mr. Whiffin to be able to use his computer to walk us through the PowerPoint and explain it to the jury.
No objection, Your Honor.
Yes, thank you, Mr. Whiffin.
Okay.
May we begin, Your Honor?
Yes.
Mr. Whiffin, if you would walk us through and explain the PowerPoint and explain this issue to the jury, what the question was and how you resolved it.
Of course. Okay. The query revolved around a database called browserstate.db. Browserstate stores information about Safari internet browser and about the tabs that the user has either had open or has open. Fundamentally, in this presentation, I wanted to include information from iOS 14 and earlier. iOS 14 is not the version of iOS that was on Jen McCabe's phone, but iOS 14 has an easier way to understand how this database works. And then I can move on to iOS 15, which was the device, or was the version installed on Jen McCabe's phone. And hopefully by that point it will be clearer how this information is being populated on the device.
Could you tell us what iOS means?
iOS is Apple's proprietary operating system available on iPhones.
Thank you.
Fundamentally, the browserstate.db tabs table is shown, hopefully I can show this on here, in the top here. The real database has many more fields, but these are the fields which are important for the demonstration to just see the row ID, the timestamp that's recorded, the URL or the web address, and the title of the page. And the example at the side there, you can see there's the browser is open, but there is no tab actually in focus at this time.
Can I take us just a little bit back so we can put this in context?
Yes.
When you are doing internet searches on your phone and you hit Safari or Google or whatever search engine you're going to use, does it create a tab?
It doesn't create a tab just by opening the application, but there may be tabs already open in the background when you start the application, and then you can tell it to create further tabs.
So if I have a phone, can I have a number of different tabs on my phone at the same time if I search for different things throughout the day?
Correct. You can have hundreds of tabs open.
Do tabs stay open forever, or can you close them?
They stay open until you close them.
So if you look at your phone and you have a number of different tabs, and say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs where a particular search was made.
Objection, Your Honor.
Sustained is to form.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
So as I showed, there's a field in this table called timestamp. It's actually called last viewed timestamp. I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
So if I have one or many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor.
I'll allow them. Is that what's looked at?
That's correct. The URL is the address of the page that's being viewed.
So if I have a tab open and I use it continuously 3, 4, 5, 10 times, will the timestamp change?
No, it will not.
And is that what you're explaining to us now?
Correct. That's part of the demonstration and presentation.
I'm sorry to interrupt.
Okay. So in this instance, at 10 a.m., which is shown in the top of the device there, we can see I visit firstpage.com as an example website. At that time, a row is created in the database that shows row ID 1 with the timestamp 10 a.m. when the page was opened. The URL and the title are relevant to the page that was visited, so firstpage.com. A minute later, excuse me, I now use the same tab to visit secondpage.com. What actually happens in the database at this point in time is the first record is updated with new information. So we continue to see row ID 1. We continue to see the timestamp that the tab was opened at 10 a.m. And we now see the URL and the title that are related to the secondpage.com website. So I've shown it here. The first one is red to show that's no longer a live record. It's been replaced by the new record that's underneath it in black. A minute later again, I can visit thirdpage.com. And at that point, the record's updated a further time. So we still see that it's row ID 1, because no new rows are being created. We're just simply updating the existing rows. So we still have row ID 1, we still have 10 a.m. as the timestamp, and we have the URL and the title that show thirdpage.com instead.
Mr. Whiffin, so in the URL column, there are 3 different searches?
Yes, this is 3 different pages that have been visited within the same tab.
And in the data, it has 3 timestamps, but they're all the same?
Correct.
Okay, thank you.
This database is not monitoring web navigation events. It's purely monitoring the tab events. So when the tab's brought into focus or when the tab's created is the only timestamp that's relevant here.
Thank you.
From a non-forensic point of view, if I was looking at this database in a regular database viewing tool, all I would see is the black record at the bottom. I wouldn't see the other 2 records because they've been essentially overwritten by the third record. If I was to use a forensic tool, though, then I would see all of these records because the forensic tool is designed to find the older versions of these records that have been replaced. So again, from a forensic point of view, I would see all of these records, I would see all the different URLs, and I would see the same timestamp and the same row ID for all of them. This fundamentally changed in iOS 15, and I've tested this on multiple versions of iOS 15, 16, 17, and 18, including iOS 15.2.1, which is the same version of iOS installed on Jen McCabe's phone. In this case, the data is not written to the database immediately. So I've tried to show here that we have some in-memory variables, so essentially a short-term memory that the device knows exist, but aren't written to the database yet, so they're not written long-term. So in this case, if at 10 a.m. I go to firstpage.com, we see that the in-memory variable for timestamp URL and title are updated to show a 10 a.m. timestamp and the firstpage.com information. But you can see at the bottom, I still have the browser state tabs table, and nothing has been written to that database at this time.
So can I ask you a question about this browser state DB? What does that mean? What does that tell us?
The browser state.db is just the name of the database that Apple are using to monitor the tab activity on the device.
Will a cell phone have a number of different databases it will send information to, or is it all one database?
There are hundreds or thousands of databases, depending what applications are installed on the device. Each database typically targets a different application or a different feature.
Can information from a URL or a Google search or a Safari search, can it leave data on different databases, or does it always go to one database?
It can leave on different databases, for sure.
Thank you.
So again, to continue this example, if I now go to secondpage.com a minute later, we can see that now the in-memory variable is updated. So the timestamp still remains 10 a.m., the same as it did previously on iOS 14, but the URL and the title are updated to reflect the current web page that's being viewed. Again, nothing has been written to the browser state database. I can go to thirdpage.com. Again, we see the in-memory variables for the URL and the title are updated, but the timestamp still remains the time that this tab was brought into focus or created, not the time that the navigational event occurred. Still, nothing's been written to the browser state database. And it's not until you actually close the tab that the information gets removed from the in-memory variables and written into the database. And at that point, the information written to the database is whatever was in the in-memory variable. So right now, all we have is a single record in the database that shows the 10 a.m. timestamp. That's when the tab was opened. And we have the thirdpage.com URL and title information, which is the most recent web page visited in that tab. It wouldn't matter whether I was looking at this data using a regular database tool or a forensic database tool. The only record that I will see is this particular record. There may be multiple versions of this record, but still would only show me this timestamp and this URL information, because this is the only information that was ever committed to the database. Okay. Moving on from that, there was multiple databases or multiple data sources on Jen McCabe's phone that could be used to see what actually happened on the device at this time of day that was of interest. So the analysis I did looked at the browser state database that we've just described, the history database, which is what is tracking the navigational events. So every time you visit a website and the website fully loads, it gets written to the history database to say this URL was visited at this time. And that's the information that, as a user, you can see. When you look at the internet history in your device, it will list all of the web pages that have been visited. com.apple-mobile-safari.plist is a property list file, so essentially a list of values and information, keys and values that would describe various settings on the device typically, but it also stores information such as the last searches that were conducted using the Safari search feature. And then finally here we've got knowledgec.db, which is a massive database at the heart of iOS that stores lots of types of information. It can tell you what web page was actually on the screen at any given time. It can tell you when the backlight came on, when the backlight went off, when the device was locked or unlocked, the battery level, lots of different types of information, but useful here for the web pages that were being viewed. So using the combination of all those sources, I could see that at 2:27:29 a.m., Safari was opened from the application library on the device. At 2:27:29 a.m., when Safari opened, there was already numerous tabs open in the background. The browser would show in the foreground whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db, that the web page that was being viewed was related to Hockenmock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time that the tab was closed, but based on other activity, this timestamp can be inferred. But essentially, when this tab was closed, a record is created in the browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time that the tab took focus, and then the Hockenmock Sports Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledgec. Around a second later, that tab gets closed, and that record gets written to the database with a time of 2:27:31, because that's the time the tab was brought back into focus. it gets written with the URL and the title information related to PayPal. At 2:27:33, another tab is brought into focus from the background. This one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time, so we know it's just brought into focus and visible on screen according to Knowledge C and browser state databases. That tab gets closed and it gets written to the database. This again is going to show, and I've just noticed there's a typo on here and the timestamp at the top is showing incorrectly. But essentially it's closed at around this time, and the Eastern Bank URL is written to the browser state database with the 2:27:33 timestamp. At 2:27:35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in Knowledge C. There's no new navigational event for it, but there's also no timestamp in the browser state database at this point. This is because this page is actually, or this tab is brought back into focus a second time, and when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially if you imagine that the in-memory timestamp here would have said 2:27:35, but then there's another tab that's brought into focus related to Hockomock Sports at 2:27:36.
Mr. Whiffin, can I ask you a couple questions?
Yes.
This timestamp 2:27:36, does that indicate the time when this tab was actually opened?
Yes. The time that the tab was brought into focus or opened.
What does it mean brought into focus?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp, and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab and they didn't put it in the background, but they used other functions or shut off the phone, and when they came back, that tab was still open, would that create a new timestamp?
As long as Safari doesn't close, then the timestamp will remain the same. So if I just minimize Safari, put it into the background and start to do other things on my phone, the timestamp won't get updated. If I completely close Safari or turn the phone off, when Safari reloads, then that tab does get a new timestamp when it opens up again.
Thank you.
Okay. So at 2:27:36, we've got Hockomock Sports, Gallery Shoots, Canton Girls, Basketball to important win at Mansfield is the page that is visible on screen. Again, we know that there's no navigational event at this time, so the page is not being loaded as a result of a bookmark or typing the URL in. It's just showing what was on screen previously, and we know that this page was previously viewed at 22:55 on the 27th of January. This tab gets closed and gets written to the database as well, and we see it's written with the timestamp 2:27:36 when the tab was brought into focus. And then we go back to the YouTube video tab. So at this point, the timestamp that had been written there gets overwritten again with 2:27:38, and it shows the YouTube video is the active page that's on the screen. At around 2:27:39, that tab gets closed and the record is written to the database showing a timestamp of 2:27:38 when the tab took focus, and the YouTube video URL. Then we move to 2:27:40, which was the time of interest, and we see that a browser switch occurs, causing the last visited timestamp to take on the time of 2:27:40. This is the tab that was ultimately used to search Hoss Long to Die in Cold, which is the query that started all of the confusion. At this point in time, there is no navigational events recorded anywhere. All we see is that the web page that was brought into view is ozonebasketball.com/teams. This web page was last visited at 14 minutes after midnight on the 26th of January. We know that this is on screen because it tells us that in Knowledge C, and we know that the time is 2:27:40 based on Knowledge C timestamps and based on the browser state database timestamp. At 2:27:42, there is a web navigation event. Whether this is loaded from a bookmark or whether it's typed in, I can't say, but a web navigation event occurs using the same tab that's just been loaded, and now the user is loading the web page hockamocksports.com/standings. This is logged in the history database that shows what web page is visited when, and it also shows in the Knowledge C database to show what web page is on screen at this time.
Mr. Whiffin, in the slide before 2:27:40, you mentioned that was the tab in question.
Yes.
Do the following pages that you show us in the PowerPoint follow that one specific tab?
Yes.
Thank you.
So at 2:27:47, there's another web navigation event as the web page hockamocksports.com/schedules is loaded. Again, this is evidenced in the history database to show that a navigation event occurred and completed, and in Knowledge C to show that this is the web page that was viewable on screen. At 2:27:53, there's a further web navigation event where we're now now loading the page hockamocksports.com/schedules/girls hockey. Again, this is evidenced in the history database and the Knowledge C database to show what page loaded and what page was visible on screen. At 2:27:58, there's a further navigation event for girls hockey Franklin 21-22. Again, this is logged as a navigational event in the history database and shown on screen according to the Knowledge C database.
So I understand these are all subsequent searches on the same open tab?
Correct.
Your Honor.
Are these
Sustained as to form.
Are these all subsequent searches on the same single open tab?
There is no tab switch event listed. We see the tab switch event occur at 2:27:40, and then we see lots of navigational events occur.
Thank you.
At 2:28:06, Safari is minimized, so it's removed from focus so that something else could be viewed, or the phone is locked.
Is remove from focus different than closing?
Correct. If you remove it from focus, it's essentially going into the background, but it's still open. It's in its current state, just in the background, versus if you close it completely and have to reload it later on. So in this particular state, the timestamp doesn't get changed. The timestamp remains 2:27:40 as it was earlier. Safari is then not used again until 6:23:37, when it's opened from the background using the icon in the app library. At this point, when it loads up, the same page that was open when Safari was minimized is shown. So we still see hockamocksports.com/schedules/girls hockey/Franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the Knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to how long to digest food. Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari if you were to do this search. If you were to type in how long to DI, you would get the result that's shown at the top of this screen with an image of somebody eating a plate of food. And this is the image that was cached onto Jen McCabe's phone at 6:23:49.
What does cache mean?
Essentially, downloaded now for use later. It will download it, it will save it in case it's required again. If it is, it doesn't need to download it, it's already there. If it's not required again, eventually it will be deleted.
So is it stored information from prior events that's available in case the device thinks you're looking for it?
Yes, so at this point in time, at 6:23:49, when it downloaded it, that's the first time that it's downloaded this image, and it stores it. If an hour later, for example, I did the same search a second time, it wouldn't need to re-download the image because it's already got it in cache. So this, the creation time of this image shows that this is the first time that this cache file was downloaded. A few seconds later, at 6:23:51, the blue button at the bottom of the keyboard is used to submit a search for the term "How long tid I in Kikdi?" CIKD. This creates a specific URL in Safari, which is shown on screen here. So google.com/search "How long tid I in Kikdi?" IE UTF-8, OE UTF-8. Client Safari is the important part of this string that tells us that it's a query that's made using Safari. This is different to if I visited Google, for example, and just typed in the search text box in Google. It wouldn't necessarily have this same structure of the URL. So we know that this is the query created by submitting a search using the search bar here and pressing the blue button at the bottom. We know that that search was conducted at 6:23:51 according to the information in mobile Safari.plist. And Knowledge C also shows that this page was visible. Importantly, there is no history record made that shows that the navigation actually occurred to this website. Several reasons why that might happen. One could be if the device was in private browsing mode. However, it can't have been in private browsing mode because if it was, we wouldn't have the search recorded in the mobile Safari plist either. So we know it wasn't in private browsing. It could have been deleted at some point after the fact. That would leave a gap in the numbering. Every time a record is written, it would be consistent numbers 1, 2, 3, 4, 5, 6. And to delete a number would leave a gap there, so you would see 1, 2, 4, 5, and that number will pretty much never be reused. So if you don't see a gap, then you can be confident that nothing was deleted, and there are no gaps on this device. The third reason, and the one that I believe is the reason why it wasn't recorded in the database, is that the page never completely loaded. If I go to a web page and cancel the navigation prior to it completing the load, it will never get written to the history database. At 6:24:18, there's a second search submitted using the same method, so still using the Safari search bar, this time searching for "host long to die in cold." This is evidenced in the mobile Safari.plist. Again, there is no record made in the history database that to me suggests that the page never successfully loaded. At 6:24:24, Safari is minimized again. It gets reopened at 10:33:33 a.m., again loaded from the app library and brought into focus. And at that point, the previous page is shown to the user. That previous page is related to the search "host long to die in cold." This is evidence in Knowledge C to show that this is the page that's visible on screen, but there is still no history event that shows that the page completely loaded. And at around that time, so around 10:33:34, that tab would have been closed, resulting in the record being written to the browser state database with the timestamp 2:27:40, when that tab was originally brought into focus several hours earlier. But it shows the most recent URL information, which is the Google search for "host long to die in the cold." It doesn't have any of the other URL information that was visited during that time period. It doesn't have the previous Google search for how long to die in the Kikti, because all it records is the most recent URL that's visited alongside the original time that the tab took focus. Importantly here, there is no title information. The title information is included within the page itself. So if you do a Google search, the title of the page that showed up would show Google search, and then it would show the query that you typed in to search for. The fact that this doesn't have a title also suggests that the page never loaded. So again, it kind of ties back to the fact that it's not written in the history database. We have no title. It's both indicative that the page never successfully loaded.
Mr. Whiffin, when a tab is ultimately closed, does the URL always have the last search, or could it show an earlier search?
It will always be whatever URL is visible in the tab at the time.
Thank you.
To overview again the data sources used here, com.apple mobile safari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows how long to die in the Kikti is at 6:23:51, and the only time it shows how long to die in the cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file. The history database, again, is known to be a good source of data for visited web pages and timestamps for the pages that completely loaded. Again, in this case, neither of these searches or neither of these URLs was in the history database, but there are no missing records, which indicates that nothing was deleted. And again, the only reason that I can come up with for why that is the case is that the page didn't load. There must be an entry within this database to allow the user to delete it. Obviously, if the page doesn't load, it doesn't get written to the history. As a user, you can't see that item in your internet history list, so you can't delete it. And then knowledge C, which shows the page that's on the screen when the browser is in use. Again, we know that this is a good timestamp, and we see the only times that web pages related to these web searches were open is at 6:23 and at 10:33. There were multiple deleted records in the browser state database. It wasn't just the record for How Long to Die in the Cold.
When you say there's multiple deleted records, can you go into a database and see what URL searches have been deleted from the actual item?
Yes, so from a forensic examiner point of view and using forensic software, I can look at the database and see the records that have been deleted and recovered. There does become a time when you're unable to recover any more records and they're now just purely deleted and unable to get back. But at this point, I was able to recover a good number of records. And these were the 5 that I thought it was important to focus on for here. You can see that 3 of them occur at 2:27. So at 2:27:36, 2:27:38, 2:27:40. And these are the web pages that we've just seen in the presentation. So Hockamock Sports, the YouTube video, How Long to Die in the Cold. And then 2 additional pages for cantonma.org and Ozone Basketball. The way that we're able to recover these records forensically is because of how databases work. What I've tried to display here is that when you first create a record, in this case creating record 4025, a new page is created in the database. A page is simply a block of binary data that's organized in a way that can be understood by the database as a page of data, much like it would be a ledger with a list of records. So it creates frame 181 with page 2752 and the record 4025. What is a little bit different from if you were doing this manually is when you want to add a new record, or when you want to delete a record, or when you want to update a record, it has to create an entirely new page, or an entirely new version of that page. So in this case, we see that frame 194 is also page 2752. It duplicates the record 4025 and adds the record 4026. From the database's point of view at this time, frame 181 is now dead, like it won't be used for anything. And a regular database tool would only refer to the most recent version of that page, so frame 194. Forensically, I can look back at all of these different versions of the page and I can start to see differences. Not so important in this case when all that's happening is that you're adding information, but when you start to delete or edit records, being able to go backwards and see these previous pages, you can see the records that have been changed or deleted. So as we're moving along all of these pages, each of these refer to a time when a new record was added. Every time a new record is added, a new frame is created, it duplicates the page from before, and it adds the new record. I've highlighted record 4028 in green across these three frames because this is the host long to die in cold record that is of interest. Moving forward again, we continue to see records being added, but particularly here at frame 430, record 4029 is deleted. 4029, if I go back a few slides, we can see 4029 is the cantonma.org families index webpage. As far as I know, no relevance to anything related to this case. It just so happens this is the first record deleted from the browser state database. We don't have information that tells us at what time the record's deleted, but we're able to infer what time that record was deleted based on other records in this frame. So for example, we know that at the time that record 4029 was deleted, record 4031 already existed. Record 4031 has a timestamp of 6:29 on the 31st of January. Therefore, we can summarize that record 4029 had to be deleted at some point after 6:29 on the 31st of January. We see again record 4030 is deleted on frame 468. Again, we can look at what record was the most recently created on that frame at the point that that record was deleted. And that gives us information that suggests record 4030 had to have been deleted at some point after 8:35 on the 31st of January. We can continue to go along and continue to see that records being added, edited, and deleted, but the record of interest, 4028, still exists, even on frame 650. And in fact, it doesn't get deleted until frame 732. By the time the record related to host long die in the cold is deleted, record 4037 already exists. Record 4037 was created after 2207 on the 31st of January. Therefore, we know that the host long to die in the cold record was deleted at some point after 10 p.m. on the 31st of January. Taking all of those deleted records, those 5 deleted records, and the earliest time that they could have possibly been deleted, we see a spread throughout the 31st of January. Like a few quite early on at 6:29 and 8:35, a couple at 9:20, 9:40, and then finally the one that we're interested in at 22:07. For the user to cause these to be deleted, if you wanted to do it selectively and delete one at a time, the record has to be available in the history database. As I said earlier, it wasn't ever in the history database because there'd be a gap. So this record could not have been deleted by the user selectively. That leaves options of deleting everything from the history, but if everything was deleted, we would have none of this information, and we do. And it also leaves the option of deleting everything from what's considered today and everything that's considered today and yesterday. And again, if either of those options were the case, we'd have much less information than what we have, and we wouldn't see this staggering of timestamps that we see here where the information was deleted. Ultimately, I wasn't able to say what caused these deletions at these particular times, but I'm confident that it wasn't as the result of user interaction. That's something that was brought on purpose.
Mr. Whiffin, I have a couple questions about your analysis and your opinions.
Yes.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe it was, yes.
Does your opinion, is it based on your analysis of reports generated by software like Cellbrite?
Objection, Your Honor.
Sustained as to form.
Was your opinion limited to analysis of reports generated by companies like Cellbrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 6:23 and 6:24 occurred at that time as opposed to 2:27:40, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history database. The fact that it wasn't in the history database it strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those attempted searches at 6:23, 6:24, you mentioned that information at some point was deleted from the phone?
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want to take you back to your first opinion, where you opine that the how's long to die in the search occurred at 6:23 and 6:24, not at 2:27:40.
Yes.
And so, in looking at the data, coming to that opinion, what caused the confusion with the software where it could be misunderstood the time those searches were actually made?
Objection, Your Honor.
I'm going to allow it.
The way that forensic software typically works, certainly the way that Physical Analyzer works, is we design models for the data. So we know that an SMS application, for example, will always have a message body. It will always have a sender, a receiver, a time, that kind of thing. We always know that a web visit will have a URL, a title, and a visited timestamp. In this particular case, in the database, the timestamp is called last visited timestamp, which is indicative, you would think, of the time that the web page was visited. So when that information was being modeled within the software, the timestamp that was within the database was used, and it was called last visited timestamp. Since the investigation that I did into this case, I requested that the forensic research team at Cellbrite revisit this data and confirm if there's confusion around it. Were my findings correct ultimately? There are times that that information can be correct. If, for example, you create a brand new tab, visit a website, and then close the tab immediately, then that timestamp would be indicative of the time that the URL was visited. But if you were to create a tab, use it for 3 hours, and then close it, the timestamp would not be indicative. Also, if you were to bring an old tab into focus that you'd used several days earlier and then close that tab, again, you're going to get bad timestamp information. So ultimately, from Cellbrite's point of view, we removed the timestamp from that data to avoid confusion in the future.
You shared with us that the URL for the 623 and 624 attempted searches ultimately was removed from the device.
Yes.
Would it be fair or accurate to say there were over 4,000 deleted files from the phone, or there was 4,000 deletions from the phone?
There were many.
Sustained.
Okay.
As to form.
Would it be accurate to say that the only deletion from that phone was that 623, 624 search?
No, there were thousands of records deleted, ultimately, for various reasons that I can follow.
That would be an inaccurate assertion?
To say that that's the only record that was deleted is inaccurate, yes.
Okay. Thank you. I'm now going to turn to a second phone that you looked at.
Okay.
You told us that you looked at two phones. The second one was a phone that was, or is attributed to John O'Keefe?
Correct.
When you looked at the phone for John O'Keefe, were you looking at things different than we looked at on the phone attributed to Jen McCabe?
I wasn't as interested in internet data. I was more interested in location and health and anything else that could be useful.
Before we show any presentation, I want to get a little understanding of what you looked for and what you found. Were you looking for what's called location data?
I was, yes.
Was there a period of time that was important that you were looking for relative to location data?
Typically after midnight and before 6 a.m.
Is that on January 29, 2022?
It is, yes, sorry.
How does a phone, like an iPhone, store location data?
Multiple ways that it can be stored. Primarily, there's a database called cache.sqlite. And every time an application requests location data from the device, a feature called Location Services on iOS tries to calculate the device's location using a combination of technologies, GPS, Wi-Fi, cell tower, and Bluetooth. Calculates the device's location and stores that into the database as a latitude, longitude, altitude, timestamp, accuracy radius, information like that.
Are there different types of location data that are captured and stored on a device like an iPhone?
Can you define different types, please?
I'm sorry?
If you could define what you mean by different types.
The different sources of data that are generated that then captured on an iPhone.
Yes, so the application can specify how accurate it wants the data to be. So for example, if you're using a navigational application, you'd want high accuracy data. So the application would request high accuracy data from location services. Location services would then try to use GPS primarily to get location information. Versus if you were using a weather app, for example, where you don't really need to know precise information, you just need to know the approximate town maybe that the user's at. So a weather application would ask for low accuracy information, and the device may be able to calculate the location based on cell tower information, for example. Both can be stored in the database with the accuracy information that's available.
Would a application that is devoted to navigation in your programming experience typically have stronger data, location data information than a more general application like a weather app?
Yes, for sure. And Apple actually specify in their documentation, when they specify the various different accuracy levels, they have one for navigational purposes for map applications.
How do you define accuracy level from the different data that's being stored in the phone?
How do you mean, sorry?
Is there high level, middle, low?
Yes, the information is typically provided with a range of meters. So you'll have a latitude, longitude coordinate and a number of meters that you have to draw around that locational point. And the device is somewhere within that circle. It could be as accurate as 2 or 5 meters. It could be as inaccurate as several miles, depending on the technology that was used to get the data.
Are you familiar with an application called Waze?
I am, yes.
Tell us what Waze is.
Waze is a navigational tool, so you can plot a route and it will try to direct you the best way, avoiding toll roads, avoiding accidents, that kind of thing.
What is the level of accuracy in location information that is generated by using Waze?
That would be the highest level of accuracy. So it would aim to get GPS quality information of around 5 meter accurate.
So why doesn't a programmer in every application just use the highest level location data for every application?
Getting GPS data is not always possible. If you're in a building, in a basement, for example, you may not get that. But also, it can be expensive to the device in terms of processing power, in terms of battery requirements. So if it can find location information cheaper by using the Wi-Fi networks, for example, then it would prefer to do that. So just a lot less resource intensive than using GPS all the time.
In order to capture the highest level of location data, the most accurate in an application such as Waze, if somebody's using Waze and then turns it off, does it still continue to capture that highest level of accuracy?
Typically not. It may do for a short time, as it's still kind of working through a backlog. But fundamentally, if there's no application open that's trying to use location services, then the location information that's being requested and recorded is far more sporadic. It's typically background applications that may be requiring location data.
When you analyze John O'Keefe's phone, in addition to the location data, did you also look into data known as health care data?
Yes.
And could you tell the jury how that works?
Yeah, so pretty much all iPhones for the last 10 years or so have Apple Health included. It monitors activity on the device, such as steps taken using various sensors inside the device, looking for motion which appears to be walking. It monitors altitude, so it knows whether you've gone up a flight of stairs, for example. It uses that information in concert with the steps taken, so it knows the difference between going in an elevator versus walking up a flight of stairs. And all that kind of information is available to you as a user to essentially see how far you walked each day and to monitor your own health.
When you look at healthcare data, you said it interprets it in different terms. One you used was steps. If I have an iPhone and I'm walking and it registers steps, can it tell what direction I went in?
No, it's purely just looking for motion of the gyroscopes, which appears to match the pattern that it expects of somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
What if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some, but typically it's relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it store with date and time?
So there's two locations that health data is stored. Primarily a database called healthdb_secure. And that aggregates the information into periods of time. So you may have a 10-minute period where it says 100 steps were taken. Now, it could be that the 100 steps were taken in the first 2 minutes, and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is more granular. It's where the information is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, we're talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
So I did test this a few months ago, driving in my vehicle. I was able to, if I just put a phone on my dock as I'm driving around, nothing was recorded. But I found that if I was actually holding the phone while driving at the same time, then the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if that motion happened while I was driving up a hill, it would also result in a flight climb event. And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill multiple times.
In your studies, what elevation change would have to be present if you were in a car with a phone and it would register healthcare data as steps? Is there a certain level of elevation that would trigger that?
Again, it's just a 3 meter incline is required.
Did you say 3 meter?
3 meter.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Sorry, can you just repeat that, please? I'm
Sure.
just trying to think.
The healthcare data you shared tells us there's movement.
Yes.
And it may come in the term steps. You also shared that the healthcare data can show elevation. That can come in the term flights.
Yes.
Is there any other information about the healthcare data you looked at? Did you look at it across a wide range in this case?
No, it was just the steps and the flight climb that I was interested in.
What is the time period you looked at the healthcare data for in this case?
Between midnight and 6 a.m. or 6:30 a.m.
That's midnight on January 29,
29th.
2022 till about 6 a.m.?
Yes.
And before we get to any presentations, did you see movement on that phone relative to healthcare data at different points through the night?
I did, yes.
And did you identify those different times in your report?
I did.
You created a PowerPoint for Mr. O'Keefe's phone. Are those time points and movements, are they indicated in the PowerPoint as well?
They are, yes.
So you had, with Mr. O'Keefe's phone, you looked at location data, you looked at healthcare data. Is there any other data you found important in your analysis to try to track the movements or non-movements of the phone of John O'Keefe on January 29, 2022?
Yes, I've also looked at battery temperature information and at a feature called Doppler, which is monitoring for Face ID.
Tell us a little bit about the battery temperature. Is it the battery temperature of the phone or part of the phone?
There's a battery temperature sensor built inside the phone within the battery, and it's essentially always checking for battery overheats or battery cool downs to the point where performance will be affected and the device needs to power off to save itself being damaged. So that temperature information isn't recording ambient temperature. It's not interested in the temperature in the room, for example. It's purely interested in the battery temperature. But it is affected by ambient temperature. And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time, to monitor how the battery temperature would decrease over time, given the environment it was in, bringing it back into a warm environment and testing how long it takes to increase, putting the device outside. I live in Calgary, where it's pretty cold in winter, so putting it outside, it was like 40 Fahrenheit, I think it calculates to. The temperature of the environment had a big impact on the battery temperature that was recorded by the device.
Were you able to track the changes in battery temperature for Mr. O'Keefe's cell phone over the course of the evening from after 12 on January 29, 2022 through after 7, 8 in the morning?
Yes, there wasn't a massive number of records, but there were records that I've included in my report.
In addition to those three areas, when a person uses an iPhone and presses the buttons, or they hold it and they try to open it by recognizing their face, what is that process called?
The Face ID would be the process for the unlocking, and then the locking, pressing the button on the side would lock the device.
When an iPhone is being used, does it act or operate differently when it's out in the open, or if it's in your pocket or under something?
Yes, so this is the Doppler function that I found within a feature called Unified Logs. Essentially, whenever the device receives a phone call, or when you pick up the device, an iPhone X or above is trying to find a face to use to unlock the device. If the camera is blocked, a record is made to say that it's within a pocket state. So if my phone's in my pocket, when somebody calls me, it tries to look for a face, it immediately recognizes that the camera's blocked, and it records pocket state. As soon as I take the phone out of my pocket or unblock the camera, it records a pocket state cleared event. So we know when the camera was covered up versus when it was uncovered, if at the time it was receiving a phone call or was being picked up.
Does an iPhone always record whether or not the camera was blocked or hidden or covered at the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared. And if the device isn't blocked at all, so if I have the device on a desk in front of me, for example, and a call comes in, there'll be no record that says that it's in a pocket state or a pocket state cleared. It will only record a pocket state event if the camera's blocked, and it will only record a pocket state cleared event if the camera was blocked and now isn't.
So if I have my iPhone and I put it inside my jacket in the darkness and I get 30 calls, would all of those calls result in a reading of pocket state?
They'd all result in multiple readings of pocket state. The pocket state check is conducted more than once a second. I can't remember the exact number, but it's very frequent. And an average phone call from the start of the ring to when the device essentially hangs up, somewhere in the region of 500 checks. So if you had 10 phone calls, then you'll have 5,000 checks made that would all report pocket state.
Did you analyze John O'Keefe's phone on the evening, early morning hours through the next morning on January 29, 2022, in an attempt to identify where he was, what he was doing, and whether his phone was inside or outside?
That was my goal, yes.
And did you engage in that analysis, sir?
I did.
And in your efforts, did you write a report?
I did.
Did you write multiple reports on these separate issues?
I did.
And those reports are provided to everybody?
Yes.
In addition to the reports that you generated from your study, did you present or did you prepare a PowerPoint?
I did.
Does the PowerPoint outline some of those points?
It does.
At the end of the PowerPoint, do you go through a timeline accumulating many of these pieces of evidence together that show them in a chronological sequence?
I do.
And does that help capture the movement or non-movement of John O'Keefe's phone through that night?
I believe it does.
All right, may I approach?
Yes.
I'm showing you a binder, sir. Could you look at it? Let me know if you recognize it.
Yes, this is the presentation that I created regarding John's phone.
And does it include some of the subject areas we just spoke about?
It does.
I'd move to introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
39.
Thank you. With the court's permission, Mr. Whiffin, referring to Exhibit 39, I'd like you to walk us through John O'Keefe's phone on the evening of January 29th,
Okay.
2022.
Yes.
Thank you. So I start the presentation with location data. As I mentioned earlier, this comes from the cache.sqlite database, which is considered the most reliable location, or the most reliable file for location data on an iOS device. Stores information whenever location information is requested. That could be through user interaction with the device using something like Waze. It could be background activity, just depending on what applications the user has open, what settings the user has chosen. It's constantly trying to find its location and recording it in this database, partly for the purposes of identifying frequent locations. At 12 minutes and 5 seconds after midnight, the device shows multiple location points at Washington Street around Forge Pond. What I've tried to show here, there's a kind of a gold dot in the middle, which would show the actual latitude, longitude information. And then the circle around it is what's considered the accuracy radius. The smaller the accuracy radius, obviously the more accurate the information is believed to be according to the device. But ultimately, if the device is anywhere within that circle, then iOS would consider it correct. It considers it an accurate record.
Mr. Whiffin, why are there multiple circles of location data for one point where Mr. O'Keefe's cell phone was?
So this wasn't a single point in time. This was multiple records at around 12 minutes and 5 seconds. No application was actually in use at this time requesting location information, but the device, for whatever reason, recorded multiple records with various degrees of accuracy. Typically, you would see accuracy start quite low and get better over time, which you may have seen on your own device when you open up the map application, and it may show your device close to where you are, but not perfectly where you are, and then wait a few seconds, and that information gets refined. Essentially, this is the same thing.
So low accuracy would be a wider circle, and higher accuracy would be a smaller circle?
Correct.
At this point, Mr. O'Keefe is not utilizing Waze on his phone?
Correct.
But location data is still being stored randomly on the phone from multiple different sources?
It is, yeah. Depends on the device itself.
In the top left-hand corner, it says 12:05. That's the time that this snapshot?
Yes.
Okay. And
in this
below
case, approximate.
And below it's obviously the date?
Yes.
Okay, could you take us ahead, please?
Okay. There were multiple records between that last time and what's shown on screen now at 19 minutes and 33 seconds. But all of the records were sporadic and low accuracy with values of 1,000 meters or more. But around this time, around 19 minutes and 33 seconds after midnight, is when Waze was actually brought on screen. Waze starts to ask for high accuracy data, so we see the accuracy immediately start to improve. So again, we see relatively low accuracy data to begin, and then over the next few seconds it begins to refine itself until it gets down to a 5-meter accuracy records as the device continues up here. We'll highlight that there's a cluster of records here as the device came to either a slow or a stop. Momentarily, multiple records were created, and then the device continued driving up Denham Street.
Mr. Whiffin, below the time, 12/19/33, in the date, talks about the average accuracy.
Yes.
And that's in meters?
That's in meters. So again, the records that are shown at the bottom here are around 55 meters. The records shown at the top are around 5 meters.
Is it typical in Waze that once it locks in the range is around 5 meters?
Typically, yes. That would be the goal.
You also mentioned the average speed. Where do you learn the speed from? Where does that data come from?
The database, the Cache SQLite database also calculates the average speed between two data points, and also the bearing, or the direction of travel between those 2 points. So the average speed that's shown here on the left is approximately the average of all of the records that are shown on this map at the time. And each of these map points has a directional arrow that points in the direction that the database recorded the device was traveling in.
When you look at this information generated because of the usage of Waze, and you can see both the accuracy and the speed, with the Waze information at its most accurate, can you actually tell whether the vehicle is moving or whether it stops?
Yes, based on the speed and the location and the timestamps, you can determine whether the device is moving or stopped.
Okay, thank you.
Also important to, I think, point out here, in terms of knowing how reliable this location information is, I typically look at something along the lines of, does the location think it's accurate? In this case, 5 meters, so yes. Does it make sense? Like, it's on the road, it's on the correct side of the road. So again, it kind of makes sense. It fits the pattern of the road. The cadence and the speed are, what you would expect for this road. Like traveling at 20 to 30 miles an hour up here seems quite reasonable. So all of these factors taken together increase my confidence that this would be reliable location data. Moving to the next slide, between 20 minutes and 19 seconds and 21 minutes and 58 seconds after midnight, the device starts on the right side at Dedham Street, drives up and turns left onto Maplecroft Road. Again, we see that all of these location points match the pattern of the road layout. They all have a consistent cadence, a consistent speed, traveling at between 10 and 20 miles an hour. And we see a cluster of records here, which is around a stop sign. So again, it indicates how reliable the data is, because the location, the location data that's recorded recognize the vehicle slow, come to a stop, and then continue after the stop sign.
Is Maplecroft Road in Canton?
Yes. At the end of Maplecroft Road, the device turned left onto Oakdale Road and continued heading down there. Between the hours of 21 minutes and 59 seconds and 22 minutes and 53 seconds, the device continues down Oakdale Road. Again, all of these location points show with 5 meter accuracy. They show consistent cadence, consistent pattern to the road. And again, we see a cluster where we see the device come to a slow or a stop for a stop sign. The device ultimately turns right onto Cedar Crest Avenue, I believe, and continue down there between 22 minutes and 54 seconds and 23 minutes and 57 seconds. Again, as I've said before, all of these points, 5 meter accurate, they all conform to the road. The cadence is good, and again, we see a cluster on approach to a stop sign. The device shows that it overshot Fairview Road and continued turning up Cedar Crest, but came to a stop somewhere between 50 and 51. And at 23 minutes and 58 seconds, the device appears to have turned around, so potentially a 3-point turn, in order to head back down Cedar Crest Road and turn right onto Fairview Road. Again, accuracy 5 meters, good cadence, good conformity to the road. All appears to be reliable and make sense, traveling at an average of 20 miles an hour.
And that road coming down at the bottom of the screen where John O'Keefe's phone travels, that's Fairview Road?
This is Fairview Road here, yes. The next few slides replay that same data, but instead of showing multiple points on one graph or on one map, it's going to show one location point per slide. So at 24 minutes and 20 seconds, we see the device is already on Fairview Road. Accuracy of 5 meters, traveling at 14.8 meters and heading south. 24 minutes and 21 seconds is now at 16.2 meters, but it's still highly accurate information. 24 minutes and 22 seconds, traveling at 18.3 miles an hour. 24 minutes and 23 seconds, traveling at 16.9. 24 minutes and 24 seconds after midnight, traveling at 16.9. 24 minutes and 25 seconds, traveling at 16.6. 24 minutes and 26 seconds, traveling at 17. 24 minutes 27 seconds, traveling at 15.9 miles an hour. 24 minutes and 28 seconds, traveling at 14.5 miles an hour, at which point it's approximately outside number 34, around the driveway area. 24 minutes and 29 seconds, traveling at 12.1 miles an hour. 24 minutes and 30 seconds, traveling at 11.5. 24 minutes and 31 seconds, traveling at 10.4. 24 minutes and 32 seconds, traveling at 8.9. 24 minutes and 33 seconds, traveling at 7. 24 minutes, 34 seconds, traveling at 5.2. And 24 minutes and 35 seconds, traveling at 3.5. 24 minutes and 36 seconds, traveling at 3.2 miles an hour. And at 24 minutes and 37 seconds, traveling at 1.4 miles an hour. Finally, the device comes to a complete stop at 24 minutes and 38 seconds. I'll say from the testing that I've done related to the speed, it may not be 100% accurate, but it's a very good indicator of the speed in general. So if it says it was traveling at 10 miles an hour, it would have been traveling at somewhere between 9.5 and 10.5 on average.
Mr. Whiffin, you just showed us the travel of Mr. O'Keefe's cell phone around 12:24 to 12:24:38 on January 29, 2022, and you said at 12:24:38 it came to a complete stop.
Yes.
Before that complete stop, was the car continuously moving at some speed?
Yes, this is the first record that shows 0 miles per hour or 0 meters per second. Prior to this, there was always a record that showed some level of speed.
If you look at number 34 on that chalk, if you can highlight it, please. Okay. If the driveway were at the right side, the top side of the house.
Yes.
Does your studies indicate that the vehicle, or at least the phone, traveled past the driveway before it stopped?
Objection, Your Honor.
Ask it non-leading, please.
Did this car, or the phone that was in the car, ever stop at the driveway of that address?
No, according to the location and the speed data from the device, by the time it was approximately the driveway, the phone reports it was still traveling at around 15.9 miles an hour.
Have you ever seen a photograph of that address?
I have.
You have or have not?
I have.
You have. And in that address, do you see on the far left corner of that address, the yard, there's a flagpole?
Yes.
Where this car stops, or this phone stops at 12:24:33, how close is the phone to that flagpole?
I believe very close.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
Please continue.
Between 24 minutes and 39 seconds and 25 minutes and 8 seconds, there were a cluster of more records, all showing 5-meter accuracy, but no movement. Although the center point does move around a little bit, you could interpret this as movement, but because all of the radiuses or radii overlap, there's also a good chance that there's no movement that actually occurred here. This is just the device as it's trying to refine its location. At 25 minutes and 30 seconds, we see a relatively significant change where the accuracy drops to 34 meters. We do see a course or a bearing that shows that the device reported it was heading west. But again, this accuracy radius includes the previous locations anyway. So it's difficult to differentiate between actual movement based on this location data or just on the fact that the accuracy reduced, the center point shifted because of that accuracy change, and therefore a bearing was attributed to it when it shouldn't have been.
If I could ask you some questions about the clock on that indicates 25 minutes, 30 seconds, so 12, 25, 30. The circles become larger.
Correct.
Is Waze still being used, or has Waze been stopped?
No, Waze has been closed at this point for about 40 or 50 seconds.
For how long, sir?
About 40 or 50 seconds.
Okay. This location data, or this circle, the perimeter, that's not coming from the Waze application anymore?
No, the location data never came from the Waze application. Waze was requesting location data. iOS is responding to that request, and as part of that response would write the information to its database. Waze itself records very little location data.
So when you look at that circle based on location data alone, could the phone be anywhere within that circle?
Correct.
There is a bullet pinpoint center of that circle?
Yes.
That center of the circle doesn't necessarily mean that the phone is at that exact location, does it?
It doesn't, no. The center point is purely an indication of where you need to draw the center in order to draw the radius. If we didn't have a center point, how would you know where to draw this circle?
And so the phone could be anywhere in that circle, close to 34, inside 34, 32?
Objection, Your Honor.
Ask it non-leading, please.
Could the phone be anywhere in that circle?
It could.
Could it be at the center point?
It could.
Could it be still in the car?
It could.
Continue, please.
Between 25 minutes and 31 seconds and 25 minutes and 36 seconds, there's an additional cluster of location data, ranging between 61 meter accuracy and 17 meter accuracy. All of them roughly centered on the same point, approximately, and all of the accuracy radius covers the same area. Like, there's so much overlap in these records that the device is essentially anywhere within the smaller circle. Between 27 minutes and 35 seconds and 38 minutes and 15 seconds, there was approximately 50 low accuracy records. Again, the device wasn't being used to ask for location data. This is completely passive and resulting in some pretty poor location data. I've highlighted with the red arrow where the 34 Fairview Road is. And we can see, although a lot of these location data do overlap with that point, there are location information here that doesn't. At 38 minutes and 16 seconds, the accuracy improves again. Is now 18 meters accurate, but continues to show approximately the same location that we saw 10 or 15 minutes earlier, around the flagpole area. 38 minutes and 17 seconds, same general area, slightly higher accuracy information down to 14 meters. 38 minutes and 18 seconds, accuracy increased to 12 meters, shifted slightly. Now the flagpole area is essentially at the lower side of this circle. Obviously the top side of the circle now includes a part of 34 Fairview.
If the location information is indicated by the circle and the circle has shifted, does that mean necessarily the phone has moved?
Not necessarily. Typically, you could assume it has, but when we're already talking about accuracies of 12, 13, 14 meters, it starts to become a little bit harder to determine how accurate this data is. So at this point in time, it could be anywhere within this circle, and the movement of the center point could just be the result of refinement of the device or environmental conditions that suddenly change. If the weather changes, it could cause the device to slightly miscalculate or to calculate differently.
Would a snowstorm or a blizzard potentially impact the precision of location information that's not precise like Waze?
It definitely has the potential to, yes.
How about a phone being covered? Could that affect it?
That could also affect it, yes.
If somebody was lying on a phone, could that affect it?
That could affect it.
Could being in a building affect it?
It could.
Thank you.
We've done that one at 38 minutes and 20 seconds. Again, refining information more. We've got an 8-meter accurate radius, still focusing primarily on the front yard towards the left side. And then accuracy of 7 meters at 38 minutes and 21 seconds, again showing that same general area. Between 40 minutes and 22 seconds and 59 minutes and 29 seconds, accuracy fairly drops off again, and we see some fairly wild records that don't cover the area at all. But we also see some more accurate records showing, again, where the red arrow points at Fairview Road. Those records are highlighted here, just between 40 minutes and 22 seconds and 59 minutes 29 seconds, only showing records of 25-meter accuracy or better. And again, it's kind of focusing on that flagpole area. Between 1 a.m. and 2 a.m., only looking at location information which is 25 meters accurate or better. Again, it kind of focuses around the front yard area, although some of these accuracies are still rather large and could put the device inside 34 on the opposite side of the street, towards 32. Between 2 a.m. and 3 a.m., fairly similar story. Again, most of these points are centered around that same location at the front yard. Similarly, between 3 and 4 a.m., between 4 and 5, between 5 and 6. And in fact, if I take all of the location data between 25 minutes after midnight until 6 a.m., only looking at the records that report 10-meter accuracy or better, then typically they all focus around that same location at the front of the yard, nearish to where the flagpole can be found.
I'd like to ask you some questions about this photograph. There's a red circle with a bunch of red dots in the middle?
Yes.
Would those red dots indicate the center of some location that was captured at a particular point over that night?
Yes. So each of those center dots is the center of a 10-meter accurate or better location record. I chose to not show the accuracy radius circle on this image, just purely because it makes it hard to see when you've got all these intersecting lines. But ultimately, if you were to draw a 10-meter radius around all of these points, they would all fall within the large red circle that's shown.
So this photograph was meant to take readings from the most accurate of the data throughout the night?
Correct.
Objection, Your Honor.
Sustained. Ask it again differently, please.
Was this circle, did it include low frequency data?
No, this circle only includes 10-meter accuracy or better.
The fact that the center dots are in different spots, is that inconsistent with a phone being in the same place, not moving that entire night?
It could indicate movement, it could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail anyway.
Are all of these dots, given the range, 10 meters or under, are all these dots and all these readings of the high frequency data that you compiled for that night, are they all consistent with Mr. O'Keefe's phone being near the flagpole and not moving that night?
Objection, Your Honor.
I'm going to move on.
I think that's a reasonable assumption.
All right, this might be a good spot. Are you ready to move on to the next area, or you have any more questions about
Now would
this?
be a fine time, Your Honor.
All right. Folks, why don't we take our morning break, 15, 20 minutes. We'll see you back there in about 15.
Thank you.
Oh, my word, folks. There you go. You heard it in real time. John O'Keefe never moved from the lawn. It has been confirmed from John's own cell phone data again and again and again. My name is GrantSmithEllis. I'm a towel. We are now on morning recess. We're less than an hour away from the Arca hearing. Folks, could be one of the biggest days so far. It is the biggest day so far of the Karen Read retrial. And I, a little towel, am here with you. Now, allow me to quickly pop up on your screen so I can close out this clip, because we must let the world know. We must let the world know, towel friends. It must ring out loud. It must be hearkened from the hills. The towels must wave loud as a blue wall, and they must say, John O'Keefe never moved from the front lawn of Fairview Road. John O'Keefe never went inside the house, and the cell phone data confirms it. Praise be, truly, praise be to Jesus. Not in an inauthentic way. Towel feels that this was quite a moment. Folks, tune in live. Watch the upcoming hearing. It's going to start in less than 50 minutes with Arca. YouTube.com/GrantSmithEllis. I'll be here with the towel friends. We're on recess until about 11:25 a.m. Eastern. Come join us. You get to see your comments on the screen. Truly, Diana Natale is right. John O'Keefe's last moments, heartbreaking. But the whole issue has been Karen trying to obfuscate Karen Read, her own responsibility in those moments. After Karen and John sat outside Fairview Road between 12:24 and 12:31 a.m. And then as 12:31 turned to 12:32 in the dark, as the snow began to fall on that cold January morning, Karen Read, according to data we'll see further in the trial, backed her Lexus up with 75% acceleration to 24.2 miles an hour, reducing to 23.7 miles an hour in a millisecond, with a 4.7 degree correction of her steering wheel to the right upon allegedly striking John O'Keefe. It is a heartbreaking series of events, folks. And then John's own phone data shows he never moved again. Never moved again from that spot on the lawn, as he lay dying with a traumatic brain injury after being allegedly struck by Karen's car while Karen was drunk driving with a BAC between 0.13 and 0.29. Incapacitated, eventually covered by a blanket of snow, which induced hypothermia, according to the medical evidence showing reddening of John's pancreas, and led to John's death. That is the story of Karen Read, John O'Keefe, and the chaos that consumed Canton, Massachusetts, a small town, completely taken over by Karen's inability, in my opinion, to accept responsibility for her actions in those horrific moments, taking from the world John O'Keefe, a noble, humble, honorable man dedicating to serving his profession and his community and his family, who stood up and adopted his double orphan niece and nephew when their dear mother, Kristen, John's sister, passed away from a medical condition, and then their father, Steve, just a few months later, also passed away. 7 years ago, John stepped up and adopted them, because John was a good man who suffered an ending of his life worthy of no human being, in particular, someone who lived in the service of others and was truly loved by those around him. My name is GrantSmithEllis, folks. We will be back in just 20 minutes. Tune in, join us, chat with the Towel friends as Towel tries to keep himself composed. YouTube.com/GrantSmithEllis. That was a tough one, Towel friends. I'm still here with you. I had to make that clip. That was a tough one to say. It's hard. It's hard to think about those last moments. I think it would be hard for anyone to think about John's last moments. All right, let's type it up, Towel friends. Together, we can do this together. We can do this. All right, let me type this up. Just in. It has now been confirmed via John O'Keefe's own phone data that John never left the front lawn of Fairview Road after he was allegedly struck by a drunk driving Karen Reed at 12:32 a.m. on 1/29/2022. John never went in the home, and the data confirms it. Oh my word. Oh my word, towel friends. Oh my word. Oh my word. What a series of events. We, the towel friends, we sat, we watched, history unfolded, and the day is not even half over. The Arca hearing has not even started. Towel friends, you were here for it. You will continue to be here for it. I'm a towel. You're a towel. We're all towels. Follow along live with the towel friends and special Karen Cam coverage at the following link. All right, towel friends, that was a moment. Let me take a look at what some of you have to say. You must all have a lot to say. Jimbo says, Grant is an amazing orator. Grant does sometimes just forget what he's actually looking at because I'm just typing things, and I'm just kind of speaking and saying things, and I'm like, I hope this makes sense. Sunken Grave says they went to the liquor store and got them some wine to enjoy the voir dire. How poetically appropriate. I feel like the investigation was good. Brutally honest, I just don't think anyone could have anticipated Karen to pull out the Chewbacca defense. Listen, no one sees the Chewbacca defense coming. When you bring in Alan Jackson, and Alan Jackson pulls out the Chewbacca defense, listen, folks. No investigation, no prosecution, no one can forget about the Chewbacca defense. Do you understand Alan Jackson rolled out the Stay Puffed Marshmallow Man defense for this case? That's how serious this was. He pulled out the Stay Puffed Marshmallow Man defense. Nobody just goes to the Stay Puffed Marshmallow Man defense. That is like a tactic you pull out only if you are really, really, really desperate. And yes, Alan Jackson might be the kind of man who can deploy the Stay Puffed Marshmallow Man defense. And if you're wondering, these are very, very nuanced, arcane legal precedents, obviously. The Stay Puft Marshmallow Man defense, my word, astute legal constitutional scholars could spend decades and never come across the Chewbacca or the Stay Puft Marshmallow Man defense. Now, I think if we're looking at the Stay Puft Marshmallow Man defense as kind of an analogy to the way the Bowden defense functions versus a third-party culprit defense. When you roll out the Stay Puft Marshmallow Man defense, oh my word, friends, there is just no way on earth that you're coming back from that. And I will show you the clip. If you think I'm kidding you, I am not. Alan Jackson actually brought up the Stay Puft Marshmallow Man. Yes, now listen, the one good thing about the Stay Puft Marshmallow Man coming up now as the new third-party culprit for the Karen Reed team, that somewhat absolves Chewbacca. Now listen, I have a theory that it wasn't actually Chewbacca who Karen Reed was trying to blame. Listen, I know this is going to sound outlandish, but I've thought a lot about it. Karen's real plan was to say even that Chewbacca third-party culprit she had come up with wasn't actually Chewbacca. It was Aidan Kearney in a wig. You see where I'm going with this? So listen. I know this is the type of erudite and refined legal commentary as a lay towel, because I'm not a lawyer, and none of this is legal advice. I'm a towel. You should get a lawyer if you have questions about the law. You should get a towel if you're trying to prove that unconditional love exists in a world that seems to be resistant to that very concept. But I know this is the kind of erudite thing that commentary you come to the stream for. The very subtle difference between the Stay Puft Marshmallow Man defense and the Chewbacca defense. But I assure you, I did not bring up the Stay Puft Marshmallow Man. It was not Towel. It was Alan Jackson. He brought up the Stay Puft Marshmallow Man defense. Now, you all may be saying, Grant, are you the type of person who would seriously bring up the Chewbacca and the Stay Puft Marshmallow Man in the context of a criminal trial? And let me just tell you, it was not me. You can stand there and you can assert that Towel introduced the Stay Puft Marshmallow Man as a defense for the Karen Reed team all you want. But I have proof that it was not me. I have proof that it was Alan Jackson who introduced the Stay Puft Marshmallow Man defense. The truth never changes. I agree. All of you who are siding with Towel in this very important discussion about the Stay Puft Marshmallow Man, just know that your hearts are in the right place. All right, now let me bring this up on the screen for you all. And if you're wondering, oh my dear God, is he actually going to bring up the Stay Puft Marshmallow Man? Listen. We all need to have a conversation about this because I did not bring up the Stay Puft Marshmallow Man. All right, you can sit there, you can argue all you want that I am responsible for the Stay Puft Marshmallow Man being part of the Karen Reed and John O'Keefe retrial, but I will sit there and I will tell you, no, I am not responsible for the Stay Puft Marshmallow Man becoming part of the John O'Keefe and Karen Reed retrial. That is something that must be correctly placed at the feet of Alan, the Marshmallow Man Jackson. Now, I want to close this loop as we wait for the trial to come back in session by proving my point. Ladies and gentlemen, I have to ask you a question. Does that look like the Stay Puft Marshmallow Man? Yes, it does. And if you're wondering, Grant, did Alan Jackson actually invoke the Stay Puft Marshmallow Man? My God, yes, he did. We will liberate the Stay Puft Marshmallow Man. He did nothing wrong. We must defend his honor. He is nothing but just a ball of marshmallow. I took it as far as I could. I'm sorry. He's nothing but a ball of marshmallows. Now, ladies and gentlemen, you must listen. I assure you it was not.
Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes.
Okay, I have proven my point. I did not invoke the Stay Puft Marshmallow Man. It was Alan Jackson. Now, ladies and gentlemen, we are going to be coming back into the Karen Reed trial session soon here in a moment. And I just want to be clear that just because I am intent on explaining the relevance of the Stay Puft Marshmallow Man, that does not mean that that is in any way relevant to this case. In fact, I don't think Chewbacca is relevant to this case at all either. I think Karen Reed's whole invocation of the Chewbacca defense was an attempt to just confuse the jury. You can't just get up there and say, members of the jury, if Chewbacca lives on a planet with a bunch of 2-foot-tall Ewoks, then this case demands you vote not guilty. That is not a legal strategy. And I tell you, folks, no matter how much analysis I do of this, I will never get over the fact that Chewbacca is not a reasonable third-party culprit, okay? Alan Jackson, I will never get over that. Now, let's take a look at something else that happened, which I think is very important, and that is, of course, towelettes being mentioned in the trial. These are the very, very important pieces of commentary you come here for during the recesses in the Karen Reed trial. So let's take a look at towelettes getting their honorary mention. Where are you, dear towelettes? I shall find your moment of vindication. The moment that truly, truly brought smiles to the faces of all the towelettes around the world. They came together in celebration. Here it is. Nope, that was not it. Where's the towelette moment? Towelettes? Nope. Nope. Tesseracts? That was a good quote. Nope, that was about sending someone to Latin America. Towelettes! I found it. Let us listen.
What types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says do not use alcohol swab because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and it's every hospital should have the same policy where we use a swab that has no alcohol. We call them a moist towelette. That's what we refer them to. Also, in the emergency room, my supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case the phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So,
when were the alcohol swabs removed from the emergency department?
it was before my time.
So fair to say prior to January 29, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained, competent, and know.
Okay, so ladies and gentlemen, I think you now have realized how important the towelettes are to the John O'Keefe and Karen Reed retrial. Moist towelettes are incredibly important. Now, I have bigger news, ladies and gentlemen. I think Christina, our dear Christina from the chat, has located Karen Reed's two third-party culprits. We have found them together. This might be very damning for Chewbacca. I have very bad news for the people who thought we were going to be able to exonerate Chewbacca today. Ladies and gentlemen, Christina has just broken your hearts. Do you see what I have just brought up on the screen? Ladies and gentlemen, this is terribly concerning. There are reports, it's not a white Bronco, but there are reports that Chewbacca and the Stay Puft Marshmallow Man have been seen together. I don't know if one of the Free Karen Reed people leaked this photo. I don't know how this has happened, but somehow, some way, Christina has managed to locate the crucial piece of evidence that could free Karen Reed. Yes, ladies and gentlemen, the Marshmallow Man, the Stay Puft Marshmallow Man, and Chewbacca have been found together. Turtle Boy's not in court until Wednesday, I don't believe, but I'll make sure we check up on that. I believe that's when his motion is heard. But yes, I mean, I know, I know this is very, very important because there is no way that anyone would have managed to locate a fleeing Chewbacca and the Stay Puft Marshmallow Man unless they were actually responsible. So therefore, ladies and gentlemen, the folks need to get this information to Karen's lawyers if they're really, really going to vigorously defend their client. Based on everything else, all the other ridiculous things they've said, then at this point they have to go find Chewbacca and the Stay Puft Marshmallow Man. Listen, okay? You got to think about all this. There is no way that the Stay Puft Marshmallow Man and Chewbacca would be in a car together unless they were somehow responsible for what's going on in the Karen Reed trial. That's what I'm saying. Why would they ever be? You all, listen. This is a very serious situation. We're not sure exactly where they are. It's not just me. I think all the Towel friends are thrilled. We're not exactly sure where these two are. Listen. The Karen Reed fans are going to go absolutely ballistic. They are going to spend time geolocating this photo. They are going to comb the streets. We are going to see pictures of car chases where the Karen Reed fans think they found Chewie and the Stay Puft Marshmallow Man. I mean, listen. I don't know how we inadvertently stumbled onto this. This cracks the entire... Forget the confirmation that John never moved from the front lawn. Listen, I know that confirms Karen Reed's guilt. But ladies and gentlemen, this is clearly the relevant piece of information. Okay? This is what Karen Reed's lawyers need to bring up on a giant poster board in court. They need to show it to Judge Canody and say, Judge, we have developed sufficient foundation. We are ready to announce our third-party culprit. We found them fleeing from the jurisdiction. It's a picture we haven't been able to verify, but look, Your Honor, it is simply too probative to deny as to our argument. It's Stay Puft Marshmallow Man and Chewbacca. No! Don't implicate the Michelin Man in this. Oh, no! Listen. That was the one thing you weren't supposed to say. This was all cover to let the Michelin Man get away. Oh, you've just blown the whole plan out of the water. Do we really talk about this for 25 minutes? Oh, we certainly did. We talked about the Stay Puft Marshmallow Man. But don't worry, you didn't miss anything. Court's not back in session. We're watching closely. Christina, no! You may not imprison the Stay Puft Marshmallow Man and Chewbacca. Let them go right now. You're depriving them of their core constitutional rights. Hold on. Listen, I got an even better plan, okay? We're going to really throw people off. They're going to think that I am Chewbacca and the Stay Puft Marshmallow Man. Why, yes, I've transmutated. I agree. Listen, that's why Karen Reed's team must move forward with the Stay Puft Marshmallow Man and Chewbacca defense, because it's more believable than their other nonsense. At least with this, they have evidence. Listen, there is no reason that Chewbacca, a Wookiee, a 7'2" Wookiee, should be in a car with the Stay Puft Marshmallow Man. Ladies and gentlemen, it does not make sense. And if it does not make sense, that's enough to get one juror to acquit Karen Reed. Yes, this is Karen Reed's defense strategy. Thank you to Christina for sending us on this wonderful digression. The type of erudite, cogent, and wonderful analysis you all flock to the Towel stream for. Yes, that's why you're members of the Towel universe, because we put together complex theories and thus explicate why this picture is so crucial to the Karen Reed and John O'Keefe case. All right, folks, we should be coming back into session any minute here. I have the little bit of the early feed up on the screen. Well, I don't have it up on the screen for you, but I'm looking at it. And we can, as soon as that comes into session, we'll know we have about a 20 or 30 second heads up, and that should be happening any minute now. My name is not Chewbacca. My name is not the Stay Puft Marshmallow Man. My name is GrantSmithEllis. And if you want to support this stream, feel free to give it a like, subscribe. You can become a member. There's all sorts of ways to support the Towel stream. If you want to help Towel, you can support Towel as well. You can look in the description, maybe consider donating to Lindsay Gattani's fundraiser. Listen, this stream is rooted not on 6 degrees of Chewbacca. This stream is rooted on 6 degrees of authentic legitimacy, wherein we do small acts of kindness, either for homeless veterans or for other Towel friends or for people who are in your daily life or your family members. And through those small acts of kindness, we reinvent the soft power paradigm and shift us away from a world that prioritizes preserving, demonstrating, and expanding one's power to a world that is centered on an ethos of expanding, preserving, and demonstrating universal love and compassion for one another. Yes, ladies and gentlemen, 6 degrees of small acts of Towel compassion. That is what will bring about the age of Aquarius as it is meant to come forward on the historical scene, defined by compassion, toleration, and somehow Towels facilitating inter-economic cooperation among the Americas to ward off the rise of the BRICS and salvage the role of the petrodollar to thus preserve the liberal Western world order. See what I mean? Listen, I have all sorts of plans here. I absolutely have all sorts of plans. And while I'm not actually Chewbacca and the Stay Puft Marshmallow Man, I think we can reach levels of cultural relevance with this plan in ways that no one foresees. I do think the history books are going to be a little bit confused by the whole emergence of this Towel phenomena. But all of the best inventions in history, all of the best minds, all of the best contributions to the syntactical Hegelian, beautiful historical form, reflected in Vico's sort of recursive circles that I like to talk about so much in the context of Finnegan's Wake. Ladies and gentlemen, that is how they will eventually be able to parse through the Towel motif and understand the wider fabric of the Towel universe and say, yes, for some reason, this epoch became defined by people doing acts of service and compassion for each other because they thought of themselves as anthropomorphic towels or soap dispensers or flannels or paper towels or hemp towels or towelettes or otherwise. And there in the New World Order, the age of Aquarius was born, and it came about with both a man carrying a water jug and a towel. How fitting. There you go. I have put this all together. Why did Han Solo not enjoy his steak? It was chewy. That's hilarious. The sunken grave. Oh, goodness. You Towel friends certainly know how to keep each other entertained. All right. Well, I will say, folks, you can take a look here. We are not yet ready to go back into session. Towel, of course, is on real-time monitoring. I'm extolling for you all the virtue of a world order based on universal compassion, centered apparently on towel production. Now, listen, I think it's unfortunate, but we really do have to center this on towel production, because the only way you can get benevolent influence over the government is by being an industrialist. And by the way, we're only 30 minutes away from the potential ARCA hearing. I hope you're all ready. That's what we're all waiting for. Oh my goodness, I forgot that I put myself as Chewbacca and the Stay Puft Marshmallow Man. You know what? We're going to keep this on the screen. I just don't think we need it as, you know, no, what's that? I don't want that. Get that out of here. We're going to keep Chewbacca on the screen and the Stay Puft Marshmallow Man, because we're trying to send a message to the Karen Reed defense. No, that was not what I wanted to do. We're trying to send a message to the Karen Reed defense. We found them. Somebody tell Meredith. Meredith was, I told Meredith that if I got any leads on Chewbacca, I would let her know. I think Meredith was a little perplexed by that. All right, ladies and gentlemen, Chewbacca and the Marshmallow Man are now along with me for the ride. We are still, I agree, Karen should have taken a plea. I heard she was offered 18 months and should have taken it. Ladies and gentlemen, we are now waiting to come back into session. Keep your eyes peeled. Little Towel, as soon as the top left of your screen there, Little Towel will be with you as soon as that happens. Little Towel is ready, and we are waiting. Also, an important thing to do is, well, I know that we can't be back into session until that happens, but let me jump forward. The most important thing is that we not look at the fan. Towel has objections to the... Oh, no, it's the fan. Oh, no, what have I done to myself? Why will you not show the light every single day? I don't know if you all are new to this Towel feed. My name's GrantSmithEllis. We're watching day 5 of the presentation of evidence in the Karen Reed and John O'Keefe trial. We are now listening to Ian Whiffin, a celebrated, renowned expert and coder for Cellbrite. Someone once tried to tell me Ian Whiffin didn't code for Cellbrite, and I was like, you fool, you don't know what coding is. I looked at his GitHub, and he pushed commits, and the person was like, Grant, you can't go say he's a coder. And I was like, try to tell me what to say again, because I do not believe your words. I did my own independent research. Anyway, that's a bit of a digression, but we're listening to Ian Whiffin from Cellbrite not only confirm, which was a big part of his first part of his testimony, that Jen McCabe Googled how long to die in cold at 6:23 and 6:24 a.m., but further now that John O'Keefe never moved from the front lawn of 34 Fairview Road after John was allegedly struck by Karen's car at 12:32 a.m. on January 29, 2022, and then left to die from a catastrophic brain injury and slowly induced hypothermia on the lawn by Karen in a blizzard. Yes, welcome, Busty DD. You're part of the honorary blue wall of towels. And so we are waiting for the session to come back in, and I will say, folks, using Ian Whiffin in this dual role for Jen McCabe's cell phone and John O'Keefe's cell phone is brilliant. It's just absolutely brilliant. And someone was asking earlier, what was that log about a deletion in a search? No, there was no how long to die in cold search that was deleted at that time. What happened was there was a write ahead that eventually caused like a cache to get overwritten, but it wasn't the how long to die in cold search. I think it was the earlier search. And either way, there was another, what really happened was, I think when you open the new tab at 6:23 or something, and then you start typing, what it does is it can sometimes overwrite previous data, and that's what Richard Green misinterpreted. So Ian Whiffin was trying to explain that. He might not have done a great job, but if it comes up on cross, then I'm sure on redirect it will come back up. The point is, Jen McCabe Googled how long to die in cold at Karen Reed's request at 6:23 and 6:24 a.m. on 1/29/2022 while standing in the cold. And then furthermore, Karen was asking the same kind of questions to an EMT on the way over to the hospital after she was committed by her own parents for making threats of self-harm. So we know that that's when Jen Googled how long to die in cold, 6:23, 6:24 a.m. But now Hank Brennan's moving on, and what we're going to come back and listen more to is about John's phone data and what it shows. And ladies and gentlemen, this could be very interesting. The battery temperature information, what folks have been waiting to hear, could be coming up now. My name's GrantSmithEllis. Thanks so much for turning into Towel Stream. We're just waiting for the court to come back into session. Towel is avoiding making you watch the fan. As you know, Towel has an aversion to the fan. Those of us on Towel Stream who do not like the fan, we raise hell. We are fans of the light, and we do not like the fan, so I cover up the fan for you to prevent you from becoming nauseous. But once this arc of voir dire starts, folks, remember, there will be a 1 o'clock lunch, but Towel's already eating his lunch now. I got 7-Eleven pizza, and let me just tell you, for $1.50 a slice, ladies and gentlemen, I am a very happy Towel. Let's see. Wait, what? We're hearing that there was a missed flight? No, it's not possible. They were ordered to appear. Hold on, folks. We need, oh, no, Busty DD. I have great news. I'm at 10,000 watch hours or something. So we are, I think we're already good to go, and I'm in the partner program. What happens is at 1,000 subscribers, I think I have the option to turn on ads, but I don't think I'm going to do, I don't know. You all let me know what you want me to do. I can turn them on every half an hour or whatever, but that's the next milestone. We already have super chats now. Somebody sent a super chat earlier. We had our first 2 super chats. It was from Jew Drops and Lisa Cox, and Towel was very honored. Obviously, super chats are the same as regular chats here, but just know that Towel was touched. And also, did you know you can become a member of the Towel channel now? You can gift memberships to other people. And if you become a member of the Towel channel, you can then use these wonderful emojis. And my word, who would not want to send a Towel-themed emoji in chat? My word. But yes, can we find out if Arca is late? Well, you know what we can do? You know what Towel can do? Because I'm a Towel. We can take a look around because we do monitoring. Now, remember, if Arca is late, Judge Canoni is going to announce it in court. They were ordered to be here at 12 noon Eastern. I think I slipped a little bit from New England accent to whatever that was there. But when you're ordered into court, you don't ignore the judge's order unless it's an act of God. Oh, Alex, I will consider turning on ads because I'm a Towel. But also, until I can turn on ads, if you want to help Towel today, because remember, the hardest time for Towel is the end of the month. I operate this public information service, which is done through a professional. I have the software that I use. It takes a lot of effort. We're about to come back into session. Folks, I'll find out more about Arca. About to come back into session. Okay, we're back into session.
Let's close the session. Be seated.
All right, Mr. Brennan, whenever you're ready.
Mr. Whiffin, before we go into the next subject area, I'd like to ask you about the location data. Based on your review of the location data, do you have an opinion whether the location data throughout the evening is consistent with John O'Keefe's cell phone being near the flagpole the entire night?
I believe it is, yes.
I asked you whether you had an opinion whether it was consistent with. I didn't ask you if you had an opinion to a reasonable degree of scientific certainty. Are there other things that you looked at that you will consider in addition to the location data to have a more certain opinion?
There is.
And is the next thing that you considered Apple healthcare data?
It's the Apple Health data, yes.
We asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present to us the data that you've compiled for us. Is Apple Health data different than when you have an Apple Watch?
No, it's the same Apple Health data recording on the phone or the watch. The only difference is the sensors being used to do that monitoring. So if you're just using the phone, obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survives on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Apple Health data tracks movement of the phone?
Correct.
When you were considering the Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching Fairview Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
The different points when you tracked Apple Health data, is that helpful even if you're only trying to isolate a certain point in time?
It can be, yes.
Does it help determine whether or not it was working properly? If it was,
it can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
If a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data resume movement even if somebody else picks up the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Your Honor. Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
Could you turn to the next part of the data analysis that you did?
Yes.
Please.
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This, as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information's aggregated, so you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C.SQLite database is much more temporary, but is much more granular, so we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time. So again, we might see within the cache encrypted C individual flight climb events that occurred, for example, 30 seconds apart. But by the time that information is written to the Health DB Secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed to 3 individual flight climb events with individual timestamps. Typically, that source is not used because the data is not stored there for very long. The information I found on John's phone was essentially these 5 records. So between 11 minutes and 9 seconds and 21 minutes and 5 seconds, there were 170 steps recorded by the device.
Mr. Whiffin, I'm going to stop at each one and ask you some questions. At the time period between 12/11/09, 12/21/05, you don't have any independent information where John O'Keefe or his cell phone were, do you?
The location data that I showed to begin with on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using Waze. It was already driving along Denham Street or had turned onto Maplecroft.
What time did you say that Waze was initiated?
It was approximately 19 minutes and 30 seconds-ish.
Thank you.
Again, we see at 21 minutes and 10 seconds until 24 minutes and 22 seconds, there are 80 steps recorded. And again, if you compare this to the location data, we know that the device was in a vehicle at this time. Between 22 minutes and 14 seconds and 24 minutes and 37 seconds, we have 3 flight climb events that are aggregated into that time period. And again, the location data shows that the device was traveling in a vehicle at that time.
Mr. Whiffin, you had showed us a slide of 2437 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12/24/37, the phone in the car was still traveling at 1.4 miles per hour.
Correct. This is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12/22/14 to 12/24/37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone, was still in that car?
Yes, the location data shows it was in the car at the time, and my next few slides will demonstrate why that was still recording a flight climb event while it was in a vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
Let me ask you about that 12/31/56 to 12/32/16 time period. We can see larger ranges in the time period range. That is a smaller range comparatively.
Yes.
Okay. At 12/31/56, is that the beginning of the 36 steps?
Essentially, yeah. It takes the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12/32/16 would be the last steps taken for that cell phone?
Correct.
And in between that time period, there's 36 steps. You shared earlier that it doesn't indicate the direction of the steps.
Correct.
Other than the movement that equates the steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been a straight line.
Could it have been somebody pacing?
It could have been.
Could it have been somebody moving and jumping?
Yes. Jumping, if they were jumping forward, essentially.
After 12/32/16, when this phone took its last steps, it never moved again?
Objection, Your Honor.
Form of the question, sustained.
After 12/32/16, when this phone took its last steps, did it move again until 6:04:01 a.m.?
There were no more steps or flight climb or any other health activity recorded during that time.
Do you know what triggered movement at 6:04:01 a.m. of Mr. O'Keefe's cell phone?
I presume that the device was moving at that time, but I don't know the details of who.
Objection, Your Honor. Move to strike.
I'll strike it.
Please continue.
Okay. Regarding the flight climb events, looking at the cache encrypted C database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
So you're going back to earlier in the evening now, 12/22/14.
Correct.
To 12/24/37 when the phone stopped near the flagpole.
Correct.
Okay, thank you.
So we have the first record at 22:17, a flight climb event was recorded. I've highlighted that was a red line, and that equates to the red line that shows underneath the timestamp where the location was, where the device was at that time. The second record is 22 minutes and 32 seconds, showed with a green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34 Fairview. I'd like to point out that health activity events are recorded upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you've reached the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database. So then I took that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the altitude of the device over time. So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record's recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event. When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line, and again, working back 15 seconds and beyond to allow for the tolerance, we see the green gradient area. This shows an altitude change of around 45 meters to 48 meters. Again, that would be sufficient for a flight climb event to be recorded because we have 3-meter incline change. We then don't see an incline change for a while. All we see is the device going downhill until we get the record right at the end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
I'd like to ask you...
Sorry, I'll go back.
Continue, and then I'll ask you, please.
Okay. I then compared that information to a topology website from the area, according to a topology website data, and plotted that out here. We see the red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb event occurred, and within the orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters. Between the green gradient and the green number 2, again, we're going from around 47 to 50 meters. And then with the orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Mr. Whiffin, there's 3 different times. The first is 12/22/17. At that time, was the Waze data app initiated?
It was.
And did that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to still be traveling in a car.
At 12/22/32, was the Waze data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the Waze data initiated and active at that time, 12/24/37?
If I remember correctly, Waze had closed about 5 or 10 seconds earlier.
Now, based on your study of the Waze information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Thank you. You can continue, please.
Okay. So I'll address the idea of 3 clocks, which I believe was brought up previously.
Let me interrupt.
Sorry.
Why don't we just explain to the jury how clocks work in an iPhone?
That is kind of covered in the next slide anyway.
Okay.
Maybe worth just jumping ahead to that slide.
Explain the idea of 3 clocks.
Yes. Essentially, there is one clock on an iPhone. It's the clock that you see. It's shown in the top corner, and all activity is related to that particular time. So when you receive a text message, the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything is related to that time. The difference is within the current PowerLog databases. It's a subset of files stored on iOS devices. They use what's called a monotonic clock, but it's not a clock that can actually be trusted to see when events occurred. It's the way that the device records time. It's essentially a counter that's just counting seconds since the device was reset, basically. And I'm sure most people can recall a time where you would set a clock on a digital device, come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift. It might drift forward and be faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in this slide here. The confusion with the idea of 3 clocks, I believe, comes from the way that Magnet Axiom product displays PowerLog data. They show a monotonic date and time, a baseband date and time, and a display date and time within the PowerLog records. As an examiner, it's really good to see this data and understand how the tool is determining these values. As an examiner, it would be really bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk through how this information works. So the other thing that Axiom shows, as well as the monotonic baseband and display times, is they show the location where this information came from. In this case, we have 2 tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number, a timestamp, and a value of locked. But we also show a second table that's involved called PL Storage Operator Event Forward Time Offset. And that's this table at the bottom here. So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds once you account for the UTC -5 offset. And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12:21:27. What we need to then do is take that monotonic time and add it to the baseband value that we see in the time offset table. So now we have a value of 1643.8687.14954, and we add -183 point whatever this number is here to get this value. If we treat this value as number of seconds since the 1st of January 1970, then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here as the baseband time. Finally, we can take the monotonic time and add the minus 181 seconds shown in the system to get this value, which equates to 18 minutes and 25 seconds past midnight on the 29th of January, which is the same as the display time up here. So all this is essentially doing is saying that the counter that is built into the iPhone is registered the time of that we see in the top, the monotonic time. This is not necessarily the time that the event happened. You have to offset it with this value here in order to get the actual time that this happened. My own personal phone, when I was doing this testing, the time difference between the monotonic time and when something actually happened was over 2 weeks. There was a massive difference because my phone has been drifting so far since I originally bought and set up that phone. And again, when I was testing this, I can turn the flashlight on, turn the flashlight off. Both of those activities are recorded in the power log database. If I just look at the monotonic time, it's off by over 2 weeks. If I do this process to calculate the correct offset, it shows exactly when I turned that flashlight on and when I turned that flashlight off. The calculation is imperative. Without the calculation, these timestamps are irrelevant. And all Axiom is doing here is they're showing you the values that they use in order to calculate the final value. It doesn't mean that you can take the monotonic timestamp and read anything into it. It's completely irrelevant on its own.
Is it necessary to understand this process in order to ensure the integrity of the time that you're offering to the jury so you understand whether it's accurate or not?
It would be if we were discussing power log data. Power log data only really encompasses things like battery level, the time and date that it's plugged in, button presses, camera usage, things like that. It doesn't count for location data. It doesn't count for Apple Health data. They both work on the system time, and they both work on the same system time. So they're always going to be aligned.
Do you have an opinion to a reasonable degree of scientific certainty as to the accuracy of the location data times and the accuracy of the health data times that you shared with us?
They'd be consistent with each other. So to summarize that, there's only really one clock that's in use on an iPhone for recording. The only difference is the monotonic time, which is how power logs record information, but you need to offset the times to figure out when that activity actually happened. And that you only have to offset those times for power log data, not for health, not for location, not for messages or photographs or any other activity like that, purely power log data.
Okay. Is there another subject that you looked at, that you analyzed in order to reach a conclusion about the time and location of John O'Keefe's cell phone over the night of January 29, 2022?
Yes, the next one is battery temperature.
Can you explain a little bit of background on this before you start the slides?
So again, we have a temperature sensor built in within the phone, monitoring for if the the battery temperature increases too high and becomes a danger, or if the temperature gets too low and becomes an issue. So it constantly monitors the temperature of the battery and records that information in the Knowledge C database.
Did you look into the battery temperatures from before midnight and after midnight and do an analysis regarding the temperatures of that cell phone battery?
I did, yes. Throughout the evening of the 28th of January and then the morning of the 29th.
Mr. Whiffin, that's going to be hard to read. Is there any way you can enlarge it?
But apparently not like that. There we go.
Thank you.
So on the evening of the 28th, see an average temperature of around mid-80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after midnight, we now know the device is already at Fairview. It's been at Fairview for approximately 12 minutes, and the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffin, if I can interrupt you. At 12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. 1:36, it's dropped to 50. And then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m. when the temperature is 43 Fahrenheit.
Mr. Whiffin, if a phone has any protection or coverage, well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know. Accurately, no.
Okay. And then you're now at 6:14 and it's 37 degrees?
Yeah, you're correct. This is the coldest temperature recorded.
Do you know what, if anything, happened to that phone at 6:15:01?
I don't know.
Okay, please continue.
And then, as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we can see on the evening of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase. But there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or had extensive usage.
Between 1:36 a.m. and 6:06 a.m., is there any indication at any time that battery temperature went up?
No, there's no records related to battery temperature at all for that time.
Thank you. Is there another area that you looked at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The current power log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And unified logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur. So really granular. We see that at 12 minutes and 52 seconds after midnight, the device is unlocked using biometric Face ID. The SMS application is on screen for about 5 seconds before it's closed, and then the user presses the lock button at the side of the device to lock the phone. At 13 minutes and 54 seconds, biometric Face ID is used again, and the SMS application is opened. And at 14 minutes and 29 seconds, the lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID. The SMS application is already on screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. And at 19:23, that phone call ends. At 19:29, the Waze application is opened by the user pressing on the icon on the home screen. And that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds. 2 seconds later, at 24 minutes and 28 seconds, the device is locked by the user pressing the lock button on the side of the phone. At 24 minutes and 59 seconds, the device is unlocked using Face ID. The SMS application is opened using the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The SMS application is already on screen, and at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage, and at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use, and at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device. It's the final unlock of the device using Face ID, and it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night?
Correct, up until 6:15 a.m.
In 12:32:09 was the last time before the phone moved again the next morning?
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. this was the pocket state that I think I mentioned earlier, and it detects when the user takes the phone out of a pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records, and to filter and aggregate down into a more digestible number, which is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera is blocked, it records the fact that it's in a pocket state. And it will continue to record pocket state until either the obstruction is removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends. So in this case, at 12 minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds with a pocket state cleared event. At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds. At 25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state. And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97 Doppler checks. The 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted. Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time. At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 seconds where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffin, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including Waze data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them to the jury in chronological order?
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use. For around 11 seconds, a phone call is made from John to Jennifer McCabe. Phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again. 31 minutes and 47 seconds after midnight, a message is received again from Jennifer McCabe saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "Pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in a pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler's pocket state being detected by Doppler. And I've also showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, "See you later." Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, "Your kids are cooking alone."
Mr. Whiffin, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that wave was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16, that the last interaction was at 12:32:09, followed by an overnight pocket state, an increased reduction.
Objection, Your Honor.
So I need to hear the question first.
Including a increased reduction in the battery temperature. Do you have an opinion, to a reasonable degree of scientific certainty, that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
The location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing that the camera was unblocked during that time, which would typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion, to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the flagpole area from around 12, 24, 33, until the next morning at 6 a.m. or after?
That's
the
my
objection's sustained. Ask the question in a different form.
Do you have an opinion where John O'Keefe's cell phone was from around 12:24:33 on the evening of January 29, 2022, through at least 6 a.m. and after that morning?
Yes, based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
I have no further questions. Thank you.
All right. Mr. Leslie?
May we approach, Your Honor, please?
Okay.
Oh, my word, folks.
Jurors, feel free to stand up.
It's GrantSmithEllis. We are in Sidebar. We are in Sidebar. Karen Reed walking over to Sidebar. Karen Reed, a lonely figure. That was devastating testimony for me and Whiffin. Just devastating. Absolutely devastating. John O'Keefe's phone never moved from 12:32 a.m. and 16 seconds until it was picked up when he was found by Karen Reed and others after 6 a.m. the next morning. Oh, my word, folks. My name is GrantSmithEllis. We look like we're coming back from Sidebar. Bob Alessi's about to try to begin his cross. We have very little time before lunch. I'm a towel. Hi, Christina Rex. You're an honorary towel. Oh, that's Peggy O'Keefe. She can be a towel. Everybody loves Peggy O'Keefe. God bless you, Miss O'Keefe. You have the support of the legions of towels behind you. The whole towel universe. We come together. We stitch together as a fabric. Flannels, washcloths, soap dispensers, towelettes, hemp towels, paper towels, every kind of towel imaginable. God bless you, Peggy O'Keefe. We're going to come back into session here. I'm a towel.
Your Honor, if I may have a moment, please, to set up at the podium.
Okay.
Your Honor, if I could have 7,000 hours, my name is Bob Alessi. I should be done sometime next year.
Mr. Whiffin, I should have told you you can feel free to stand up and stretch if you want to as well.
Thank you, Your Honor. May I proceed with the
Yes.
administrative matters? May I approach?
Yes.
Thank you. Your Honor, pursuant to a stipulation with the prosecution, I would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by Mr. Whiffin. The first one.
So, yes, they can come into evidence.
Right.
They can come into evidence. There's a stipulation. So we can mark it as the next exhibit.
If we can, that's page 29 for the next exhibit.
You want them marked separately?
Separately, please.
Exhibit 40.
Right.
The next exhibit will be pages 77 and 78 of the same report.
Okay.
Exhibit 41.
The third and last is page 43 and page 44.
Exhibit 42.
Okay, all set.
Thank you, Your Honor. May I, Your Honor?
Yes, please.
Good afternoon, Mr. Whiffin. I don't believe we've had the pleasure of meeting.
Good afternoon.
Cell phone data, when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this, literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation and specifically go to the timeline that you had gone through with Mr. Brennan, and rather than repeating everything, there'll be select aspects of the timeline I'm going to reference, and with the court's permission, we will put the timeline back on that's already in evidence.
Okay.
Thank you. So what I'd like to do is to start with page 70, which we have as 78 of the deck. If you could, Mr. Wolf, go to that. And what I'd like to do, if I could please, Mr. Whiffin, is draw your attention to the very last entry, which says at the bottom, location 122438, and it indicates description, first location record showing speed of 0. Do you see that, sir?
I do.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
If we could go to the next page, please. We have up at the top 12:24:59, about 21 seconds later after arrival, we have device unlocked with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that device with Face ID?
If a secondary user was set up.
Do you have any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry.
I never looked to see if a secondary user was set up.
In terms of the next entry, 12:25:08, it says, read message, you coming here? With 3 question marks. What I'd like to do, because you did not note who that was from, but I want to go back a few slides so we can identify who that message was from. We could go back to 76, please, Mr. Wolf.
Yes.
So in the last line there, message reading left to right 12:20:49, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here, is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry when it was read by John that message was from Brian Higgins, correct?
Correct.
Now, the next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12:25:09, and it says device locked with lock button.
Yes.
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely, device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, that's covered in the location section of this report, the PowerPoint.
So there is no statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct?
The location, latitude, longitude was moving westerly, but at the same time, the accuracy was increasing, so it didn't intrinsically prove that the device was moving.
My question, Mr. Whiffin, is straightforward in this sense, that I'm just looking for an answer of whether on this timeline you included the analysis that you had in your report that the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Next entry, 2733. That's 12/27/33. You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, at this point, you have two people in just 2.5 minutes, Brian Higgins and Jen McCabe, trying to find out if the John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair conclusion?
It would appear so, yes.
So, just because of the colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12/27/33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John, or the phone, is coming to, or if John is coming to 34 Fairview. Objection.
Sustained. Ask it differently, Mr.
Thank you, Your Honor. Now, at this point, you have two people trying to find out if John is coming to 34 Fairview, correct? Objection.
Sustained.
Mr. Whiffin, in terms of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is, they're trying to find out, I'll rephrase it. There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolf. This is 12/27/45. Device unlock with Face ID, correct?
Correct.
And then right under that is 12/27/48. It says read message, which it says here, and is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
Sorry, repeat that question?
Yes. You did not, it does not appear in that timeline that you've drafted that that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above there's read messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular in a particular way so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942, when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44, and that you state is an incoming call from Jen McCabe. So there you do indicate the name, and you say answered 7 seconds. Correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right. So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7 second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to Mr. Wolk 81, which is starting up at the top of 12:31:47. There is, as you indicate, an iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone via the Apple servers, not like an SMS message which goes through carriers.
And is it correct that the message that was received from Jen McCabe said, from a contact of Jen McCabe, says, "Pull behind me"?
Correct.
And then at 12:31:52, we're back to Doppler pocket state, correct?
Correct.
Now let's go to the next entry, which is Deck 82. It's under health type. And what I want to do is see if we can clarify. The Commonwealth on direct examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or is it health data?
It's health data.
So it's incorrect to refer to this as healthcare data, correct?
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right, so the correct parlance is health data,
yes.
Correct? Particularly when we're getting to steps, is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
So in this entry, 12:31:56, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
It's approximately that, yeah.
Right. Would you health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
It's approximately that, yeah.
Right. Would you accept approximately 84 feet? So as we discuss meters, we can go to feet and
yes.
About 84
I would accept
feet.
Approximately 3 times 25.
Right.
So
in your report of March 2025, isn't it correct that for this time, you stated that the device began moving for a period of 20 seconds, correct?
Yes.
So, again, your conclusion from your analysis is, with these 36 steps, the device at this point began moving. Correct?
Correct.
Next entry. 123203. Pocket state cleared. Correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's happened, yeah.
Next, 123204, device unlocked with Face ID. Correct?
Correct.
And then at 123205, it states application focused messages.
Yes.
Can you clarify what that means in terms of what is happening with the phone for the jury?
Yep. So at 32 minutes and 5 seconds, the messages application was in focus on screen. So it was the application that was being used by the user at that time.
Now, the next entry is message 123206, and it states red message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 1231:47, correct?
Correct.
Next entry is application lock at 123209, and you've got here end application focus, and then you state device lock with lock button for the last time, correct?
Correct.
So that's again pressing the side button on the iPhone that locks it.
Correct.
And that requires human conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 123216, that is 7 seconds after the lock. It's the end of the health event of 36 steps, 25 meters, and as we agreed, approximately 84 feet. Correct?
Correct.
So, in terms of the steps, I want to turn to some further information with regard to your previous, the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep continuing?
All right, Mr. Leslie. Folks, we'll stop. Turn on lights, please. Thank you. Mr. Whiffin, we need you back here. Jurors, we're going to recess for the day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read
anything about the case, please disregard it and let us know, and please be very careful with your social media use, all right? We'll see you tomorrow morning.
All right, don't go anywhere. Don't go anywhere, folks. My name's GrantSmithEllis. I'm a towel. We expect
I'll see
to
counsel at Sidebar.
We're going to go to Sidebar, and then we're going to find out if we're going to go right into the Arca hearing. It could be now. It could be after lunch. This is the moment. Towel friends, assemble. I'm a towel. You're all towels. Grant, I don't think just yelling that you're a towel is effective. That's true. I should not just yell I'm a towel. But it's true. I am a towel. And this could be the moment. Are we going to lunch? Will we be working? Oh, the light. The light. No. Go back to the light. We go down. Towel is looking at his phone. I'm looking at your comments, ladies and gentlemen. Miss Peggy O'Keefe in the foreground. Will we see Arca now? We don't know. We simply do not know. Oh, we're told to film not anything but the fan. Well, not me. Oh, look, Chewy and Mr. Marshmallow Man are still with me. I'm a towel. It's so good to see you all. We are waiting. What is going to happen? Am I a towel? Are you a towel? I'm not going to make you watch this unbearable fan. We are waiting to see if things come back into session. I have a towel plan. Bear with me, little towels. Bear with me, little towels. Here's the towel plan. You ready for this? Oh, no. Oh, no, I grabbed the wrong screen. I'm such a towel. Wait a minute. I have a towel plan. How's that, little towels? We are just waiting for the court to come back into session. Your comments, as always, are at the top of the screen. Bob Alessi struggled there on cross, to put it lightly. You all towel friends, tesseracts though you are, engaging with the public. The Marshmallow Man is about to hit the fan. Is Arca about to come? Are we about to see the moment we've all been waiting? Is Bob Alessi a wet towel? I don't know. Okay, hold on. That can be a poll. You're all towels. As we wait for this sidebar to continue, bear with towel. Bear with towel. Bear with little towel. Bear with little towel. Okay, ready for this? Are you ready for this? I don't know if all you little towels are ready for this. Now, I don't know if we're going to see Arca right now. I don't know if they're going to come back into session. I don't know if we're going to go to lunch. But here's the question. Is Bob Alessi a wet towel? Yes? No? Hold on, we need more options. I'm a towel. You're a towel. Okay, here we go. I have started a very important poll, towel friends. This is crucially important. Is Bob Alessi a wet towel? I don't know how folks are going to answer this question. I gave you a lot of options. There's a lot of different ways for us to answer this question, okay, towel friends? There are a lot of different ways. Now, I'm hearing Arca is going to be here this afternoon. We are back outside the court. We could be going to lunch. Hold on, I can tell you whether we're going to... No, hold on, folks. Sorry. Towel is going to stick with the feed, okay? Towel is going to stick with the Zoom. Law and Crime has shifted its coverage of outside the court. We do not know what's going on there, but I am right here with us, and I am going to keep an eye on the various updates that we get. Even if we do go to lunch, Arca is coming. Towel is going to stay with you through lunch. Towel is going to discuss. We are going to talk. I am a towel. Here's the poll. Most people seem to think that Bob Alessi is a wet towel. Most people... some people, 18%, are towels, and 18% say I'm a towel. Now, here's the thing. I've done this again. I've created a poll with a number of correct answers, because Bob Alessi can be a wet towel, I can be a towel, and you all can be towels. So we've really created this. We've created just this terrible situation where no matter what you vote, you're right. So nothing really matters in terms of voting on this poll, because there's no way to do an accurate poll when there's so many right answers. But yes, ladies and gentlemen, I'm keeping an eye on things. The court cam has not gone away. Stay with us. We don't just rely on these other feeds here. We are towels. We are Oh, but that's Anjanette Levy. I like Anjanette Levy. Hi, Anjanette, but we're not going to watch Anjanette Levy. We're going to look at this court and we're going to stay ready. We don't rely on other channels here, towel friends. We watch and we wait and we keep an eye. We monitor. We are patient. It's Towel Attenborough on the prowl. Towel watches. He's a astute, prescient towel, and all the towel friends facilitate in this important endeavor. We monitor, we watch. Chewy and the Stay Puft Marshmallow Man are along for the ride. Ems, it's so good to see you. You've become an honorary towel. Congratulations. There's nothing so important in the world of towels than joining the blue wall. Lucy, great to see you. Monty, always a pleasure to see you. Just saying hello to some towel friends. Bear with me, towels. I'm a towel. Hold on. Are we back in session? Hold on.
Timeline of what he was doing at a particular time.
No, we're not back in session. Stay with me, towels. Stay with me. Stay with me, little towels. Now, what we need is we're going to check. Towel is going to check and see what's going on. Obviously, we have not gotten an update from the court cam yet, and normally when we break for lunch, that goes off. So stick with little towel. I'm a towel. You are all towels. And being little towels, we are just absolutely towels. Just absolute towels, ladies and gentlemen, and therefore we must find out what is going on. We have a job to do. We must find out when the Arca voir dire is going to start, and we must do so immediately. So I shall do that for you, little towels. I shall do that for you indeed. So the first thing I'm going to do is check in with Katie Benoit on her Twitter, and we will find out what is going on. All right, hold on. You're a towel. I'm a towel. I know, we're all towels. Hold on. Come on, Katie. We don't know what's going on yet, ladies and gentlemen. Bear with little towel. Bear with little towel. I'm not going to give up. I refuse to be deterred. When I set out to do something, I do it. And I find out. And I, by God, will find this out for all you towels. You've earned it. You all continue to talk and inform the public. Okay, where are you, Christina? All right, what do you got? No updates yet from Christina Rex? Oh, so we're expecting for an voir dire after lunch. Okay, folks, so it looks like it's going to be closer to 2 o'clock. I do not have the formal confirmation, though, that we are actually in lunch. However, it could just be that the court cam is going to stay on. If that's the case, that's wonderful. I know a few things we can do. One, we can get rid of this mainstream because we won't be coming back until 2 o'clock, so I'm going to get rid of that. Then the other thing is we can watch and get fully caught up for Arca during the lunchtime. That's even more exciting. And the reason I know we can do that is I have all the Arca videos. I may have closed some of them, but I can still find them for you. Okay, we are all towels. We are all towels. Well, no, I think there's some questions, Eva, about when exactly John got out of the car, if he stood at the side of the road. But the point is, his 36 steps never took him beyond the flagpole, and that's the last time his phone moved. Incredibly important data. It's all over social media right now. Yeah, I think that's really what was happening. He was walking back towards the house because you got to remember where exactly John was. I mean, they weren't right at the door. She had pulled forward a little bit. So, yeah. But yes, I'm sure Hank Brennan is going to show exactly with his crash reconstruction experts in line with the timeline what John was doing from when he got out of the car, when he was hit, and where he came to final rest. Remember, there's a specific term, pedestrian's final rest, and that's what they're really going to be looking at to analyze in line with all of the data. Where did John walk back a little bit and then get hit and then end up on the lawn? And I think all of it's going to line up. But yes, my name is GrantSmithEllis. Thanks very much for being with me, towel friends. We are waiting for the top of the hour. It turns out we will get just a little bit more of a crescendo up to the Bombshell ARCCA voir dire hearing. Now, sometimes we take truncated lunches. We don't know exactly when we're returning to session. Little Towel is on the prowl. That's a good, that's a great rhyme there. And I am keeping an eye on when, if anything, when exactly we are going to be back. Normally, lunch is pretty normal from 1 until 2, but Judge Canoni, if she needs more time, can always order lunch to be shorter, etc. It's never longer. Hold on, Towel is monitoring. Towel is monitoring, ladies and gentlemen. Towel is monitoring. All right. Oh, goodness. Breaking from Jonathan Hall. Whiffin is done for the day. A juror was called up to sidebar. There is a long discussion going on after the judge asked this male juror a series of questions. Oh, Elizabeth Little is making a point to the judge and is somewhat emphatic in her remarks. Folks, we have a situation going on. Little Towel is on the hunt. Towel is reporting live, as indicated by Jonathan Hall. The lunch has not started. There is ongoing discussion. Something has gone on. Ladies and gentlemen, we are actively monitoring. This happened 39 seconds ago. Towel is reporting live. Reporter Towel at your service. Paying close attention. Someone said I was like a horse tracker racer. Towel is paying close attention. The horse rounds the third bend. Number 42 takes the lead. Towel is reporting in real time as fast as he can for you. Something intense is going on. Towel's not exactly sure what. It seems to have to do with a juror and Elizabeth Little, Reed's lawyer, being animated. We do not have pictures, ladies and gentlemen. This is at Sidebar. This is going on in real time. You'll have to pretend this is the 1960s and you're listening to the radio. Reporter Towel is here. We are reading the news feed. As information comes in, Reporter Towel is delivering it to you. Towel is doing everything that he can. Towel does not have any further updates as of 39 seconds ago. Little Towel is continuing to monitor the fact that the court feed is still live. Okay, folks, the sidebar has ended. Little Towel can confirm the sidebar has ended. We are in lunch. I am hearing Arca is coming after lunch. But we are in lunch. I'm waiting for the reporters to write up that the sidebar is over and to tell us when we will be coming back from lunch. Jurors seem to be going home for the day. Stay with Little Towel. Little Towel is monitoring in real time, ladies and gentlemen. Little Towel is monitoring in real time. Now, what I will also bring up on your screen for you is we need to take a look at what exactly is going to go on when Arca gets here after lunch, because that in and of itself is momentous. Momentous, ladies and gentlemen, I tell you, momentous. Now, as a towel, I have all of these videos archived because I'm a towel. And as I said earlier, do you know why they call a towel a towel? Because it's a towel. All right, ladies and gentlemen, so I was able to confirm for you that there was a short delay before jurors were let go before the end of the Karen Reed trial today. I'm now able to let you know that the sidebar has ended. The sidebar has ended, ladies and gentlemen. We are now in lunch. I don't know exactly how long lunch is going to go for. I'm going to check in with the venerated Christina Rex on her Twitter. Stay with me. Stay with Little Towel as we monitor the news wires. Pretend that it's the 1960s. Towel is monitoring. Here we go. Before the lunch break, there is a juror called up to sidebar with the judge and the lawyers and Karen Reed. Judge questions him. He remains on the jury. Is not dismissed. Lunch now until 2 p.m. Little Towel. Little Towel has the information for the people. Little Towel relays it in real time. Arca alert. Arca alert. We do expect Arca to be testifying after lunch, ladies and gentlemen, and Towel will get you fully caught up as to what to expect during this very intense potential voir dire. We are within 53 minutes of the Arca voir dire starting. Now, stick with Little Towel. Stick with Little Towel for a number of reasons. One, Little Towel is going to go back and prepare us for the return from lunch, and we know that about 30 seconds before every other feed, Little Towel will be able to let you know when we are going into session. So, stick with Little Towel, ladies and gentlemen. Stick with Little Towel. I will answer your questions as I'm able to do so. I must do some technical things on the back end in order to prepare us for this potentially bombshell moment that could result in an order of exclusion from the witness list for Karen's experts from Arca. Now, stay engaged. Continue to assist your fellow towels understand the momentous implications of what is coming next, ladies and gentlemen. They need your help. Little Towel needs your help. By the way, this is a public information service, and Towel wants us to extend a huge thank you to the person who sent a donation earlier. I did the sign of the cross, but I wasn't on camera at the time, so just know that Little Towel sees you. Little Towel saw all of your super chats and was so grateful and beyond touched. Every bit of support you give me is extremely touching, but really the support you give each other is why I'm so honored to be able to help provide this public information service. But if you're new here, if you're returning, this is much like the BBC or PBS. It's a public information service. There's no sponsors, there's no ads, there's no anything. It is simply supported by you. If this is the kind of content you want to see, if this is the kind of content you like, you can find immediate donation info in the description of the YouTube. today's video, or you can find it right above my head. And then also someone asked earlier, way earlier, if I could share it in the chat. I do drop that every once in a while, every 90 minutes. I try not to overload you or burden you with these reminders, but think of it like watching PBS. Every 90 minutes, PBS really has to say, this content is supported by viewers like you. If you want to see more of this content, if you like this content, that's the way to do it, to either do acts of service for other people or to help this public information service grow. You can like the video, you can subscribe to the channel, you can become a member. There are so many ways. But if you want to help Towel directly, because I would like to get some more lunch. I don't think the 2 pieces of pizza, I guess it's 1.5 pieces of 7-Eleven pizza that I got, which is probably mostly sugar, was really enough to sustain Towel. Anyway, please don't already donate if you've already done so. Please don't donate again if you've already done so, or if it would be a burden. Always put yourself first. And obviously, if you're thinking, Grant would like me to donate to a cause, not even himself necessarily, just know that when you go and do that, I am just as pleased. And that's those small, kind acts of service are what could potentially change the way in which people think about the modern digital epoch and the rise of a new age. And perhaps it'll be based on toleration, compassion, and universal love, and a towel industrial complex that is benevolent and designed to facilitate intercontinental economic cooperation between the Americas to ward off the rise of the BRICS and protect the petrodollar. So if all those things sound good to you, please consider supporting Towel's public information service. Now, give Towel 1 second while I prepare a few things here. We have one thing that we need to do, which is get the way in which the Karen Cam functions is very finicky, so we have to prepare the Karen Cam for the top of the hour. We are not missing the Karen Cam during the Arca voir dire, ladies and gentlemen. Ladies and gentlemen, I tell you, I am a Towel. I am dedicated to my art form of broadcasting, educating, informing, and entertaining the public. And when I say, by God, that we are going to be the first people who find out when this goes into session, 30 seconds, 45 seconds, or otherwise ahead, I mean it, ladies and gentlemen. I am dedicated to you, the loyal Towel faithful. Apparently, I'm a good orator, too. Does require a sufficient amount of cocaine, though. Caffeine, my God. Towel will never do cocaine. First of all, because I'm pretty sure it would give me a heart attack. And second of all, because I would not touch a powdered substance these days if you paid me $1 million, because I don't trust anything that's out there, and I'm pretty sure half of it's some kind of dangerous, chemical from some other country that is probably going to kill me. So never in a million years will Towel ever do anything like that, I promise you. Just drinking this caffeine drink alone, which just is liquid caffeine with 1,000 milligrams of taurine and one other chemical, makes me able to provide these orations for 6 hours. So I don't need anything else, and I don't want anything else in my body, and God help the people who do that stuff. Oh, by the way, one thing I will say is I've heard there's a movement right now at music festivals and stuff to test for these drugs. So I don't condone you doing these drugs, but I also don't want any of you out there to die. And so if you are going to do whatever, please test your drugs. Please know what you're consuming, and for the love of God, please do not just ingest random substances these days, because I'm pretty sure it's like a 70% chance of death. All right, I think the government would be like, Towel, that was a great anti-drug public service announcement. You're welcome, government. You're welcome. All right, Towel friends. Yeah, Towel, I think, is seriously looking forward to this situation with Arca at the top of the hour. So stick with Little Towel. Now, the other thing is Little Towel needs to do a few things. First, I'm sorry if I missed any of your super chats or your memberships. I was focusing very intently on whatever it is. Oh, I was getting the Karen Cam prepared. Now, I'm going to return because I know you are all anxious. Stick with Little Towel. Don't get overwhelmed. I'm going to do this for you all. We have the Karen Cam. It's not ready yet, but as soon as it goes into session, I will bring it up on the screen, and that's about our 5 to 10 minute warning. The other thing I have to do is I have to see if anything new has been filed. I'm not seeing anything, but I'm keeping a close towel eye. Yes, and I know you all are having a lot of discussion about the John's last trip, the technical data. Folks, Ian Whiffin is coming back tomorrow. There will also be a redirect, and then don't forget that this technical data about John's movements comes up. Ian Whiffin is a data analyst. This is going to come up during Hank Brennan's accident reconstruction expert testimony. So definitely, folks, do your analysis. But remember, Ian Whiffin is not an accident reconstructionist. He is providing pure data analysis. And when we get to the accident reconstruction, remember everything Mr. Whiffin laid out. This is a foundation expected to come back in a loop, a Vico-cyclical Hegelian syntactical loop. And watch what Hank Brennan does with the foundation. So, that said, ladies and gentlemen, what else did I want to check on? Oh, that's right. Let us get prepared for ARCA. So, if you are just getting tuned in, if you're wondering, Grant, what is going on? Why is everyone calling this ARCA Day? Why is this like Christmas for the people who want to see Karen Reed held accountable? Well, folks, Karen Reed could lose her experts from ARCA. It's a very realistic possibility. We're going to see now why that's a possibility, and we're going to take a look at why this could be potentially so devastating for Miss Reed. And we're waiting for court to come back into session in just 45 minutes. Now, as you know, Little Towel, I say that I'm a little, I don't really want to talk for 45 minutes. Oh, no, we're going to talk for the next 45 minutes. It's not going to even feel like anything for me. I'm going to look down and I'm going to be like, oh, no, we're coming back into session. I can't believe that I had 45 minutes of things to say. We're also going to watch some clips as well to get you caught up on that ARCA situation. But I also want to be able to monitor. I know a lot of folks are nervous about this ARCA situation. I know a lot of folks are nervous. The Cellbrite expert did an excellent job. Hank Brennan bifurcated the presentation, which is to say, instead of Hank Brennan just presenting Ian Whiffin to talk about Jen McCabe's 6:23 and 6:24 a.m. Google search, which Mr. Whiffin did confirm. Hank Brennan also brought Ian Whiffin on the stand to talk about John O'Keefe's last trip over to Fairview Road with Karen Reed. Ian Whiffin confirmed that John O'Keefe's Apple Health data showing him going up and down 3 flights of stairs, quote unquote, was just errant data from when Karen and John were driving over to the house. The phone data showed John O'Keefe and Karen Reed basically in the car from 12:24 until about 12:29 or so. And then John O'Keefe's phone, after a small period of time, never moved again after taking a few steps and then going onto the lawn of Fairview Road. And then it never moved again after 12:32 a.m. on 1/29/2022 until 6:04 a.m. or so. Later that morning when Karen came back to Fairview Road with Jen McCabe and Carrie Roberts. Ladies and gentlemen, it was very, very quick. It was intense. It was easy to understand. And what the beauty of it was, Hank Brennan didn't just put Ian Whiffin up there to debunk the Google search, the nonsensical interpretation of the data from Karen's expert Richard Green, who's just a layperson basically compared to Ian Whiffin, who helped code the Cellbrite program, codes his own programs, is an expert in this whole entire set of data. It basically debunked every misread of the data by Karen Reed's expert, and it confirmed the Google searches were at 6:23 and 6:24 a.m. And then it got even worse for Karen Reed because Hank Brennan, he didn't use Ian Whiffin to necessarily lay out what the crash reconstruction, but Hank Brennan laid the foundation for a lot of technical data that's going to come up during Hank Brennan's accident reconstruction experts from Aperture. I promise you that, ladies and gentlemen. And that was absolutely beautiful. It was so well done overall. It overwhelmed the defense. Bob Alessi ended up only really being able to ask stupid questions that made no sense in a short cross that didn't go anywhere and sounded more like a direct. Bob Alessi is not suited to cross. And that was the morning. Hank Brennan took up the whole morning with his bifurcated direct with 2 main themes, confirming the 6:23 and 6:24 a.m. Google search by McCabe, and then moving right on to the main part of the presentation, which was about John O'Keefe's phone and its movements and its battery life as well. Not battery life, battery temperature, confirming that phone never moved after Karen allegedly struck John while backing up at 24.2 miles an hour with a BAC between 0.13 and 0.29 on January 29, 2022 at exactly 12:32 a.m. The phone never moved again until after 6 a.m. the next morning, and its phone temperature went down went down in a specific rate over that time. Never went up, never moved. Ladies and gentlemen, it was a devastating morning for Karen Reed, but I think we all know it's about to get a lot worse. It is about to get so much worse in so many ways, and that is a perfect transition for us to now talk about ARCA. What is coming with ARCA? How bad is it going to be for Karen Reed, ladies and gentlemen? Let's watch it together. Let's watch the last situation that happened with ARCA. Let us watch the last situation that happened with Arca. Where is it now? We don't want that. We want specifically the confirmation of the Friday voir dire. That will help us, ladies and gentlemen. That'll help us a lot. Where is that Here it is. Nope. That's the video. Nope. Where is the Arca voir dire confirmation? Nope, that was the video of Karen getting destroyed last week. Here it is. Here we go. We need to watch this, folks. If you're wondering what's coming up, you need to listen to this clip.
Your Honor, I did email
so we need to listen to
Mr.
this.
McDermott yesterday evening. He did speak with Dr. Wolf yesterday,
Oh,
and he is not available on Friday.
I'm going to make this play one more. I'm going to pause it. Okay, so ladies and gentlemen, let us listen to this, because what does this say? This video is going to tell us, remember, right before opening, Karen Read was banned from mentioning Arca entirely. Her own experts, right before opening, because of 105 deleted text messages. Now, this voir dire was supposed to be last Friday, but we are going to listen to a video right now that explains why it was moved to this afternoon and the heavy price Karen Read and her defense team paid for getting this moved to Monday. All testing must be done. This could be explosive, ladies and gentlemen. Let's listen. This, by the way, is a reminder. This is what the Arca voir dire is all about. It has multiple material misrepresentations to Judge Canoni. And now, after what was supposed to be a Friday voir dire that had already been moved up, that voir dire was not supposed to occur until the Arca witnesses were going to testify mid-trial. Got moved up already as a sanction for Read failing to comply with reciprocal discovery again under Rule 14. Read could well see Arca excluded today, ladies and gentlemen. The main thinking of the Towel friends earlier was Arca's testimony will be limited. Not necessarily due to its content, but as punishment for this Read's Rule 14 violations. But Towel's prescient prediction is Arca will be removed from the witness list, ladies and gentlemen. Arca will get removed from the witness list in Towel's opinion. Too many violations. There was a reason they couldn't mention them in opening. This is an evidentiary record to justify not just justify, but underpin Judge Canoni's exclusion ruling. We're heading in that direction. Ladies and gentlemen, we are heading in that Towel direction. Let me just tell you right now. And then as a result of that, what I want to do is I want to go back to that. Hold on. Stick with me. Stick with me, little towels. I want to go back to this video, and we are going to get a preview of what's going to happen at the top of the hour. Take it away, Elizabeth Little.
Your Honor, I did email Mr. McDermott yesterday evening. He did speak with Dr. Wolf yesterday, and he is not available on Friday. Is there another day that works for the court reasonably soon that we can have them come in?
We could do it tomorrow afternoon, if tomorrow is a better day for him. Yeah, they're just in Pennsylvania, right?
Could we do a Zoom hearing tomorrow?
No, he needs to be here in person. Mr. Alessi, I issued an order late yesterday. You were the one yesterday talking about this voir dire. I assume that you folks provided that order to the Arca witnesses. We don't have an address to serve them. We don't have enough time.
I provided a copy.
All right, so we could do tomorrow afternoon.
We have to make travel arrangements for them to get here. Yes. And he has a conflict that begins on Thursday and goes until Friday. So, is there a day next week that works for the court?
Well, we could do Monday, but what I'm going to order is if it's continued all the way until Monday, the testing that he outlined that you were contemplating or were going to do, that has to be done by then. So we can do it Monday, but that testing has to be done by then.
Okay, we'll make every effort to make that happen. I don't have a status on some of the shipping components that they need for the testing.
Okay.
So we'll do the best.
All right. So that'll be done by Monday. We'll do this Monday. I don't want to devote a whole day where, Friday was easy to devote a whole day because the jury thought they were only going to be here a half a day. Can we do this just in the afternoon?
Your Honor, I am unclear as to what the subject matter of the voir dire is going to be.
So I am indifferent to this voir dire. All right? I'm trying to help you out by having the witnesses here because I found a violation of your reciprocal discovery. So I don't know how long this is going to go. I would assume I'm giving you the opportunity to put them on and the Commonwealth an opportunity to cross-examine them.
First, in terms of time, we can do it within a half a day.
All right. Do you agree with that, Mr. Brennan?
Regarding an afternoon voir dire of Arca on Monday,
Yes.
We'll defer to the court whenever is available.
I mean, I'd like to keep the testimony going. I've already told the jurors that they have a half a day Friday, so Friday we'll be back to where we were at the half a day.
Will we have a chance to be heard on rulings regarding Arca? Because I still have the same concern about new information.
Yes. What do you mean? When?
Whenever it's convenient for the court, but I have concerns about these witnesses bringing in new opinions that we will not have an opportunity to consider.
All right, can we do that the day of the voir dire?
Whenever it's good for the court.
All right, so maybe we'll break with the jury at 12 on Monday. Now they're going to have 2 half days in a row, but we'll break.
Will we still do the voir dire and I'll have witness testimony prepared for Friday?
Yes.
Okay.
Your Honor, may I have one further follow-up question, please?
Yes.
Thank you. The reason I asked for, and I appreciate the opportunity for the voir dire, it's not lost on me. But what I'm trying to understand is I want to hit the target, whatever the target of the court
So
is.
one of the big concerns I have is that 105 or more text messages were deleted, and you said in due course. I have no idea what you mean by in due course. It's a pending case. I need to figure out that at least.
That's
okay.
And Your Honor, the 30-day, if you make the call, the defense has this very same issue with a matter with District Attorney Morrissey. So you said, I'm unclear of what deletions are, and we're happy to have testimony. The Arca witnesses can discuss it.
They're to bring them if they still have them.
Exactly. That is also very helpful. But this 30-day auto-delete, a lot of attorneys do that. District Attorney Morrissey did that.
I need something in writing about that. That's not my understanding on how you keep records in a pending case. And remember, you still said, out of the blue, months later, a bill came. This gives me pause about that, frankly. Okay?
We're happy to discuss that as well, Your Honor.
All right. So, all right. And there'll be more. I'm not limiting it to that, but those are my big concerns.
Appreciate it.
All right. Are we ready to start?
Judge, I just have
Yeah. So let's figure that out. Do you want to, what, let's see counsel at Sidebar about schedule.
Well, my name's GrantSmithEllis, folks. That was wild. You all saw it in real time. We are now at Sidebar because I think this means the view's back on for Friday if you were paying close attention yesterday. But you're watching it in real time. You were indeed watching it in real time, Towel friends. And now I have a poll. What will happen after Arca's Rule 14 hearing? Arca banned. Arca allowed. And then, hold on, one more option. Arca limited. Okay, ladies, gentlemen, fellow towels, what have you to say? What have you to say? It's going to be an interesting poll. There's going to be a flurry of activity. We're just over half an hour away. Most folks think Arca is going to be limited. Towel's prediction of Arca being banned is the outlier. Remember this moment, though, Towel friends. Towel doesn't just go along with the crowd. I'm thrilled you all have your predictions. Maybe you will be proven right. But Towel is saying Arca is going to be removed. I mean, I can't predict the future, but I'm feeling Arca being removed from the witness list. Ladies and gentlemen, it's what my gut's telling me, and the Towel gut is a strong force. Well, it's actually an immunocompromised force, but I'm a Towel. All right, ladies and gentlemen, we are almost there. 30 minutes left. We're going to watch one more part of the Arca Rule 14 voir dire saga because it's all been leading. Drop my water bottle. I only dropped my water bottle once today. It's all been leading up to this, ladies and gentlemen. It's all been leading up to this. It's all been leading up to this. Now, one thing I want to show you is regarding Arca. Let's take a look at the initial ruling, okay, related to Arca. Give me 1 second. So I'm going to pull this up for you on my feed, and I'm going to show you the original. Now, we're not ready to come back into session. The reason I know that is I would have it, we get a very quick update ahead of everyone else because we have the Canon cam. So stay tuned, ladies and gentlemen. I'm about to show you what I think is a very important component of this Arca discussion. The top of the hour, if you've been watching the Karen Reed trial, this voir dire hearing is huge. Now, I want to show you what actually got the actual moment that that led up to this. It was 2 moments. So what we need to listen to is the end of this Rule 14 hearing, which I found for you, okay? Now, let me read out for you. We don't even need for me to read out for you because I actually did an intro at the beginning of the video. We're not going to listen to Hank Brennan's arguments. Well, it's a good preview, but we're going to listen to Judge Cannoni's ruling at the end. 30 minutes away, folks. My name's GrantSmithEllis. It's almost the top of the hour. This is what folks have been waiting for, the Arca potential exclusion hearing. I'm going to be with you. I'm going to be here. I'm a towel. But I also have this for you. Here it is. Let's listen. This was the moment. If you're just tuning in, you just heard the clip play from Judge Cannoni, where Judge Cannoni said just right now to us, to the Towel Pressy and Towel friends, that we are going to come back for a motion hearing. The court pool feed cut, everything else cut, but little Towel keeps pressing away. Also, Towel is only 7 subs away. Oh, we might be coming back, folks. Now we are, oh, here we go. We are not going to listen to... Actually, you know what? Let's listen to Hank Brennan lay out why he wanted this Rule 14 hearing, because that's actually very important. Get ready, folks. We are about to, this could go on for a bit. We are about to hear a lot of information about Arca, but here's Hank Brennan's preview. If you've been wondering, what are we going to see at the top of the hour? I have a preview. Here we go. I'm a towel. Wait a sec, folks. As soon as we come back into session, Towel will have it for you. Here we go, folks. We're back into session. We're the only people who have this.
All right, so we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16, 2025 Arca discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is that the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential Arca witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Rentschler. That does not reconcile with the past positions and representations of the defense to this court, to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the Arca mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was an order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of Arca's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that Arca should be ordered and required to provide that evidence as well, so that we can see what is there It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of Arca testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with Arca. They could have called any expert, asked any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Procedural come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi's issue, I'm going to ask you to be as brief as you can be, please.
Hold on. I'm back. I'm going to spare you all. I'm going to spare you all. I'm not going to make you listen to Bob Alessi yelling for 15 minutes. I know you are all excited. You wanted to hear Bob Alessi yell for 15 minutes. I'm not going to do that to you. I'm a towel. I'm an honorable towel, and I would never, ever do that to you. But you know what I will do, ladies and gentlemen? I will play Judge Cannoni responding to Bob Alessi, which is even better. We get all the benefit, none of the fluff.
I presumed you were...
Hold on.
Every one of the ghosts in 10 seconds. There are no violations of any discovery order, no violations of this court's order. And with regard to the retaining of Arca, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with Arca, the statement I'm going to make. To this date, Arca still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion.
That has nothing, Mr. Alessi, to do with the Rule 14 compliance, and you know it.
But we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right, so as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk to ARCA and I've got to understand what they have and what they don't have. So I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
And I have that order, folks. We will look at the ARCA order right now. Give Little Towel a second to get this screen out of full screen. But yes, Little Towels, that's what's going on. 20 minutes away. We are just 20 minutes away. It is happening. It is happening, Little Towels. And Towel has Judge Cannoni's order, too. Hold on. I'm a Little Towel. I have it right here. Look at me. I'm a towel. There it is, towel friends. Judge Cannoni's ARCA order. It's going to be brutal. I can't, well, actually, hold on. I have a towel plan. I have a plan. I am a towel with a plan. I will not be deterred in my efforts to show the towel friends a more zoomed in picture of this document. I have succeeded, towel friends. It is a glorious day. It is a glorious day. I accomplished what you wanted. Towel friends, I am a towel magician. You may refer to me as Mr. Magician Towel. I make large pieces of text appear on the screen. It's the final countdown, says Angela. We are into the last 19 minutes, ladies and gentlemen. Ladies and gentlemen, get your horses in. Get your numbers in. I did make the picture bigger, Drew Drops. Oh, yes, that's why I did it, because I saw your wonderful comment. It's the final countdown, ladies and gentlemen. This is what ARCA was ordered to bring. I enlarged it for you because I'm a towel. Look at that. That's it, ladies and gentlemen. That's the order. You can see it on your screen. It's everything. That is what this hearing's about to be about. Little Towel is so efficient. Hold on. Did Little Towel zoom in a little bit too much? Yes, he did. Hold on. I was so proud of myself, and then I realized I zoomed in a little bit too much. Hold on. Little Towel will not be deterred. I am a towel. I think my excitement about this potential Rule 14 hearing is coming through the screen. One time I said to a presenting guest lecturer in class, I was like, I'm really interested in the McCarthy, Odell, DiBenedetto, and their progeny. And he was like, you are the first person I have ever heard say that. And this was like a practicing trial lawyer. And I was like, well, I'm a towel. That's it, ladies and gentlemen. That's the order. That's the subject of this Rule 14 hearing. It's up on your screen. It's going to be intense. All the towels are ready. The towels are gathered. We are just waiting, ladies and gentlemen. It should be in the next 7 to 10 minutes that the Zoom turns back on. Then the Karen cam will turn on. No jurors. And we will sit there. And we will be towels. And we will watch in real time. We will attentively, with all of our focus, we will watch. Towel Attenborough will take his position, observing the Karen in her natural environment, the Karen Reed in a courtroom where she belongs, charged with killing John O'Keefe while drunk driving with a BAC 2 to 4 times the legal limit at 12:32 a.m. on January 29, 2022, while going 24.2 miles an hour in reverse, reducing to 23.7 miles an hour in a millisecond, with a 4.7 degree correction of the steering wheel, immediately allegedly upon the moment of impact with John's body. Karen then allegedly left John to die from a traumatic brain injury in the snow, which, coupled with the onset of hypothermia, as indicated in the medical evidence by reddening of John's pancreas, caused John's death. Ladies and gentlemen, the ARCA hearing should be starting in the next 15 minutes. This is the order that ARCA was given. This is the documents they must bring. What is going to happen? The world awaits. Not just the Karen Reed trial world. I would dare say some elements of the legal world await. The crescendo of months and months of Karen Reed's team misleading the court about ARCA, deleting hundreds of text messages. It's all leading up to this. And you are here with commentator towel, ready, prepared, attentive, fellow towels. We are this moment. It has been long awaited. We are just 15 minutes away. Most people do not treat Rule 14 reciprocal discovery voir dires with this level of intensity, but you are watching David Attenborough / racing commentator towel. We've located Chewbacca and the Stay Puft Marshmallow Man. We've prepped for this Rule 14 voir dire. We are ready. We are the informed, erudite, and cogent towels, ladies and gentlemen, and we are just 15 minutes away. And Towel did indeed talk through the lunch hour as he promised to do. Towel did not actually get lunch, but that's okay. What are we now? 6 hours in. We are 6 hours into today's stream. Towel is still going, still talking, still excited for the top of the hour. Perhaps more excited than earlier today. These are the moments, friends. These are the moments. I'm grateful to be among all you Towel friends as we await this 2 p.m. voir dire. What other stream is so fully caught up that they know exactly what is going to happen at this voir dire? What they have seen previews. What other stream? None. Just the Towel friends, the documents friends, the streams, the hearing overviews. We have done it. We have prepared ourselves. We have absolutely prepared ourselves, ladies and gentlemen. I am proud of all you Towels. I'm proud. I am exceptionally proud. You all together, stitched by the fabric of your shared knowledge, have woven a towel universe defined by compassion, toleration, and erudite participation in the digital public sphere. Oh, Towel friends, Towel is so pleased to be able to be with you in these moments. There is something to be said about the stillness and solace and calmness that comes with preparation. And yes, we don't know how the hearing will end, but going in, we know that as Towels, we went fully prepared into battle, armed with the knowledge of what a Rule 14 reciprocal discovery compliance hearing is, what the subject matter of the hearing will be, how bad Bob Alessi's going to look, how angry Judge Cannoni's going to be, and the very high probability in the eyes of the Towel, this Towel at least, of the potential of ARCA being excluded from Reed's witness list. Yes, ladies and gentlemen, you are here. Towel is here. We are all here together, and I'll get your comments back running again. Sorry about that. And ladies and gentlemen, here we go. It's not time yet. I don't see the Zoom having opened, but I know that the court staff have probably finished with their lunch. Karen Reed and her few remaining family and supporters, they drink their champagne in a cratered Riken plots. The bunker from the seaport to whatever room she occupies in the courthouse now, shelled by Hank Brennan's artillery. The walls collapsing. The paint chips falling. Karen Ava Brown Reed dances oblivious to her pending doom. And Hank Brennan, calm, cool, collected, awaits ARCA's march into the courthouse for their reckoning. Ladies and gentlemen, we are here. The pretextual federal investigation is over, and all that's left is this moment of reckoning for ARCA. It must weigh heavy on the souls of those who participated. ARCA, Karen Reed's defense, Reed herself. We are just 12 minutes away. It is unlike any space shuttle launch, ladies and gentlemen. It is unlike any other type of event you can witness. With the Karen Cam, with the commentary, with your fellow towels, it is the moment you have been waiting for. There's no sporting event like it. There is truly no comparison. hanging with your fellow towels, awaiting a Rule 14 reciprocal discovery compliance hearing. Yes, not even the invasion of northern France, a peaceful invasion with non-lethal towels, will ever replicate the feeling of what could come out of this ARCCA hearing. Yes, towel friends, even obtaining a homeland for our towel anthropomorphic people will not be able to render what this could be, the importance of today. And yes, yes, ladies and gentlemen, this is the moment. And what else can we do in moments like this other than simply be here? We are prepared. We are informed. We know the context. We only now must wait to ask, how will the moments play out? And yes, the shared anticipation rises. The nerves, the tension, it all bubbles to the top. And there's nothing you can do. Friends, there is nothing you can do. You must simply ride the wave. And as we approach the top of the hour, you must gather together your thoughts. You must gather together your snacks. You must gather together your fellow towels and washcloths and soap dispensers and flannels and towelettes and beach towels and paper towels and hemp towels and all of the towels that are in the constituent towel universe. And you must simply set your eyes to wonder and and gaze with wonder upon what is about to occur. And yes, towel here with you to provide this wonderful commentary as we move into these last 9 or 10 minutes. You towel friends providing each other's camaraderie, being wonderful with each other, welcoming new honorary towels into the fold. That is how we shall spend these last few minutes together as we await the start of the 2 p.m. hearing. And Towel's oratory skills, I feel like, are developing into some type of Humphrey Bogart Casablanca-esque speech, wherein I have developed a lyrical and rhythmic tone to my intonation and delivery and syntactical precision. And I simply can go along with you and ebb and flow with the natural breaths of my speaking pace and tell a story as literary as it is philosophical, as towel-based as it is rooted in reality, as much a commentary on a Rule 14 voir dire hearing as it is a moral reckoning for Karen Reed, her defense, and 2 people from Arca. Yes, ladies and gentlemen, that is what is going on. It is the crescendo of Karen Reed's misdeeds, indeed, Trevor McIntyre. So well said, ladies and gentlemen. I think these words cannot do justice to this anticipatory moment. There is nothing that can truly explain the energy that is in the air of those who follow the Karen Reed and John O'Keefe trial. But try as I may, towel friends, to embody the sentiments of that non-temporal energetic charge, I will always fall short. Asymptotic as Towel's relationship with universal truth may be, and perhaps fittingly so, the inability to truly codify and syntactically explicate this feeling of anticipation is a testament to the true reality that some emotions, some moments, some hearings are rightfully beyond full description. My name's GrantSmithEllis, ladies and gentlemen. It is 1:52 p.m. We are heading into the top of the hour. We are waiting for this court Zoom to turn on. We are waiting for the court cameras to return. The world turns its eye to Judge Canoni's Norfolk Superior Court in Dedham, a place in time unlike any other, where perhaps the world, at least localized to that small courtroom in Dedham, will stand still. The eyes of multiple nations, multiple states, multiple towels, affixed, unable to avert their gaze, as Karen Reed's and Arca's pending reckoning plays out in real time. Yes, ladies and gentlemen, the towelettes are here. The towelettes who have taken center stage in the Karen Reed and John O'Keefe trial, the only people among the towel fold who were mentioned by a witness, the towelettes. We are all here. It is almost the moment. What else can you say in these moments, friends? What else can you say other than it is almost time? It is simply almost time. And I will be with you right until the top of the hour. GrantSmithEllis, honoring this towel public information service rooted in principles centered on engendering cogent public participation by way of informing, educating, and entertaining the public at large, and potentially building a towel-based empire to protect the petrodollar and ward off the rise of the BRICS via inter-American economic cooperation centered on the production of towels. But there's a lot to that plan. It involves teaching Semolina Spanish, and puedo hablar y entender español. Así. Pero no creo que poder atender Sema. Todas las palabras en la idioma de español en 3 meses. No es posible. Creo que es imposible. And what I was saying there is, I just don't think I can teach Sema all of the words of the Spanish language in 3 months in order to send her to Latin America and facilitate the rise of this towel empire. But, as you know, moments of levity are the price you pay, ladies and gentlemen. Moments of levity are the price you pay. All right, it's 1:55. It is almost time. We should be coming back into session any minute now. The world awaits. The cameras await. The towels await. Can it get any more exhilarating, towel friends? Can it get any more exhilarating? Claro que sí. Claro que sí. Yo creo que hay mucha gente aquí que poder hablar o que pueden hablar español. Pero las personas que no entienden español, those people must be very confused. And I don't think a lot of you understood that Towel speaks fluent Spanish, actually. Towel has been able to do so for many, many years. I'm not exactly sure why. Sometimes I just randomly start talking in I just randomly start talking in Spanish. Turtle Boy's probably having a meltdown right now. His world's collapsing and it's about to get even worse. I somewhat want to look with bemused curiosity, but I'm not going to do it because I don't take his perspective seriously. Oh, I see some of us do speak Spanish. Yes, yes, thank you, goodbye. Sí, Harvard Yard. Hay una idioma muy importante para toda la gente en el mundo. And towels mundo. I probably should use the word, learn the word for towel. I probably knew the word for towel at one point on a quiz in Spanish, but I do not just know it offhand. I wish I did. Yo también. Sí. You as well. I'm glad to hear that. Ladies and gentlemen, it's 1:56. The court cam is still not on. Towel is with you. The world awaits. There is so much eager anticipation. I can sense it building. I can sense your anticipation. I only wish I had a time machine so I could move us forward 3 minutes in time. But this is it. After all the wait, we're down to the final 180 seconds. You made it. You made it. You even started to learn some Spanish. The tone of my voice indicates how intense this is. I don't know what's going to happen. Let's see how our poll did. How are the towel friends feeling? Toalas. Toala? That sounds like a koala. Have we considered if we can integrate koalas into our plans for world domination based on the towel empire? I just feel like, I just feel like koalas deserve our support. Koalas are wonderful animals, and if we can integrate them somehow in... Oh my goodness, folks, the court camera's on. It could be starting. We could be about to start. Ladies and gentlemen, get ready. Are you ready, ladies and gentlemen? Can you feel it in your bones? It's almost time. I tell you, it is almost time. Hold on one second. I'm going to have to rebuild the Karen cam. Ladies and gentlemen, it is almost time. We are just waiting. I'm going to give you an early peek. Hold on. Stick with towel. Where is it? There it is. Ready, ladies and gentlemen? There it is. As soon as that turns to the Karen cam, we are ready. Save the koalas. Arca cannot be saved. The koalas might be able to be saved, though. All right, we are waiting. We're waiting. Patiently waiting, observing, watching. Ever vigilant towels. This is the moment. This is the moments, ladies and gentlemen. Dixie Doodle says they feel like they're at the horse track. The race is about to start. The horses are lining up. Arca's penned in. Number 7 takes the stage. I don't know what horses do. They enter some kind of pen before they're released to run. I have really thought too much about this. Dear God, it's about to start. I don't know what to do. I'm completely overwhelmed. This is it. We've reached the point where Towel himself has become overwhelmed. All I know how to do is describe to you the intensity of this final 60 seconds. The court should be ready to return any moment now. I have 2 screens. I'll be ready no matter what. We'll hear it first come through this Zoom webinar. The Towel friends are ready. It's like we're at the Olympics. I'm somewhere between Howard Cosell and Walter Cronkite. I'm breathless in anticipation. The fate of the very concept of a Rule 14 voir dire is at stake. Oh, friends, oh, the implications. This is bigger than a man running backwards and catching a baseball while facing away from home plate. Willie Mays. This is bigger than the guy on the Dodgers who hit the home run with a broken leg. Donald Gibson or something. I'm not going to say it's bigger than the Red Sox winning the World Series in 2004, but it's certainly like within the top 20 events. I tell you, ladies and gentlemen, I have done my best to emphasize the importance of what we're about to watch. And you all have discovered Towel apparently has some kind of announcer voice. I didn't know it was a thing. The horses are at the gate. The Arca is at the gate. Release the Hank Brennan. Apparently there are people who are very pleased that I giggle randomly sometimes. Oh, ladies and gentlemen, the horses are at the gate. I don't really know what they do from this point. Apparently we lift the starting gate and then they run forward and their goal is to go around in a circle. I think that's what Bob Alessi's going to try to do. I don't think it's going to save him. Hank Brennan seems to understand how to actually proceed in a linear fashion to the finish line. We are moving towards the final minutes here, folks. I think we'll call Judge Canoni the race official. She is gathering the horses at the gate. Arca are the horses. It is a terrible day for them. We should really be nicer to our horses, but no one is going to be nice to Arca. This is the Monday Night Football of voir dires. We need some kind of song. It needs to be done by that country artist who did the first Monday Night Football theme. It's Hank Brennan and Arca on Monday night. It's football night. It's Karen Reed trial night in America. Rally the towels. Somebody find Murder by Maestro. Somebody make sure that northern France is distracted so we can take over their territory and create a homeland for towels in a peaceful fashion. Oh, ladies and gentlemen, it is past 2 o'clock. Judge Canoni, stop tormenting us. The world wants you to come back into session. We are ready. We're here. Please. Actually, you know what I can do? Hold on. I'm going to go off the screen, even though we are not ready to come back into session, and I'm going to rebuild the Karen cam. And as soon as we do go into session, you're going to hear it here first, folks. You're going to hear 30 seconds of news over the Zoom, and then sound over the Zoom, and then we are going to jump right to the voir dire. Ladies and gentlemen, this is the Monday Night Football of trial watching streams. Apparently, I don't really understand. I'm a towel. You're all towels. Everybody's a towel. And I am preparing the Karen cam. Yes, the Karen cam won't be making a return, ladies and gentlemen. I'm sure you're all exceptionally thrilled. The fan! We must be close now. The fan is here, ladies and gentlemen. The fan can only mean one thing. Towel resents the fan, but in this case, I'm willing to live with it. I'm even willing to say that I'm okay with the fan in this moment. because it means it's almost time, ladies and gentlemen. Yes, it is almost time to begin the Rule 14 voir dire hearing, which apparently is akin to some kind of major sporting event, although Towel doesn't really watch sports. So I did a little bit of a difficult job explaining the horses at the gate, but I think we got the concept. Arca are horses. They're lined up in some kind of pen, and Bob Alessi's going to run them around in a circle and go nowhere while Hank Brennan gets to the finish line. I think we managed to put it all together, ladies and gentlemen. We got there eventually. It was a joint Towel effort. The Arca voir dire is about to start. I tell you, folks, there's only a certain number of people who get truly enthralled and excited for a Rule 14 voir dire hearing, but they've all gathered in these comments, and Towel is thrilled to have you here. It is almost time. We watch the fan pensively. Towel Attenborough. I'm so loud that I've scattered all the animals. Me filming the documentary about the natural habitat of a Karen Reed has completely gone out the window. I am just at this point yelling. There's nothing anyone can do. I have channeled my inner Bob Alessi. These moments, folks, they are too intense to bring words to appropriately. I must only use the intonation of my voice and my breathless posture and somehow explain that this is akin to a large sporting event, because that's what people understand, in order to emphasize the importance and weight of this moment. Yes, I am a Towel, and I am standing here proclaiming to you the importance of Rule 14 voir dire hearings. You can't actually tell me you're bursting out laughing, because then I have a mental image of you bursting out laughing, and I think that's hilarious. Oh, goodness, ladies and gentlemen. We truly have taken the Towel stream to another level. I have channeled my inner Howard Cosell, or the man who was on channel Walter Cronkite, and now we are watching a fan together. The most anticipatory watching of a fan in the history of trial streams. You all are here for it. We're here together. These moments are being experienced in real time. Where else can you get these type of moments? Nowhere else, ladies and gentlemen. And if court could just come into session, I would really be so pleased, because I can only talk with breathless passion for so long. This apparently puts a lot of strain on one's ability to take air into one's lungs. I had no idea. I don't think that sustained horse racing commentary is really a viable career path. I'm not even sure horse racing lasts this long. We've gone through like 4 horse races since we were supposed to go into session. The crowds are just furious. The horses are going at 3 miles an hour. One of the horses is eating grass. I'm pretty sure that's Bob Alessi. He got distracted. It's like that famous skit from Monty Python when the philosophers try to play soccer. We put Bob Alessi on the horse track. He went into the grass. He found a redneck drinking beer. He started explaining to the redneck about something or another. It was very convoluted. I think he was talking about Chewbacca. And then all of a sudden, a bunch of the other horses finished. And now we are sitting here waiting for Bob Alessi to stop lecturing people in the infield grass of the horse track about Chewbacca. Yes, that is where we are at, folks. I hear it. We might be ready. Here we go. It's time.
Why not, Grant? For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions. Thank you.
We're back in session. You may be seated.
Why not, Grant?
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the Arca witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the Arca witnesses or to exclude their testimonies. Upon that, I believe I issued an order last week for certain discovery to be provided and to be provided by Arca. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning Arca in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So, Mr. Brennan, who are we going with first? Dr. Wolf?
Please.
Okay.
Face the clerk and raise your right hand,
please. You solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Can I
All right, go right ahead, Mr.
Thank you. Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So we
order?
need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little last year, I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to... Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Miss Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Ms. Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please.
Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Ms. Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially. Again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCA. So That's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you on March 20th, 2022, not the 22nd, not the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
Okay. The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case?
Not work with. We could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring to?
Do you remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April still?
Yeah, I'm still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir, and it was all laid out in the report that was issued in February.
I understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never ever talked about this case?
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So, yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can we approach, please?
Who asked me that?
Me, Your Honor.
Yes. Come on over.
Oh, towel friends, I'm still here with you. Hold on. I'm here, towel friends. It's me, GrantSmithEllis. This is wild. This is going very poorly for Karen Reed. Oh, my word. I can't believe this. ARCA failed to comply with the court order. They didn't even send the documents to Judge Canoni. This is as bad as it can possibly be for Reed. Oh, my word. I can't believe it. I literally cannot believe this is happening. Alan Jackson is floundering. Karen Reed is floundering. Bob Alessi's floundering. All they know how to do is just beg for a sidebar. The witness from Arca just got rid of his phone in November of 2024. Oh, towel friends, this is so brutal. This is going to get so much worse. Hank Brennan does not mess around. I've seen Hank Brennan be in front of a jury now, and I've seen Hank Brennan in front of just a witness who he knows is screwing around. Oh, my word. Towel friends, this is simply incredible. I cannot believe we're all seeing this unfold live. I'm still trying to get caught up with all of your comments. We are at a reset. We are at a sidebar right now. Keep your eyes peeled, towel friends. Keep them peeled for the return. This is going to get worse for Arca before it gets better. Hank Brennan is on a mission right now. Hank Brennan is a man on a mission, I tell you, ladies and gentlemen. A man on a mission. Now we should be returning to session in about 20 seconds here, ladies and gentlemen. 20 seconds. Get ready. I'm a towel. Here we go, ladies and gentlemen. Here we go.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about Arca, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about Arca?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
Mm-hmm. And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Yeah. So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling, no, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, Did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
Objection, Your Honor. So next question, no comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you were?
I just said I delete texts routinely. You're asking me to specifically give you a location and a time when I deleted those? I don't recall that.
You said it was after the trial?
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted act when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson.
Don't know. How many times did you use Signal with the defense to talk about this case?
Objection, Your Honor. Going to allow it.
From what I recall, was probably a handful of times.
When you say what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right, I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you've talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal, the 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes, yes.
Are you putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
Mm-hmm. How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
Can you answer that? How confident are you, Dr. Wolf?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider, right?
Yes.
Okay. And Signal is a communication, isn't it?
Certainly.
You looked at all your records and knew it listed the text messages and the phone calls. You knew that, right?
Yes.
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
Yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your Signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the Signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
Mm-hmm. You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
Mm-hmm. During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the first
So there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not...
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. You know. So, did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without the qualification, the simple question is, you've met Kat, haven't you?
I think I met her, it was either at the voir dire day or the trial day, yes.
Mm-hmm. Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street, and I think she walked me over, and then ultimately when I was done, I think she walked me back to the lot.
Did you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
Okay. And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
Well, I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe... I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Objection, Your Honor. I'm going to allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face-to-face,
yes.
Right? Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. he would give me some information about the scheduling and kind of when we would need it. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. And I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
okay.
Yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
Okay. You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
Okay. So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
Well, so you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here, because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Showing you an email. Do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
Okay. And what's it labeled as?
Wolf Direct.
And that's before you testified on trial 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified?
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
Okay. You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I get that, please? There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1. Exhibit 1.
So you assisted the defense before your testimony.
Hold on.
Where's the one with the comments? Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question
Hold the comments, please.
My question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor. All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Objection, Your Honor. Sustained.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your question.
You don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your Honor. I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely, and it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here, under oath, before this court, that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That's the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that point was understood, to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
Oh. And then, do you defer to the defense, not the jury, trying to give the full story to the jury, do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Question, Mr. Brennan, then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions. 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there,
Well,
sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to... Okay.
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one?
Yes.
Memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again,
Court, you had never met Attorney Jackson face to face?
Correct.
Right. But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
Arca did send an invoice afterwards, yes.
Did you talk to Arca about that? About the billing in this case?
No.
You submitted your bill? Yes?
Arca submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement, and ultimately he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson I don't think felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not me.
I understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it,
Right.
yes.
It doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking about.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, again, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
Okay. And, sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Mr. Lessie, do you have anything?
You do, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, we know how much time Mr. Brennan's...
I'm just asking you.
I hope so, Your Honor.
Okay.
May I approach the witness?
Yes.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing record.
Sure, we can mark it.
Yeah, that's exactly. Thank you.
Exhibit 2.
Thank you. I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that?
Yes.
Thank you. Take that, Judge. You're with me, Your Honor? Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within Arca's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with Arca comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that Arca had in our possession, we produced.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was Arca under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at Arca for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in Arca?
Well, let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have, from any time in 2024, any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
Let's now go to your first interactions with the defense. As I understand it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness?
Yes.
Thank you. Your Honor, what I have is the entire production that Arca made. I think it would ease in terms of the...
Sure, he can have it.
Thank you. Use that pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial, before you took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCA was working for the United States Department of Justice, do you know whether ARCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, did the federal government prevent ARCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Okay.
Are you there, sir?
Yes, I think so.
Okay. Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that Arca would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the Arca main line on March 20th, 2024 at 7 a.m., and that's Pacific Standard Time, so that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes, and as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from Arca to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes. I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at Arca. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No. Again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet, so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
right,
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
And for any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay. Right, so the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m. I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait, basically, until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember a part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics, and when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea, hey, can you come this day, right? And then I would relay that to Dr. Rentschler and say, yeah, that works for me. So then I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing.
About whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Now let's go to the next tab with regard to the outlines that you were asked on direct examination by Attorney Brennan. You've described this situation, well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government, there's rules of the road, so to speak, as what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No. As I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you, before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline and that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to, in any way, favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that, I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours, in your mind, to help the defense more than to help the Commonwealth?
No, it's impartial, and I will note I give numerous presentations, and I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic, and I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Do you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? Do you remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that Arca was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December of 2024. Were there any conversations from the end of the trial until December of 2024 other than logistics? Was there any conversations of any kind? And please summarize briefly what they were. Or texts.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Now let's go to this year. Did the defense approach Arca to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding Arca and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end, and I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
And in the case, I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, etc., do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, etc., did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report in PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take ARCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson I indicated to him on the 26th that we did have authorization to move forward. He immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative term, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Rentschler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at Arca to work on this matter?
Absolutely. Work and personal things.
And personal things, what did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So
it affected his personal life, I understand.
Okay, I'll move on, Your Honor. With regard to the work, you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
Correct.
You said you would like to have had more time, correct?
Correct, but I understood Your Honor's order, and I wanted to meet that deadline, so I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline, and we completed our testing.
And with regard to the testing now that you've worked on, that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does Arca have in mind, any further testing that you need to do, or have you completed what Arca needs to do with regard to fairly and properly responding to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video, so it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, to my next question, which is there's nothing that you have that you've done that hasn't already been produced pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
how long on an expedited basis? Well, let me ask it. In the ordinary course, how long would it take you to do this last part of your work? In the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping, if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
That's all I have at this point, Your Honor.
All right. Mr. Brennan?
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that.
And
no.
the file in its entirety was turned over by February 5th? Did you know that?
Objection, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing and report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as Arca, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now, so wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True?
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information. You said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, Arca's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by Arca or the defense to try to facilitate an agreement that the defense could use Arca as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use Arca in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use Arca, or specifically you and Dr. Rensselaer, in late March of 2025?
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the Arca issue was being litigated, and I think that Like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Rentschler so you could review the materials?
Objection, Your Honor. Do you know? Do you know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense or the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No. It was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. Do you recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
So, as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month, to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new, and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one, so
okay.
No, I want you to focus on.
Okay, no, that was not produced, no.
You never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welcher's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided in
so
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round...
I don't think I am.
Objection, Your Honor. You should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's not what I'm asking
We have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
Okay, hold on, towel friends. I'm still here. My name's GrantSmithEllis. This is becoming a very intense situation. Karen Reed's experts from Arca very clearly are playing games. They may have they deleted more than 100 text messages with Reed's team, and this is only the first expert from Arca. This voir dire may well need to continue tomorrow. We don't know what's going on here, friends. I'm going to zoom through this. I'll be with you. So we actually can zoom forward a little bit here, friends. We can zoom forward on the main stream. Bear with little towel. We should be coming back into session here, folks, any second now. So it looks like we're going to continue with Hank Brennan asking questions of Dr. Dr. Wolf. Stay with Little Towel, friends. Here we go. We're back in the session.
And let's bring Dr. Rentschler in.
Oh, we're going right on to Dr. Rentschler. Get ready, folks. Get ready. I'm a towel. Judge Canoni cutting that off makes me think she might be moving to exclude Arca. She didn't need to hear more. Oh, towel friends, get ready. My name is GrantSmithEllis. I'm here with your towel friends. We await Dr. Rentschler, the next Arca witness. There he is. Oh, this could be brutal.
Do you solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Dr. Rentschler, this is going to be very quick. Go ahead, Mr. Brennan. We just need his name.
Good afternoon, Doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
In a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe one or two phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than texts or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I...
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
Well, I don't believe that Arca has any specific policy for that, no, sir.
Mm-hmm. Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
Well, certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
Well, it certainly helped prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order? That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness, so before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an opinion.
You make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done?
No, not yet. Okay. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it, yeah.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I'm going to see counsel at Sidebar for 1 minute.
Down, follow me.
Sidebar. It looks like the day is going to come to an end after this sidebar, towel friends. You saw it all happen in real time. That was absolutely incredible. Judge Canoni may well order Arca to get this done before May 7th. Arca may have been trying to spring this at the last minute on the prosecution. We're going to wait and watch and hear what they say.
Thank you.
All right, that's it for the day. That was the end of the Arca voir dire. I'm sensing something very bad could happen. At least is going to be ordered to produce this report earlier than May 7th. My name's GrantSmithEllis, towel friends. Let me come over onto the screen and give you a recap. That was a wild day. We are over 8 hours, towel friends. I am so grateful that so many of you stayed engaged. I'm so sorry there was that slight technical hiccup. Although the streams both stayed up, which is great, the actual software facilitating that stream going out to you all had a bit of an issue. But needless to say, we're back. I'm still with you, towel friends. My name's GrantSmithEllis. That was an explosive day, from Ian Whiffin's testimony about confirming Jen McCabe's 6:23 a.m. and 6:24 a.m. Google search, to then Ian Whiffin confirming John O'Keefe's phone never left the yard of Fairview Road based on its battery temperature and movements after 12:32 a.m. when Karen Reed is alleged to have struck John. Let me pause that. My word, towel friends. My name's GrantSmithEllis. I'm still here with you. You all saw that happen in real time. I'm still reading your comments. Oh, sorry. I didn't mean to yell. Towel forgets occasionally. Oh, hold on. Fixing mic. Bear with me. Replugged in my mic. Please let me know if the sound has changed. I'm sorry for the fact that it went a little fuzzy there. We should be coming back with you now, and I hope things have improved. All right, folks, so now we have some sense that at least Judge Canoni is going to order this Arca report to not be on May 7th, which would give the prosecution no time to respond before Arca testifies. May 7th is almost a week or 10 days away. My name is GrantSmithEllis. We just watched some very serious things happen, towel friends, and I have also re-plugged in my mic, and I'm glad that it sounds better. It seems like that was an issue with the microphone cord, which I have now fixed. Ladies and gentlemen, that was a lot very fast. This towel stream has been going for over how many hours? Almost 9 hours, and I feel like that was very intense, and we are still going. I'm going to, do I think Arca will be allowed in? Judge Canoni didn't seem to want to hear a lot more. I think she's very concerned, and I am leaning towards potential exclusion. Now, let's do something special for all the towel friends. Look at that. Look who's the star of the show. You, towel friends. You are in the position of honor. Look at all of you. Look at you all are in. Wait, there's no sound? No, there should be sound, Angela Whittick. I'm seeing sound on my end. So just double check if you might be a little bit behind. You might be at the point where I had to change my microphone settings, but I think we're back. Now, towel friends, let me tell you, that was quite a series of developments. Now, Alana is saying it sounds like she's not going to exclude. Alana, it is very interesting to think about how Judge Canoni said she was thinking about ARCA trying to give this report on May 7th. Remember, Alana, we have a situation where ARCA did not comply. Okay, sounds good. I appreciate that the sound is good. We just had a situation where ARCA admitted multiple times that they didn't even comply with Judge Canoni's order. They sent it to the production to the defense, not to the court as they were supposed to. They deleted a bunch of messages. Wolf got rid of his phone last November, coincidentally, and the DOJ allowed Wolf to violate Judge Canoni's sequester order. Oh, sorry, Angela Whittick, I apologize. I myself was getting a little bit animated and intense, and also, in my defense, I was also talking like a horse racing announcer earlier, so I was stuck in that mood a little bit. But yes, you all are making your comments right now. I could not keep track of all of your comments earlier, but I want to do a few things. One, I want to point out that Dr. Wolf's wife is a Free Karen Reed supporter. And that was some intense moments there when Hank Brennan was asking him. I didn't think it was going to go in the direction of the DOJ having facilitated ARCA violating the sequester order. That's not where I thought they were going. That was shocking. Furthermore, Wolf brought up his wife, who was discovered to be a Free Karen Reed supporter. And that was not even the most intense moments of the day. That was just so intense, ladies and gentlemen. Who was discovered to be free, and that my word, friends. I cannot believe we all just experienced that, and he was using Signal to communicate. They were clearly attempting to hide things, in my opinion. That was incredible. I do agree that, and it was the old DOJ under Rachel Rollins and Josh Levy, folks. That's what I believe was happening. And I think that DOJ had a grudge against the Norfolk District Attorney's Office. Yes, Wolf's wife is a Free Karen Reed supporter. And that was what they were talking about, how people uncovered it online. Oh, my word. I can't believe the bombshells. They just continued and continued and continued. That's what I'm saying. I think Judge Canoni has to take the court just closed, but I think the Judge Canoni has to take a serious look at this. And yes, I'm doing my best to be zen, but let me explain. If I were hearing things in that voir dire that made me say, oh, well, at least ARCA had this to lean on, or at least they could argue this, I would be saying to you, yeah, in general, I think, Hank Brennan really could have gotten them excluded, but they have just enough cover. No, folks, they're checking all the boxes here for exclusion. Judge Canoni could potentially split the ruling. That's a great question. But no, I'm seeing a situation. What day is it, by the way? Oh, yes, it's Monday. But I'm seeing a potential situation where, because ARCA didn't actually turn over records to the court, then they tried to say they were going to hand in their report on May 7th when Judge Canoni had ordered it to be done, all the testing and such, and by today or something. All of this is leading me to think we're going to get some kind of ruling. I don't know how intense it's going to be, but I am not feeling confident in the least that ARCA was able to justify any of the Rule 14 violations. They made that situation far worse, folks. Far worse, in my opinion. Yeah, and I will say, Judge Canoni has all these documents. She knows that the money was deobligated and ARCA probably only got paid $9,000 and the balance was $26,000. Then Reed's team comes in and pays that exact amount. Judge Canoni knows all this, and that's why I'm saying I don't think she cut that short because she was pleased with what Arca was saying or she was satisfied with the answers. I think she cut it short because there was nothing. That's what I'm saying. There was nothing there that Arca provided that could give Judge Canoni any cover in terms of good faith, attributing good faith to Arca to not exclude them. That's what I think went down there, folks. And I'm keeping an eye on what you're saying. You all are commenting very fast here. Let me end the last poll that I had because I asked who you all thought I should interview. But, folks, Towel friends, I know that there are some moments in the trial where Towel gets animated. This wasn't animated from a place of moral incredulity. This was animated because these kind of rulings, this type of Rule 14 situation that has to do with disclosure and witnesses who are ostensibly independent being a little bit odd, to say the least. Very rare, folks. That's what I'm saying. That's what I think. I think there's something nefarious that went on with the DOJ and Arca and Reed, but it was the old DOJ, not the new DOJ under Leah Foley. And that's what I think could make all the difference. I agree with Jew Drops. That was a very big day for Hank Brennan. I agree with B and Chance. Wolf is not independent. Now listen, Towel friends, our 9-hour adventure, we are going to be back tomorrow. It is just past 4:30 p.m. Eastern. Here's what we can do. We'll take a look to see if any of the channels do a clip of Karen leaving court. If we don't get that in the next few minutes, we'll take some of your questions, and then we'll save Towel for tomorrow, because we need to follow up. We need to see if we get rulings on this from Judge Canoni, either overnight or in the morning. We need to see how this is all going to play out. That is odd that the Arca experts weren't traveling together. I agree. I really think Judge Canoni may be at the end of her patience, even with her willingness to be overly deferential to the defense. There may have been just too many one step too far situations. I'm not sure. We may get an initial ruling forcing Arca to turn over their report sooner than May 7th, and then we could get a subsequent ruling on their admissibility or potential exclusion as witnesses. Yes, I called him Dr. Fowler as well. I apologize too, Angela. I got that wrong initially. All right, Towel friends. So what we're going to do now is we're going to see if any video of Karen leaving court comes out. So give me 1 second here. I'm going to bring that up for the Towel friends. Well, I'm not going to actually bring it up on the screen unless we get the video, but I'm going to see if any of that video came in. I'm not going to make you listen to any of that. But let's see if they give us coverage, because Karen Reed leaving court is the coverage we all want to see, ladies and gentlemen. Now, did we get any of that? Do we get Karen Reed leaving? No, I don't believe so. But hold on. I'm not to be deterred. I'm a Towel. All right, so let's see. I'm keeping an eye, by the way, Towel friends, to see if we got any information. Oh, no, we didn't actually get a clip of Karen Reed leaving court here. However, I have other plans. Oh, my goodness, it's Murder by Maestro. My Towel eyes have lit up. I'm so thrilled to see you. That's a great comment, by the way, Murder by Maestro. And by the way, Murder by Maestro, we had multiple amazing super chat drives, and we have there are so many wonderful Towel members. It has just been a wonderful day, Towel friends. And what I'm going to do for you all is we are going to try to get footage outside of court of Karen, and that will be our close of the day, as I think that's very appropriate. Now, as always, I will mention, if you've enjoyed this stream, if you've benefited from this stream, if you think this information will help other people, there's a number of ways that you can help Towel. You can do a number of things, such as like the stream, subscribe, become a member. You can leave a super chat now. You can send donations. Someone asked earlier, is there a direct way to send donations? And I actually really appreciate you asking, because any direct donations today would actually be very appreciated. So much like PBS or the BBC, every 90 minutes on this Towel stream, you get a little reminder that you can support Towel. So many of you have left kind super chats, and so many of you have rallied together to make Towel feel like a truly appreciated public information service. I posted the information in the chat. Please don't feel obligated to donate. All of your questions and comments go up on the stream. B and Chance, I agree. Alan Jackson did absolutely look intimidated. I agree. Listen, if I were Arca after going through that, I'm not even sure I would want to be crossed by Hank Brennan. That would be miserable. Now what I'm going to take a look for here, towel friends, is are we going to get anything of Karen Reed leaving court? Because I'm an effective towel. If we get that footage, I will have it for you right away, and I'm also going to continue looking at your questions. All right, so let's see. Now, I don't think we have any live feeds outside of court. If you see any live feeds from outside of court, oh, yeah, so you guys are so kind. Listen, I posted my Venmo and my Cashapp and my PayPal. You are welcome if you want to contribute directly. Those donations mean a lot to Towel. I actually only ate 2 pieces of pizza today, so I should probably go get like some grilled chicken. Murder by Maestro is encouraging me to eat things that are not just sugar in other forms, so that's good. But yes, I want to talk with you all. I see a lot of Towel friends in the comments, so while we await as Towel monitors for video of Karen Reed leaving court, let me continue to... yes, Lucy R., you can send a PayPal. I don't know if you just saw it because it flew by so quickly in the comments, but let me paste it one more time and you'll see right at the end of this section, there's paypal.me/GrantSmithEllis. And yes, that does go, that goes to Towel. So God bless you, so many of you Towel friends. And the only reason, of course, we're not sticking around gratuitously, I'm trying to see if I can get you all coverage of Karen Reed leaving court. So bear with me, and we'll see who, if anyone, can get us a live stream. Records being kept with the defense, it tends to be quite an issue. And so you really are supposed to keep your client's records for appeal for a number of reasons, and Judge Canoni pointed that out. Auto-deleting records is very weird like that with your own expert. Now, I can't actually see your comments. Let me go down a little bit. So, the I Hate Alessi fan club. Cynthia Doolittle. That was a great question, by the way, so I'm going to make you an honorary towel. We also have a wall of blue here, so if you are new to the wall of blue, welcome. Lucy, God bless you. Thank you so much for asking. Towel, as you saw, by the way, if you want a recap of today's hearing, we started the day with the explosive testimony from Ian Whiffin, Murder by Maestro. I'm so interested to hear your thoughts on the temperature data. We will do these recaps, of course, tomorrow morning when Towel sees you all next, but I'm so interested to hear your input on how Brennan bifurcated Ian Whiffin's testimony, and in that sense brought out both the 6:23 a.m. and 6:24 a.m. Google search confirmation, and John being confirmed as having not moved with his phone on the lawn from 12:32 until after 6 a.m. The whole time John was on the lawn, never went in the house. Yes, be in chance Judge Canoni could exclude one witness from Arca, keep the other. Absolutely. Eva says, I didn't care about Arca testifying before, but Hank's question should have had them dismissed. I agree, Eva. Dewdrop says, justice for John O'Keefe and his family. Lock Karen up and get the justice they deserve. God bless you, Dewdrops. You are one of the most loyal towelettes I've ever seen. And you know, Dewdrops, it was you and your fellow towelettes who I think truly were honored with a mention in the Karen Reed trial. So why don't we, as good little towels, bring up that right now? I'm going to go over here and I'm going to bring this up on my towel screen, and we are going to listen to the towelettes being mentioned during the Karen Reed trial. It is something that the towelettes deserve to have mentioned. It is praise that the towelettes have earned. It is due homage and due justice to the legacy of towels, and towelettes in particular, that they made it into the Karen Reed and John O'Keefe retrial. So let's take a look at this footage of the towels. And where is it, folks? Where is it? It is right here. I have it for you, towel friends. I have obtained the video. It is the video that all the towelettes want to see as we await to see video of Karen leaving court. It's truly the footage that brings warmth to all the towelettes and their hearts. Bifurcated is a great word. Tripartite's a great word. Towel has lots of wonderful words. Towel is just a repository of a wide and varied lexicon, which is deployed with syntactical precision as a manifestation of Vico's beautiful recursive historical motif, as embodied in Joyce's Finnegan's Wake, but more aptly described as an applied version of Hegel's syntactical dialectic, wherein Towel preaches a antithesis, a new world order, a new age of Aquarius based on universal love and compassion and preserving, demonstrating, and expanding our ability to engage in those behaviors against the thesis of the existing world order defined by self-interest and greed, which is against everything Tao believes. And thus the Hegelian synthesis will be born, and Tao will be here with his rhetorical skills applied as a conduit to explain as such. The synthesis will be born, which shall reflect Tao's vision for a more compassionate world, rooted in a new soft power dynamic, by truly allowing us to preserve, expand, and demonstrate our capacity to be kind for one another, and stitch together the fabric of the Tao universe, to include washcloths and flannels and soap dispensers and towelettes and hemp towels and paper towels and beach towels, and truly any type of towel you can possibly imagine. Truly, towel is I am the rhetorician for the modern age. I speak in towel motifs to engender the standing of human beings in the wider world, and I therefore reflect a universal sort of belief in the capacity of humans to do well, to do good by each other. But yes, let's do what I wanted to do, which is play the towelette video as we wait for Karen Reed and see if we can get video of her leaving court. Ladies, gentlemen, fellow towels, I present to you one of the most important videos, not from today in the John O'Keefe and Karen Reed retrial, but last week, an homage to the towelettes. Hold on a second, towel friends. As much as I would love to play this video, I must unmute the video for it to play. Are we ready? Here we go.
What types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab, because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and every hospital should have the same policy, where we use a swab that has no alcohol. We call them a moist towelette. That's what we refer them to.
You heard it, towel friends, you heard it here. Moist towelettes made an appearance in the Karen Reed and John O'Keefe retrial. But on a more serious note, towel friends, let us together take a look at some of the developments today. We are, of course, waiting on news to see if Karen Reed will come out of court. But as we do that, if you missed it, I have to say, all you thousands of towel friends watching on X and the hundreds of towel friends watching on Twitter and leaving comments and being so kind to Little Towel and supporting Towel's public information service, let us watch some of these scenes. I think the biggest one, perhaps the biggest scene of all, was the admission from Karen Reed's experts from Arca that they deleted messages and didn't comply with court orders. That was probably the biggest moment of the day. I could not believe it. I could not believe it, towel friends. And then also the 105 deleted messages. So let's listen, folks. Let's listen to this absurd series of events that Hank Brennan so masterfully teased out.
2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about Arca, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
So I'm seeing some really good questions, which is why I'm going to break in and annotate this. We really have to listen here about what, how much ARCA withheld to determine if Judge Cannoni even can rule that their new report can come in. Absolutely something we're going to listen to here, but that's a spot-on question, JI5. Maui Swift, it's great to see you. But yes, JI5, great to see you as well. I love seeing your name pop up, as well as so many other Towel friends. But normally the prosecution wouldn't appeal. They're not really prejudiced in the normal way that a defendant would be prejudiced. So I wouldn't see that happening. Instead, I would see Brennan might raise an objection to the ruling, but no, I doubt. If I'm Judge Cannoni, I'm very hesitant, though. In light of, if you missed it, by the way, we're doing a Karen retrial recap from day 5, the explosive 2.5-hour voir dire of witnesses from ARCA that got very heated with Hank Brennan at one point. Hank Brennan was righteous with vengeance. We are going to take a look. Hi, yes, Maui Swift, hello. If you missed it, by the way, Towel Friends is coming up on 5 p.m. We're going to do one quick recap of the explosive ARCA moments, the deleted text messages, everything Karen accused the prosecution in the case of doing, basically Reed did with ARCA, according to this testimony. And then we'll take a look at the moment where one of the ARCA witnesses admitted it was the DOJ themselves who allowed Reed to violate, allowed Reed's witnesses during the first trial to violate Judge Cannoni's sequester order. Big news, friends. Big news. Let's listen.
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
Yeah, and let me pause and say one more thing. To the folks who are saying, all right, is it possible that the old DOJ in Boston had a motive and an opportunity to weaponize the probe of John O'Keefe's death to get at the Norfolk DA? The answer is yes. Rachel Rollins had an existing beef with the Norfolk DA, Michael Morrissey. You all can look this up. There are 2 separate reasons they had tensions. One, Morrissey was one of the DAs who wrote a letter or formally intervened in a case where Rollins was trying to avoid seeking a life term for a youthful offender between the age of 18 to 25 in a homicide case. The other DAs were pissed. Rollins retaliated in the media with comments. The other situation was Rollins was a soft-on-crime prosecutor who wouldn't prosecute a whole list of low-level offenses. It's what brought her to national infamy, quote unquote. Now, what's really interesting about that is that Morrissey also became enemies with Rollins over that. Now, there was another person in the DOJ by the name of Dustin Chow, a line prosecutor in what's called the Public Integrity Unit. Well, guess what? Dustin Chow's wife got passed over for a promotion in the Norfolk DA's unit in 2015. And Chow went around saying he was going to do whatever it took at the time to burn down the reputation of the Norfolk DA. 7 years later, November of 2022, Karen Reed and David Yannetti, by the way, who was on the transition team for Rachel Rollins when she became Norfolk DA, walk into Josh Levy's office and the pretextual probe opens. Okay, folks, I just want folks to understand the politics and the machinations of this all. And just so folks know, to add another layer of this, why did U.S. Attorney Rachel Rollins, Josh Levy's boss, the woman who was in charge of the U.S. Attorney's office, get appointed to her position? Well, have you ever looked into the 2020 Senate primary between Joe Kennedy Jr. and Ed Markey in Massachusetts? Have you ever wondered if maybe the Biden White House appreciated Rachel Rollins working with, here's a name you'll know, Aidan Turtleboy Kearney to send a Republican operative and a spoiler candidate named Rayla Campbell to Joe Kennedy Jr. events in that Senate primary? And why would Rachel Rollins, a liberal, work with Turtleboy, ostensibly a Republican, and Rayla Campbell, a declared Republican, to sabotage Joe Kennedy's bid for Senate against Ed Markey, a Democratic primary? Well, I wonder if the Biden White House saw Joe Kennedy Jr., a rising Democratic politician who would have been going into JFK's old Senate seat, on a trajectory to challenge Biden in the 2024 White House primary, which probably would have worked out for the Democrats better than that Harris-Biden catastrophe. But listen, Towel friends, what if Rachel Rollins got appointed to the position of U.S. Attorney in Boston, a position we'll quickly come to find out based on what I tell you next she never should have been appointed to? What if she only got appointed to that position because of how she helped the Biden White House by using Turtleboy and Rayla Campbell to sabotage Joe Kennedy Jr.'s race for Senate in the primary against Ed Markey in 2020? And what, Towel friends, if Rachel Rollins got removed and forced out of the position of U.S. Attorney in May of 2023 by the U.S. DOJ OIG, the Office of the Inspector General, in a report you can read that found that Rollins launched a pretextual federal probe into the Suffolk DA, Kevin Hayden? Why? Because Hayden beat Rollins' ally Ricardo Arroyo in the primary for Suffolk DA, Rollins' old seat that she left when she became U.S. Attorney. So line it up, folks. Rollins got the motive against Morrissey. Chow's got the motive against Morrissey. Rollins got the history of using pretextual federal probes. Everything's lining up. The DOJ gave cover to Arca to violate the sequester order, keep secret these payments and contacts. It's all lining up. It's a modern Black Mass, folks, with Karen Reed reprising the role of Whitey Bulger, and Rollins and Dustin Chow and Josh Levy apparently reprising the role of John Conley, allowing Reed and Turtleboy to maraud through this state trial related to John O'Keefe's death simply because of a tension with Michael Morrissey. Is it making sense, Towel friends? Arca was just the pawn. Arca was the tool to take out the DOJ's revenge, to use the pretextual probe into John O'Keefe's death. Yes, it may have uncovered Sandra Birchmore's murder cover-up by the same MSP unit who investigated Karen, but it was always about getting Michael Morrissey, smearing him, making him look bad. That's what it was all about. Arca played their role. Karen played her role. Jackson played his. Yannetti played his. And when the new DOJ came in, friends, under President Trump in January of 2020, ladies and gentlemen, stuff hit the fan, because new U.S. Attorney Leah Foley must have came in and realized this was happening and said, I'm not going to enable Josh Levy and Rachel Rollins and all that nonsense. No, I'll disclose what was going on. And that, ladies and gentlemen, is what brought us to where we are today. It was political conflagrations of the highest order, overlapping concentric socio-political circles that engage in such a way as to disgrace our representative form of government. Yes, ladies and gentlemen, the Karen Reed case was a honeypot. It was never a real federal investigation. It was always political. It's always been political, and even though that probe is closed, make no mistake that even its closure was the result of a new political administration coming in and finally cleaning house. Ladies and gentlemen, my name's GrantSmithEllis. I'm a towel. I think I have explicated in perfect form the nature of how the DOJ came to enable Karen Reed's nonsensical public relations campaign out of self-interest or otherwise. I think I've laid it out for you. Thank you to whoever asked that question. Sorry for getting a little impassioned. People were asking me earlier if I would perhaps not yell, but it is very impassionate. Let's continue with the Arca review while Towel looks for footage of Karen leaving court.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Yeah. So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling, no, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
Objection, Your Honor. So next question, no comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the number?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you were?
I just said I delete texts routinely. You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial.
Child.
Means like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your careers when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson.
Don't know. How many times did you use Signal with the defense to talk about this case?
Objection, Your Honor. Going to allow it.
From what I recall, was probably a handful of times.
When you say...
Notice he has a lot of trouble remembering that, but he had a very easy time remembering details when Alessi started asking him questions. By the way, I noticed that your comments are not showing up. They're not reloading in real time. Don't worry, Little Towel is on it. Doing my best to get that to reload for you, Little Towel friends. Towel promises. But yes, Towel friends, so much going on right now. I'm waiting to see if we can get coverage from outside the Karen Reed trial to see footage of Karen Reed leaving. I'm watching right now the 5 o'clock news, and if it does indeed come on, Karen Reed leaving the trial, I will show you the footage, and that is how we'll wrap up our day. But you heard that, folks. You heard what just went down with the deleted ARCCA, and also your comments are going to pop back up on the screen here any second now. I apologize for that delay. I had to refresh the feed that was actually showing your comments on the Towel stream. But, you know what we are also looking for? I'm watching the news. All we're really waiting for is to see the footage of Karen Reed leaving court. We know that they're probably going to go to Karen Reed coverage almost right away. So being the honorable Towel that I am monitoring for you. And that is hopefully how we're going to close our coverage today. Now, we don't actually have the Karen Reed leaving court footage yet, but I'm right here. All right, I'm watching. I'm monitoring. I'm being a Towel, and also I have your chat back on the screen. Now, the news is on an incident in Seekonk right now, so that is why we're not looking at it yet. But don't worry, your chat has returned. Look at that, Towel friends. You have returned to your rightful place of glory. Hold on, at least you did a second ago, but now I had to readjust it to live chat. You have returned to your rightful place of glory, Towel friends. You are now right on the top of the Towel chat, and all I am waiting for is to see if we get footage of Karen Reed leaving court. Now, right now, I'm looking at a story about Seekonk, but I already know that the Karen Reed story has to be coming up. Who wouldn't lead with the Karen Reed story? That is one of the most important stories of the day. But as we're waiting, obviously, you got a chance to see what happened with Arca. Tomorrow morning, friends, we're going to start again early. We'll review the Arca testimony, the Ian Whiffin testimony in depth. I know Murder by Maestro is going to be very excited for that. The juror who was questioned at Sidebar was allowed to continue on the trial and was not removed from the reporting I saw. So that's the update there. And in terms of other questions, hold on, I'm keeping an eye. I actually have to do this to keep an eye, which is going to throw off the Towel comments. Hold on. We are keeping an eye, Towel friends. We are waiting to see if we get footage of Karen Reed leaving court. But what was the question that was asked? There was a question that had come up. I apologize. I missed it, Towel friends. But that's okay. That's okay. I will keep an eye on the other comments. It's been over 9 hours. You got to give Towel a little grace. Dewdrop says breaking news. If there is breaking news, let Towel know. I would say this is very bad for Arca, though, obviously. Let's see. Arca may have been communicating with Karen through Cat, says Barb. I think that's possible. And towel friends, if you're wondering what we're waiting for, we are keeping an eye on this footage of Karen and seeing if we get a report. And if not, we will move on with our day. Karen obviously lost at the Supreme Court today. Everyone saw that coming, especially if you were a towel friend. And then Karen just got humiliated throughout the day by Ian Whiffin and otherwise. All right, towel friends, is this going to be the Karen Reed coverage? Hold on, bear with towel. Nope, this seems to be a press conference. They're taking the press conference in... Oh, sadly, a very sad accident has happened in Hyde Park, so that they're taking that first. Stand by, though, towel friends. Stand by. We are waiting to see if we have footage coming over the wires of Karen Reed coming out of court and what, if anything, was said while Karen came out of court and embarrassing it was for Karen Reed. Now, in context of that, I was monitoring the news, and the news, unfortunately, is not covering Karen Reed because a very serious situation happened in Hyde Park where a child was struck by a car, unfortunately. But needless to say, as towel friends, we have the ability to patrol other mediums to see if there's footage of Karen Reed coming out of court, and that's exactly what we're going to do. Because I'm a towel, and you're all towels, and as little towels, we monitor, we patrol, we act like little towels. So let's do one thing. Let's take a look. Has anyone gotten us footage of Karen Reed leaving court? What do we got? What do we got? I'm not seeing anything so far. Hold on. I'm looking very, very, very clearly. Very, very, very clearly. Let's see. Any footage of Karen coming out of court? Come on. I know some of your reporters are down there. Nothing yet, towel friends. Nothing yet. Don't worry, though. I have a backup plan. My other backup plan is to continue monitoring this news channel and see if they decide to break in. Personally, I think they should. I think they should break into coverage of the Karen Reed trial, but we are waiting. The Suffolk DA is giving a press conference about that sad situation, as I mentioned, that went down in Hyde Park. Now, let's see. We have nothing from any of the reporters yet. That doesn't mean a reporter isn't going to get a clip for us up, but it does mean that there is not one up yet. Little Towel is patrolling. Little Towel is on the roll. I am looking very, very close, Towel friends. Nope, no videos yet. The video we all want, ladies and gentlemen, the video of Karen Reed leaving court. Is it being prepared right now? Are all the networks trying to clip it together? If you have video of Karen Reed leaving court, please feel free to drop it in the comments, and then we can all watch it together. If I missed it, please drop it in the comments again, and I will do my best. No, it's not so much that Karen escaped the media. It's just that most of the media does the coverage as an actual package on the news. So they wait, they'll roll it at a certain time. Normally we would get it as the top story on the news, but the reason why we're not seeing it right now as a top story on the news, I think, is because there was an incident in Hyde Park. So as Towel continues to monitor, it looks like the mayor is actually speaking along with the Suffolk DA. That's why a lot of the networks, I think, are waiting. But Towel is monitoring. If we get Karen Reed leaving court, which we sometimes get footage of, then I will share it. There are various people who sometimes are kind enough to get us that footage, but it is actually difficult. It requires substantial amount of network bandwidth, and that's why it mostly tends to be the networks who put together a package rather than just pumping it out on social media. But as I said, if you have the footage, that's really all I'm waiting for, and then we'll be done for the day. But I don't think anyone just has the footage. I think we're going to wait, and Karen will no doubt have said something ridiculous, and then we will watch it together. All right, Towel friends. I appreciate, by the way, everyone who has been liking the stream, subscribing to Towel channel. We have so many new Towel friends, Towel members. We're using Towel emojis. Someone reached out to Towel. Towel is just a wonderful, wonderful human. And Towel's doing his best to continue providing you all real-time updates as we wait to see if Karen Reed will walk out of court. The mayor is still talking in the press conference. Towel is monitoring. That is a very unfortunate situation for in Boston, and my prayers are with the people who were affected. As Towel mentioned, I am keeping an eye here. I am keeping a very close eye, in fact, to see if we can get all I really want, which is the footage of Karen Reed leaving court. And then, as I mentioned, Towel Friends will be back early tomorrow to do our Arca analysis as well as our Ian Whiffin analysis, both of which went very bad for Karen Reed's defense. All right. Nothing yet. Looks like there might not have even been very much. Looks like there might not have even been very much activity because nobody posted anything right away. All right, bear with Little Towel. Oh no, I'm sorry to report that the child who was struck in Hyde Park has passed away. This is incredibly sad. That's why there is this. Oh, there's lots of police officers. This is just so sad. Oh, they were hit by a school bus. Oh no. Oh goodness, Towel Friends. My goodness, I am so sad to report that. I'm heartbroken. I unfortunately don't have all the specific details of that incident, but as I'm monitoring the news for you, Towel Friends, that is the update that I have. Trevor McIntyre says, Grant, did you notice Caleb Schillinger was seated at council table with Brennan and Lally at the end of the day? I did not, but that's interesting. Caleb Schillinger. Caleb Schillinger is a beastly human being. He's part of what I would call the nerd squad in a loving way. Very intelligent, one of the great Harvard-educated appellate lawyer. Not someone I would want to mess with, and that is certainly an intense moment. Yes, obviously, those of you sending prayers to this in regards to the situation in Hyde Park, that it is truly devastating. I'm not taking the press conference feed because it is just heartbreaking news. But at the same time, I am keeping an eye to see if we will get footage of Karen Reed leaving court. Now, we're not going to watch any more of the footage with Arca, although we can watch actually one of the clips of, let's see, did I end the day with the Dr. Rentschler clip, or the second expert? That expert went even worse for Reed's defense. But yes, Hank Brennan's second, I think his redirect was even worse. We had watched a little bit of it earlier as to the Arca witnesses. It was terrible for them. Hank Brennan was just shining himself. All right, folks, they're now taking questions at that press conference, so I'm just waiting to see if the Karen Reed coverage is going to roll, and then that might be the end. I missed so many of your comments, though. Hold on, I apologize. It is very sad news. I appreciate all of you who are extending their prayers. And I am monitoring for you, obviously, and as soon as any of the Karen Reed coverage rolls, I'm just going to put it right up on the screen, and that will be the close of our day's coverage. And just, it is so sad. And Towel Friends, obviously, tomorrow, just as a preview, we will be talking about, very much so, we will, oh, did I hope, no, why is that video of Adam Lally on the screen? Oh, it must just be something I was playing earlier. Yeah, that's exactly true. We will absolutely go over the footage of Ian Whiffin testifying, which was very bad for the Karen Reed defense. And let's take a look, actually, at these were some of the moments of Ian Whiffin presenting his testimony. And perhaps one of the most explosive implications of that was that John O'Keefe's phone did not move. All right, Towel Friends, I'm going to see if they're going to take the Karen Reed coverage. Stay with me.
The U.S. Supreme Court will not take up Reed's appeal. WBZ's Christina Rex is in the courtroom this week for testimony. Christina, if the Supreme Court isn't taking up this case, what does that mean for the trial as it stands right now?
Well, Lisa, what it means is that Karen Reed has exhausted all of her appeals from that first trial. So this second trial going on right now will determine Reed's legal fate. That as it was a late day today in court with some really tense moments.
So when did you become an advocate for the defense?
One of several heated exchanges Monday afternoon. The jury was not present as prosecutor Hank Brennan grilled two crash reconstruction experts about their relationship with defense attorneys during Reed's first trial.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
These witnesses who work for Arca were hired by the Department of Justice as part of a federal investigation into this case. They testified in trial 1 that John O'Keefe was not hit by a car. Prosecutors want them prohibited from testifying in trial 2 because of an alleged questionable relationship with the defense, including using the encrypted app Signal to text.
I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
Ask the defense, and these experts were retained only after Reed's first trial, and they were done with their federal work.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
All morning, the jury heard testimony in the case from a forensic cell phone expert. First, did witness Jennifer McCabe Google how long to die in cold in the middle of the night before discovering John O'Keefe's body? Or did she Google it at Karen Reed's request after his body was found that snowy morning?
The only time it shows how long to die in the KICD is at 6:23:51. There's no other mentions of either of these searches anywhere else in this file.
And Ian Whiffin showed his analysis of whether John O'Keefe ever went inside the house party that night, based on his phone's location and activity.
Based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
And that witness will be back on the stand for cross-examination first thing tomorrow morning. Now, coming up on WBZ News at 6, the brand new evidence that prosecutors showed today that they say proves that John O'Keefe never went inside that house. Live in Dedham, Christina Rex, WBZ News.
Wow, no footage at all, towel friends. No footage at all of Karen coming out of court. Wow, towel friends, that is very out of the norm. And Lucy, by the way, I want to say God bless you for sending that super chat. Towel appreciates it so much. I replied to your comment, and I'm so grateful you put so much effort into figuring that out. Folks, we have to watch that now. Now that we have been told by Christina Rex that this was the biggest moment of the day, Towel views Christina Rex as a venerated reporter. Towel is providing commentary, obviously, on these various developments. Let's look at what Ian Whiffin presented. We are going to watch it, Towel friends. We'll go over 9 hours. I'm actually going to turn my camera off to go get some water, but we are going to watch what Christina Rex just hinted at was the biggest news of the day. Towel friends, comment away.
Apparently not like that. There we go.
Thank you.
So on the evening of the 28th, see an average temperature of around mid-80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after midnight, we now know the device is already at Fairview. It's been at Fairview for approximately 12 minutes, and the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffin, if I can interrupt you. At 12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. At 1:36, it's dropped to 50, and then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m. when the temperature is 43 Fahrenheit.
Mr. Whiffin, if a phone has any protection or coverage, well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know. Accurately, no.
Okay. And then you're now at 6:14 and it's 37 degrees?
Yeah, you're correct. This is the coldest temperature recorded.
Do you know what, if anything, happened to that phone at 6:15:01?
I don't know.
Okay, please continue.
And then as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we can see on the evening of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase. But there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or had extensive usage.
Between 1:36 a.m. and 6:06 a.m., is there any indication at any time that that battery temperature went up?
No, there's no records related to battery temperature at all for that time.
Thank you. Is there another area that you looked at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, a database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The current power log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And unified logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur. So really granular. We see that at 12 minutes and 52 seconds after midnight, the device is unlocked using biometric Face ID. The SMS application is on screen for about 5 seconds before it's closed, and then the user presses the lock button at the side of the device to lock the phone. At 13 minutes and 54 seconds, biometric Face ID is used again, and the SMS application is opened, and at 14 minutes and 29 seconds, the lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID. The SMS application is already on screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. and at 19:23 that phone call ends. At 19:29, the Waze application is opened by the user pressing on the icon on the home screen, and that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds. 2 seconds later, at 24 minutes and 28 seconds, the device is locked by the user pressing the lock button on the side of the phone. At 24 minutes and 59 seconds, the device is unlocked using Face ID. The SMS application is opened using the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The application is already on screen. And at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage. And at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use. And at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device.
All right, hold on. We have a question. First of all, I'm not a lawyer. Nothing on the stream is legal advice. And you should get a lawyer if you have questions about the law. Towels are for proving unconditional love exists in a hostile world. And for feeding Towel. Towel has eaten 150 calories, maybe 300 calories today. I feel like I am going to absolutely collapse. Towel needs to be fed. I'm probably going to have to go eat after this, as much as I resent food. We had some questions, though, because the reason we're watching this clip is Christina Rex mentioned at the top of the hour the news channels are going to do their review of the bombshell evidence that shows from the prosecution that John O'Keefe never moved from the lawn of Fairview Road. Now, you might be wondering about all this technical, intricate data. Well, did you know, Towel friends, we have someone who basically speaks in binary with us. His name is Murder by Maestro, and he is the smartest 24-year-old computer in human form that I've ever seen. Now, Murder by Maestro is, of course, also an anthropomorphic towel, but Murder by Maestro definitely is smart enough to help us explain all of this. In fact, when this was playing earlier, I was yelling out to the towel friends, we need Murder by Maestro. Murder by Maestro will be our salvation from this complex technical data. Because as much as I'd love to explain to you the legal implications from my lay towel perspective of this, the implications here go to proving John never left the lawn. That is the extent of the legal implications, because it shows Karen made contact with John, he never left the lawn, and the phone didn't move from that lawn until after 6 a.m., from 12:32 a.m. till 6 a.m., and the phone temperature went down and confirmed that. But really, this is a technical analysis, and what you're seeing here, folks, is Hank Brennan laying the foundation for what he's going to ask further experts about later. His accident reconstruction experts. You're seeing the data showing from a very hyper-technical perspective. Remember, Ian Whiffin is a cellular data technology expert who pushes code and commits to the Cellbrite program, which is the foremost forensic analytic tool for cell phone data in the world. It is actually a compilation. It's a tool set. It's a program that interfaces with a bunch of different tools in order to provide analysis of cell phone data. This is Hank Brennan laying the foundation for all of the precise technical data showing the movements of John's phone, showing John and Karen were driving over from the waterfall, and that John's Apple Health data, while the car ride was still ongoing before 12:24 a.m. when they arrived in front of the house, showed John going up and down 3 flights of stairs, but it was errant data because it was just the car probably going up and down a hill. But more importantly, this is the data that shows Karen and John arriving in front of Fairview Road at 12:24, staying in front of Fairview Road, although Karen moves the car forward to the dark side of the house over by like a fire hydrant and a flagpole at around 31 or 32. Karen then moves forward without John in the car, and then John's step tracker showed John never goes more than a certain amount of distance and never leaves the lawn from his final place of rest. It's called the pedestrian's final place of rest. And then you're going to see tech data from Karen's car that doesn't come up quite yet, showing Karen at 75% acceleration reversed that car with a BAC between 0.13 and 0.29, 2 to 4 times the legal limit, up to 24.2 miles an hour. And at the moment of impact with John's body, allegedly, that car reduced to 23.7 miles an hour, and the wheel corrected 4.7 degrees to the right. Ladies and gentlemen, this is the underlying technical data that proves everything about the state's case. It's bombshell, it's explosive, and we have the wonderful Murder by Maestro here with us and all the other Towel friends to help you understand this technical data as we go through it. And I'm a Towel. Thanks for being with me. Let's keep watching.
It's the final unlock of the device using Face ID, and it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night?
Correct, up until 6:15 a.m.
In 12:32:09 was the last time before the phone moved again the next morning?
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. This was the pocket state that I think I mentioned earlier, and it detects when the user takes the phone out of a pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records and to filter and aggregate down into a more digestible number, which is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera's blocked, it records the fact that it's in a pocket state. And it will continue to record pocket state until either the obstruction's removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends. So in this case, at 12 minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds with a pocket state cleared event. At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds. At 25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state. And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97 Doppler checks. The 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted. Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time. At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 second where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffin, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including Waze data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them to the jury in chronological order?
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use. For around 11 seconds, a phone call is made from John to Jennifer McCabe. Phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device. 31 minutes and 47 seconds after midnight, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "Pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered. and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in a pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler's pocket state being detected by Doppler. And I've also showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere, kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, "See you later." Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, "Your kids are cooking alone."
Mr. Whiffin, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that wave was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16, that the last interaction was at 12:32:09, followed by an overnight pocket state, and an increased reduction.
Objection, Your Honor.
So I need to hear the question first.
Including a increased reduction in the battery temperature. Do you have an opinion, to a reasonable degree of scientific certainty, that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
Absolutely, I'm pushing the towel computer to its very limit, towel friends, but we're back. Hello, I did not lose our place. We're going to keep up on watching the Ian Whiffin analysis. Then we're going to close out for the day. But that was absolutely Towel's computer, I think, saying to him that 2 crashes in one day means I need to think about my setup. Towel's working hard for you, though, Towel friends. Have no doubt about it. No doubt about it. I am working hard to get this information out. Let's continue.
The Doppler state clears because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed. and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in a pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler's pocket state being detected by Doppler. And I've also showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, "See you later." Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, "Your kids are cooking alone."
Mr. Whiffin, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that wave was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16, that the last interaction was at 12:32:09, followed by an overnight pocket state, and an increased reduction.
Objection, Your Honor.
So I need to hear the question first.
Including a increased reduction in the battery temperature. Do you have an opinion, to a reasonable degree of scientific certainty, that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
The location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing that the camera was unblocked during that time, which would typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the flagpole area from around 12, 24, 33, until the next morning at 6 a.m. or after?
That's my objection.
That was the bombshell, and we came back and got the testimony. Towel friends, that we did our Ian Whiffin review. So many of you have stayed. I know it has been a long day. I just want to say God bless you to all the towel friends. We broke another towel stream record, even with 2 buffering hiccups for 60 seconds each time. I want to say Murder by Maestro, those towel emojis I left, that's the smile on my face when I get a compliment from a towel friend, be it Murder by Maestro or any of the towel friends. You all really warm Towel's heart. I really am going to go eat now. Truly, we've broken another towel stream record. You know what that means. I need to say to you all, please, and if you appreciate this stream, go out and do small acts of kindness for the people around you. Go out and show people that love is possible, that compassion is possible. We've, in my opinion, slowly changed the ethos surrounding this trial in a positive way. No matter what you believe, a lot of people here, rightfully in my opinion, believe Karen is guilty for killing John O'Keefe. But needless to say, the ethos is changing, folks, and it's because of the compassion of you towel friends. The brave little towel. Yes, maybe one day we will have a wonderful mock cartoon that Towel makes, and we will call it the brave little towel. Truly, towel friends, I just want to express my appreciation again to all of you. You have shown Towel that it's not just Towel that believes a better world is possible, but there are other people. There's a whole fabric, a Towel universe who believes a better world is possible. You even stay around during unintended 60-second breaks. There really aren't too many breaks for Towel during these long streams, but God bless. My name is GrantSmithEllis. I'll be back with you bright and early tomorrow, 7:30 or so in the morning, friends. We'll do it all again. Will there be a ruling on Arca? We don't know. What testimony's coming next? More Ian Whiffin, we know that. Murder by Maestro, truly, God bless you. Justice for John O'Keefe and his family. That is something that all of us can share. My name is GrantSmithEllis. Some 10 hours and 20 minutes later, I close with these words. Towel loves you all. I hope you all will go out and reflect that in your actions today. Do enjoy the rest of your Monday afternoon. Be well, friends. Until we see each other in the morning, please, please go with God and be well. My name is GrantSmithEllis. Until next time.